I
Do this, disconnect.
This is the only way to describe it.
Okay, good morning. Going to call the hearing to order this morning. We have a pretty packed agenda. We have 45 people sign up to speak, so we're going to try to move along. I'll just say I would encourage everyone who wants to testify together. We would encourage that. If you're from the same organization, certainly. We would encourage testifying together in an effort to move the list along today. But we do appreciate everyone's participation and look forward to hearing from you today. I want to briefly acknowledge my co-chair, Senator Miller, who's joining us online today. Good morning, Senator Miller.
Good morning, Mr. Chair. And like the other day, our last meeting, a public hearing, I should say, I'm sorry I couldn't join you all today. I'm excited to hear the different views and thoughts on the very controversial items that we have, bills that we have today. So I want to thank everyone for joining us, and especially those of you who decided to come to the People's Building to testify. So thank you all. Thank you, Mr. Chair.
Thank you. And Senator Miller, for your benefit, I'll let you know that in front of me is a sea of red, AARP.
I should have worn my red today.
A beautiful thing to behold. Representative Delnicki, would you like to say hello?
Thank you, Mr. Chair. And I am wearing red today. So yeah, a little bit of red on that tie, but It just doesn't meet the same standard that I see with the sea of red out there. We've got a tremendous agenda here, a large number of folks, and I have a feeling that we're going to have a great time hearing what you have to say and what is important. So thank you, Mr. Chair, for the opportunity to say good morning to everybody here.
Thank you. And I will acknowledge our ranking Senate member, Senator Berthel, is joining us online. He told me he is not going to be able to join us right away, but he is joining online today. So with that, we will jump into it. And I'd like to call our first speaker today, who is Representative Jonathan Jacobson, who is also joining us online today. There he is. Representative Jacobson, good morning. Thanks for joining.
Good morning, Mr. Chairman. Thank you very much. Sir, may I proceed with my testimony?
Sure, go right ahead. And
Thank-
I having a little trouble hearing you. It's a little.
Is this better? Is this better, sir?
Yeah, I think that's good. Thank you.
Wonderful. I appreciate it. Thank you. Thank you again, Mr. Chairman. Good morning, Mr. Chair, chairs, ranking members, honorable members of the Banking Committee. My name is Jonathan Jacobson, Connecticut State Representative, 148th State House District, comprising portions of Stamford. I've come before you this morning to speak in opposition of Senate Bill number 1093, a bill which would authorize merchant cash advancement agreements to avail themselves of ex parte prejudgment remedies of attachments for contracts for $100,000 or more. As this committee is aware, the statute upon which this proposed amendment is seeking to amend, General Statutes 36A-868, in essence imposes a blanket ban on ex parte commercial PJR attachments for commercial-based financing for an amount less than $250,000. My reading of this bill is such that it would create an exception for a particular industry, the merchant cash advancement industry, which is, in my view, my experience, is an emerging practice in Connecticut. Now, when I'm not a member of the General Assembly, I am a solo practitioner of my law firm, specializing in focusing, I should say, in commercial litigation. The merchant cash advance business in the last several years has really exploded on the scene in Connecticut, or has otherwise incorporated language relating to prejudgment remedies attachment, as well as commercial waivers thereof. In my practice, and I am involved in cases which are having issues with the attachment procedure. In my view, in my experience, there are problems generally with our state's ex parte commercial waiver PJR practices that needs to be revised. Separately, I believe that the merchant cash advance industry requires scrutiny from our assembly. For lack of a better term, it is an unregulated industry, while there are some legitimate and maybe even mostly legitimate financiers, there are unfortunately instances where these lenders engage in predatory lending practices. In my case, the return on the investment, if the cash advancement were to be calculated out, it would be something like a 230% interest rate. And while there's a dearth of Connecticut case law authority on the subject, the New York district courts have recently left an abundance of multiple decisions demonstrating the predatory practices that some of these lenders have engaged in. So again, I want to stress that this can be, and New York law does recognize that it is a legitimate practice. It is, however, unfortunately been subjected to abuse, which I believe warrants greater scrutiny from our assembly. So in the current context where we have issues, in my view, with the MCA industry generally, and where we have issues with due process of rights concerns with ex parte attachments generally, I do not believe it's appropriate at this juncture to create a carve-out exception to the MCA industry to avail themselves of the ex parte attachment for $100,000 or more, but leaving any other proposed creditor for any other industry to $250,000. I therefore would respectfully urge my colleagues on this committee to vote against this bill to allow the Assembly to have a greater opportunity to look under the proverbial hood of MCA industry generally and to potentially make revisions to our ex parte PJR statutes. But I think it's premature to allow this industry to avail itself of these procedures as sought in the bill before you today. So thank you very much for giving me the opportunity to speak. I'm happy to answer any questions any member may have.
Thank you, Representative. Thank you for your testimony. I do have a question, and I think since we have you here, based on your legal practice and experience, I think it'd be helpful for the committee if you could describe the procedure we're talking about here. I mean, we have dealt with this product, and of course, on this committee, we generally deal with the question of the regulation of financial products. But I think where you could be helpful maybe is to talk a little bit about the procedure, what a PJR actually is,
Sure.
and how it works in practice with respect to this type of product and the contracts associated with it. And I think you alluded to, if you could describe a little more, some of the abuses perhaps in this procedure that you've seen and observed.
Sure, happy to, sir. So Connecticut is one of only a handful of states in the union, at least that I'm aware of, that has this unique mechanism called a prejudgment remedy, a PJR for short. And a prejudgment remedy can have multiple different remedies, so to speak. As it relates to the analysis at hand, and the one that's perhaps most commonly utilized is a prejudgment remedy of an attachment. It is a conditional attachment of assets typically undertaken prior to the commencement of litigation or during litigation before a final judgment. So what does that all mean? Assume I have a client that intends to commence litigation against a wrongdoer, whether it's for tort, whether it's for lending purposes, what have you. Prior to commencing a lawsuit where summons and complaint is served, a litigant in Connecticut can go to court with an application for a prejudgment remedy of an attachment. And the attachment essentially goes to the court and says, Your Honor, I am going to sue this person or entity. And I believe that there's probable cause to support my claim that I'm going to win. And since that probable cause exists, I should be given a provisional attachment to sufficiently collateralize their assets so that if I'm successful at trial, I can have a source to draw down on. If the litigant is successful, if it's able to demonstrate to the court by what is in essence the lowest standard of proof there is in law, by probable cause that they're going to win, an attachment would issue. And that attachment would basically become an inchoate lien, which could be assets can be seized, funds can be sequestered, liens can be placed on real property. And upon a judgment entering in favor of the litigant, that inchoate lien would perfect and relate back to the time the PJR was granted, so that rather than having to chase down the judgment debtor for funds, under those circumstances, the assets would have already been collateralized by virtue of that pre-judgment remedy of attachment. Now, when I first learned of this mechanism as a young starting out lawyer, I was surprised that about the due process implications that's associated with somebody being able to have assets frozen or a lien placed in their house by a mere probable cause showing while they litigate their case. But that's not what we're talking about today. What we're talking about is a step further. We're talking about ex parte, an attachment without court order, and specifically as it relates to a commercial waiver. Now, there are some times where an attachment can be obtained without a court order for other reasons. But as it relates to the unique and specific analysis at hand, we're talking about when in a commercial transaction, the right to notice and hearing for a PJR is waived, which is permitted by Connecticut law. And as at present, it requires, it says that it can only relate to commercial financing agreements from today forward for contracts that are in excess of $250,000. So if I were to borrow, let's say, money in some sort of financing agreement for $300,000, as part of my financing agreement, I may very well sign off and waive my right to a notice and hearing for a PJR. What does that mean? That means that the lender does not have to go to court with an application. Instead, the lender's attorney would prepare the paperwork for a lawsuit, summons and the complaint, and include with that paperwork allegations that there was a commercial waiver in the underlying loan documents, an affidavit setting forth facts demonstrating that an attachment is necessary, and then rather go to court first. What happens is that these lenders are then authorized to serve the defendant, and in most cases, what happens is the financial institutions upon which these lenders bank, freezing assets. And what is supposed to happen is that the lawsuit gets returned to court, and the balancing act as to the extraordinary due process implication with an ex parte attachment is that the respondent, the borrower, is entitled to an expedited hearing. When a motion to discharge or reduce the amount of the ex parte attachment obtained is filed, by statute, a hearing thereon has to be held no later than 7 business days thereafter. So I have issues with, if I had issues with the due process implication of PJR, I certainly have them as even more so as it relates to the ex parte nature of it, which I think warrants scrutiny from our assembly in and of itself. So to move on to the next question that you asked me, Mr. Chairman, about potential abuses that I've seen. As I mentioned, there is a dearth of Connecticut case law authority. My read of the tea leaves is that these lenders have caught wind of our PJR statutes, and what they've done is they have made choice of law provisions in Connecticut, or have opened up corporations, legitimate or illegitimate, in Connecticut for the sole and exclusive purposes of availing themselves of these statutes. And they have been utilizing the commercial PJR waiver as a form of aggressive recovery tactics. And there's a line between aggressive and predatory. And there are district court, New York district court cases that have found that there were abuses that rose to the level of not just impropriety, but federal 1983 and RICO claims for extortion, whereby these lenders would freeze assets and refuse to return the action to court. And in essence say, you want your assets frozen, you want to make your payroll payments, you want to be able to pay and afford your credit cards, pay me. And my understanding, what's been happening then is that when the action does get returned to court, they are accompanied with a stipulated judgment where the lender has rolled over. And a lot of the times here, these MCA borrowers are not commercially sophisticated actors who may not have even known that these commercial waivers were baked into the adhesion contracts that they entered into. So again, I recognize that there are legitimate businesses and that the MCA field, it can have a benefit to society and to Connecticut borrowers, but there are issues. It is the Wild West of the MCA business right now because there are no limitations. And like I mentioned, sir, in my case, my client without going into too much details of the specifics thereof, had something like, well, I believe her underlying contract was she received $275,000 to be repaid above of $412,000 off of out of a 5-month period of time, $20,000 per week, which again, if those terms were converted into a traditional loan, would result into something like a 230% interest rate. That is something that I could argue, while maybe not usury per se, because it's not a loan per se, it is unconscionable and arguably is against public policy. And I will add that some of these New York cases have found that these MCA agreements are in fact disguised loans subject to usury laws. They are predatory in nature. And I have seen at least one case where the corporate veil of a commercial lender was pierced when the New York judge found that the lender created a shell company to incorporate in Connecticut for no reason other than to avail itself of our PJR statutes. So, in light of the concerns that I have with the due process of the PJR commercial waivers, in light of the at present unregulated nature of the MCA industry as a whole, respectfully, I think that this proposed bill is premature and would not support its adoption.
Appreciate that. And again, we're here just on the PGR issue today. We had a pretty robust discussion about the regulation and the product itself a couple of years ago in this committee. Today, we're just talking about the PGR. And, you know, there was a piece in there, your answer, that I think is important. I mean, we did indeed include this provision back a couple of years ago because we were aware that there's sort of a cottage industry here in Connecticut using our PGR process. And we wanted to tamp down on that. So your testimony about, the returning the execution to court, and actually filing the action and the delays in there, both in Connecticut and in other states is important, I think, to show, why this provision is here. I'm going to go to Senator Miller online for a question.
Thank you, Mr. Chair, and thank you, Representative Jacobson, for testifying on this bill today. So some of us are not attorneys, and I was wondering if you could define ex parte for us.
Without court order, typically you can't attach an asset. If we were to go with a standard PJR, you have a hearing, but ultimately the financial institution, if you were going to seize assets, would say you need to give me a court order. Ex parte means no court order. You go absent the blessing of judicial authority. You go in with color of law, but you don't need a court order. So when I say ex parte, it means that the lender's attorney can just go in and say, hey, this is the borrower banks at your institution. The borrower waived the notice for notice and hearing, and I'm therefore entitled to obtain an attachment absent a court order, or in other words, on an ex parte basis.
So the way the current law says that if I borrow under $200,000, that they cannot, they cannot use the PJR, correct? 250,000. Under 250,000.
At present, the law is clear that no commercial financing agreement can obtain such a provision. It is void ab initio by legislative fiat.
So this bill is trying to reduce that to say, if I borrow $100,000, that same rule applies.
As it relates to the MCA.
Yes, we're talking about MCA here. That's what this bill is about.
That's correct.
Okay. All right. So how does that, because someone had mentioned in their testimony that at the level of $100,000 and above, the use of the PJR will allow us to better protect against those small businesses that might attempt to take advantage of the transaction. So basically what they're saying is that at $250,000, borrowers are abusing the law that we were able to change, that protection. What's your opinion on that?
Does it exist? Could it exist? Sure. In my view, in my experience, I think adequate remedies are in place to protect lenders already, not involving the ex parte statute. So what do I mean by that? I believe that in let's say there's an MCA agreement for $150,000. There is nothing stopping a lender from going to court with a PJR application and seeking to obtain an attachment the standard way. To the extent that the lender is concerned that that application process will scare off the borrower, who will flee to parts unknown or otherwise dissipate their assets, remedies already exist to protect their interest. If there's a concern of the lender fleeing, there's another basis, I believe, for ex parte relief, if the court can be persuaded that they're going to flee. Temporary restraining orders can issue. A cause of action for fraudulent transfer can be commenced, which would say, let's say, Senator Miller, I'm about to get sued, and I give all of my money to my wife in exchange for nothing, because I can then say, well, if you sue me, I have no assets, my wife has all the money. Well, Connecticut has something called the Fraudulent Transfer Act, which says that if I dissipate assets to an insider for no consideration or an unfair amount in an effort to avoid my creditors, then my wife can get sued. And my money that I gave her can get disgorged, returned to me. And then I get sued as well for engaging in this fraud, whereby they would get their assets back as well as additional damages for that fraud under those circumstances. So while I understand the concern that, well, Judge, there's people that are under $250,000 who might abscond and protect me from being able to collateralize, I'm not as convinced, because it's not as if there are no other ways to protect them. To the contrary, I believe that there are adequate protections in place.
So if I may, Mr. Chair. So I heard you say that under our current MCA law, and even if we reduce, because we're thinking about reducing the threshold, that's what this law and a couple other things, that the provider does not have to notify the borrower. Is that correct?
The borrower gets, in theory,
In theory.
in theory, the borrower gets notified at the same time that their financial institutions get notified, because they get served with process at the same time. In practice, that's usually not the case. In practice, a lot of these borrowers perhaps are out of state. And when you sue an out-of-state borrower, got to go to the Secretary of State. You got to mail out certified mail, return receipt requested, and then they receive it. In the meantime, what happens? Well, if we know that the borrower banks at a national institution, Wells Fargo, Chase, they just waltz into their local branch, and the marshal serves the teller with paperwork and says, freeze this account. So I would say, in my experience, almost all the time, it's a situation where a person wakes up in the morning and finds out that their assets are frozen. They say, what the heck is going on? And then the bank notifies them that a lawsuit has been commenced. And then eventually they learn of the existence of the lawsuit through more direct means.
And so can you tell us, in a case like that, what would be the legal remedy for me as the borrower?
Okay. If your assets are frozen under an ex parte commercial PJR, then what you're entitled to as a matter of right is an expedited hearing to challenge the validity of it. Say, Judge, this attachment is too much. It needs to be reduced. Or, Judge, this attachment needs to be discharged in its entirety for whatever reason. The claim was fraudulent. I have claims of my own that offsets it. The point is, it gets you in front of a judge, and by legislative design, it's an expedited hearing. You get it done within 7 days. But at the present time, our statute is silent as to when the lawsuit needs to be returned. And that's something that's being addressed. But in the interim, what you've seen in New York, and quite candidly, what I've alleged in my case, is that the lender froze assets and made the tactical decision not to return the action to court. As a default measure, there's something that's called a return date that is attached to every lawsuit. There's a 2-month window between when the summons is signed and when the return date can be. So in theory, what could happen, and what I think is happening, is a return date is selected, assets are frozen, and then the lenders sit back. And they say, well, I don't need to go to court. I don't need to go to court until, 6 days before the return date, and I'm just going to sit back and watch you sweat it out while your assets are frozen. You want me to lift the lien? Pay me. Now, in my case, and again, it's just a full transparency and full disclosure, you're actually going to hear later today from opposing counsel in that case. And we talked about this, and I saw his name on the list, so that is happening. So I'm going to be very careful what I say here. But in my case, when you ask Senator what can be done, what can a lender do if they find themselves in that unfortunate situation where their assets are frozen, but there's no court file to seek your expedited hearing? Well, what I did was we commenced a lawsuit of our own. And we have alleged, among other things, that the lender engaged in an abuse of process by freezing the assets in a way to tactically leverage their settlement position, which violated the Connecticut Unfair Trade Practices Act. I sought and obtained an emergency ex parte injunction in that matter, which, among other things, compelled the lender to return the action to court, which they did the day after. And that would, but then, Senator, what that also means is that unfortunate borrower has to pay an attorney to commence that process, and it's not cheap. It's not cheap. And this is all in the context where assets are frozen. If the corporate assets are frozen, you can't make payroll. If there's a personal guarantee, credit card payments are frozen. How do you make ends meet? How do you pay for a lawyer? Do you borrow money from your friends? Do you scrounge for the spare change in your couch cushion, or were you fortunate enough to save hard money underneath your mattress? Maybe, but these are and this is not to say that this is happening frequently. I don't know one way or the other, but it is happening. And these are loopholes that need to be closed, I believe, before we allow the MCA industry to be given preferential treatment as they're seeking. Because, when it comes to, in my view, what is the primary responsibility of a legislature? It's to fight and protect and preserve the well-being of the residency. And I think that policy concern is implicated as we discuss the two issues relating to ex parte attachments with an MCA agreement, which again underscores my belief that this proposed legislation is premature.
Thank you, Representative Jacobson, and thank you, Mr. Chair, for allowing me to ask my questions.
Thank you, Madam Chair. Okay, seeing no further questions, thank you, Representative Jacobson. Appreciate you joining us.
Thank you, sir. Have a wonderful rest of your day, everybody. Thank you.
Okay. We're going to move on. Next on our list is Representative Bolinski, who's here with us today. In the room. Welcome, Representative.
First of all, I'd just like to start by saying thank you very much for raising this bill. It's one I've been trying to get attention paid to for quite some time. I have submitted detailed testimony, so I will not read to you. I will introduce, and then I'll just speak conceptually about how we got here and what the goal is. So if you'll bear with me for just one moment. So, it's an honor to be here today, and I thank the chairs, Representative Doucette and Senator Miller, as well as the ranking members. Obviously, Representative Delnicki and Senator Berthel. The entire committee, I appreciate being here today as well. I am here to speak to you about my incredibly strong support for House Bill 6194. It's an act requiring disclosures concerning the termination of certain funds and accounts. And most folks are not familiar with the circumstances of this, or that even that this is a problem. But the history and events that surround the inspiration for this bill began in 2013 session year. General Assembly created a Sandy Hook Workers Assistance Fund. We called it SHWAF for short. It was the first public act of 2013, 13-1, and it was a response to the aftermath of the shootings that were experienced in Newtown on 12/14 of 2012. And the purpose of this particular fund was to take care of our first responders and the people that were working in close proximity to or in the facility that was, the subject of that day. What we found was that not everybody had the proper coverage to have the supports necessary to seek workers' compensation claims for trauma-induced PTSDs and ongoing therapies and other therapeutic measures that were needed, because the bill was quite comprehensive at the time, and we were careful to include unionized and non-unionized individuals in this, including folks that were in the building, and that might have just been facilities manager type folks, in addition to our first responders. So that fund was successful. It dispersed nearly $380,000 of benefit money to cover the therapies and the recovery of a number of individuals. But the purpose of the bill is to preserve the spirit of what we created there and protect future trusts from being raided by outside special interests. So what happened with this particular fund was in 2025, a unaffiliated charity executed an MOU, actually two MOUs in sequence, and emptied the balance of the fund, which at the time was about $116,000. That $116,000 was reasoned away without the knowledge of us in the legislature, without the knowledge of the Newtown Sandy Hook Foundation or the Sandy Hook Workers Assistance Program administrators. And at the time, the fund was less active than it was in 2013 and 2014. However, we did get a claim from two police officers with delayed PTSD claims in 2018-19. And when we went to service their mental health needs, we were told that the money was gone by a new administrator that we did not know had been appointed. It was very, very concerning, and we opened up an investigation, one of two investigations with the state attorneys general, and subsequently one with the independent auditors of the state of Connecticut, and the findings were very simple. The MOUs were executed emptying this fund, essentially sunsetting the foundation when it was still actively needed. So the legislation that before us seeks to prevent that from happening by simply having proper disclosures to the people that created that particular that fund and the spirit of what it was intended to accomplish, which was to have folks be supported in the necessary therapies that came after having experienced firsthand something that no human being should ever have to experience. So, so I sit before you, asking that we advance this further, but with greater appreciation that we're having a public hearing on this at this time, because while Schwalf is sunsetted, its work continues through other community foundations within my community, but there are other communities throughout the state and throughout the country that experience, extraordinary events that require attention afterwards, because one of the things about trauma that nobody seems to quite grasp is that it doesn't go away in a couple of years. It's a generational thing. So having these protections for these foundations in the future so that they can't be preyed upon by other foundations that in part fund themselves by raiding other trusts, because we found a pattern in the events that emptied the $116,000. We also found that the foundation that took it couldn't account for the money, and that it had been used in anything other than $6,000 worth of therapeutic services and $6,000 worth of administrative cost. Essentially about $105,000 disappeared because of commingling of funds into thin air, with the only evidence of where some of it was spent on ATM receipts for cash. So, I look forward to working with the committee to, mutually discuss and learn what can be done to remedy this and to not have it repeat. And that is my very simple yet complicated request today, Mr. Chairman.
No, thank you very much. Thank you for your testimony. Thank you for bringing this forward. Fair to say, I think that this issue, if not for your advocacy on behalf of your community and having the involvement for this, would have probably gone unnoticed, or it's a unique situation in that it was created by an act of the legislature. And I'm trying to search for 13-1. I don't know if it was a special act or a public act. I'm curious now.
It was probably, probably Special Act 13-1.
Yeah. What conditions at the time were placed on it? Are you aware of anything in that enabling legislation that said that they had to make certain reports, and to whom, and what kind of information had to be sort of reported and disclosed?
That's a great question, actually. Thank you for asking. The conditions were to require annual reports or reports upon demand to legislative leaders, and because that's where it came from. So I do know through review of past correspondence that reports were issued in the early stages, because I have correspondence from our council acknowledging those reports and sharing that information with us. we're very careful about sharing that information. We don't want anybody's identity, nor do we want, even for that matter, the number of people serviced by such a fund to become public. We're very private in Newtown about not relying on that event to in any way ask for things that are not totally necessary. But there were reports that went for, according to my correspondence, for the first 3 years, and then they stopped. My simple request, as a person who's not an attorney nor a banking expert, nor even an expert in execution of memoranda of understandings, my simple request is to make sure that those that create a fund for a particular reason be informed of changes in that fund's disposition, especially if it comes to the point of exhaustion of financial assets and or the sunsetting of the actual activities of that particular organization.
No, it makes perfect sense. It makes perfect sense. I appreciate that. Senator Miller online has a question.
Thank you, Mr. Chair, and good morning, Representative Bolinski. Great to see you again. Just saw you in aging. So I have a question for you. Have you thought about the mechanism of how the General Assembly would be notified regarding the disposition of the fund?
Well, in the past, there has been disclosure, and it's been in letter form. And as you know, we routinely do get reports within our committee assignments. And also, if there's a special interest involved in a particular piece of legislation, we do write in other people to be distributed to, but according to, Connecticut statute, X dash or dot year, we routinely see reports from commissions, boards, working groups, task forces, et cetera. So my assumption is that we would fit into that framework where there would be a statutory regulation that the reports are filed. It would become best practice, and it would wind up in the actual acts as they are passed. The protections were not in the 2013 Act, and if they were, they fell by the wayside somewhere in the year 3 mark, at which point the movement of funds occurred.
So let me ask you this. Thank you for your answer. How would you like the report to come to the General Assembly? Because there are a lot of committees, there are committees of cognizance, there's leadership. What would be your recommendation? Because I could see it falling through the cracks again when you say the General Assembly said, oh, I sent it to the clerk of aging, because that's where Representative Bolinski's, is ranking. So how would you, or do you have a suggestion of what committee leadership, should it go to leadership? Because I just see that there may be a concern about exactly where the report should go.
I believe that leadership should be on the recipient list. I believe that that the sponsors of such legislation should also be on that list, as well as representatives of the foundation that is the beneficiary or the administrator of said fund should have periodic updates as far as its financial activities, its its service and level of activity, and there also should be a delineation between what what would be an acceptable sunsetting date versus having something be perpetual. So, but with the notification, actions can be taken to to manage the administration of such a fund and make determinations about whether or not those funds, if there are residual funds, are then repurposed, and if at all possible, repurposed at the direction of the foundation that was originally formed in something that resembles the mission that is or was at the heart of its initial intent.
Okay, well, thank you for your testimony and your answers, and we appreciate you bringing this issue to the Banking Committee. Thank you, Mr. Chair.
Thank you, Senator. Rep.
Thank you,
Delvecchi.
Senator.
First of all, I want to thank you for coming forward with this. And when you told me the whole background, I was shocked, knowing exactly why the funds should have been there, that the board that was in charge of constituting this fund, each member, in my opinion, should have been notified. Does that make sense?
Absolutely, there is a board, but there, at the top of that board was also, an administrator. That administrator found out that the fund had been essentially sunset and was devoid of assets. About 2 years after it was purged, and hanging in the balance was the mental health care of 2 police officers with a delayed PTSD reaction. And she called me, the administrator called me, and when we had our initial conversation, she conveyed to me what I've conveyed to you, and my reaction was, how could that happen? My second reaction was, they couldn't pick a charity that didn't have to do with something, quite so terrible. On behalf of the community and the foundation, it was quite a shock. And it felt wrong from the very first second that we discovered it. The fact that it took 6 years to get anybody to actually investigate it was also something that was quite shocking. Now, that's not within the purview of the Banking Committee. Setting up the rules so that something like this can't happen again is the absolute best that I can hope for right now, and the only reason I'm here.
It seems, looking back in retrospect, everything's 2020 vision.
Yes, sir.
And had there been safeguards, had the auditors a public account, had there been requirements of notice that it would be disbanded, anything of that nature might have prevented what occurred here. And I want to say it was a costly learning experience, but I hope that we never run into that kind of experience again, where we have to constitute something like that fund. Your advocacy here, Representative Bolinski, is exemplary. And I know a lot of it was functioned around the fact that it was close to your heart and your community. And you want to make sure that appropriately the money should have been disbanded in some fashion that made sense, that everybody could have been on board, that everybody would have had a say that was part of constituting it and constituting the fund. If you have any ideas on how in the future a fund like that should be disbanded, the notifications, the folks involved, et cetera, I think we're at 150% receptive. to hearing what they are. And I think we can do something to prevent anything like that in the future so that we don't have to live through that, don't have to run into a situation where monies disappear and there's a cloud over what occurred. And again, thank you for your advocacy. Thank you for coming forward. And thank you for the conversation we had, a couple of months ago pertaining to this.
I'm very grateful for your interest and for the opportunity to bring this forth. I do have ideas. We'll speak on a community level about that. And just for closure purposes, on November 11th of 2024, the offending charitable foundation returned $105,823, I believe, to what was a sunsetted organization at the time. So we made a determination along with the Newtown Sandy Hook Foundation, which was the parent of the Sandy Hook Workers Assistance Fund in administrative terms. We basically asked the foundation, do you have a need for this in the area of mental health that's related to trauma and crisis? And they said, we all always have that need. So we reached an agreement to disperse that 105,000 and change back to Sandy Hook and the foundation, and that money's been put to work on mental health supports in our community, where it was initially intended by the people that donated to it to have been used. So I thank you very, very much, Representative Delnicki, Representative Doucette. Thank you so much. Senator Miller, Senator Berthel, your attention means an awful lot to an awful lot of people. Thank you.
Well, thank you, Representative, and thank you, Mr. Chair.
Thank you. Yeah, thank you again for joining us. And I will say, again, this, if you had not brought this to light, it may have never been noticed, and it is something that certainly needs some amendment and reform. I did find the original special act. It does refer to reports, but it seems that at some point in time, I don't know if the legislature, contemplated it going on this long, because it gives a few dates of May 1st, 2015. There was supposed to be a report produced recommending any distributions upon termination of the program. And it seems from what you're telling me that the program was still going, up and running at that time. Somewhere along the line, something fell off. And, I think it requires some further investigation on all our parts. And at a minimum, what we're talking about here in this proposed bill is something that is absolutely necessary. It shows, to the extent there are any other funds out there, or the legislature's doing this again for some reason. So at a minimum, I think your bill is very important here, and I'm glad that that you brought it to us.
Thank you very much. I
Okay.
appreciate it, Representative.
Thank you. Okay. We're going to move on to Representative Gibson, who is next on my list. I don't know if he's with us online. I'm not seeing him at the moment, so we might be skipping over Representative Gibson. No? Okay. All right, so we're going to skip Representative Gibson for now, and we're going to move on to Matt Smith and Joe Chambers from the Department of Banking. Welcome, gentlemen.
Great. Thank you.
I know you have a number of things that I think you want to talk to us about today, so I'll let you divide it up. You get to combine your 6 minutes.
Sure. Thank you. Good afternoon. It is just afternoon. My name is Matt Smith. I'm the Director for Government Relations. I'm joined by Joe Chambers, our General Counsel and Chief of Staff, co-chairs Miller and Doucette, ranking members Berthel and Delnicki, honorable members of the Banking Committee. Thank you for the opportunity to testify on several bills that are before the committee today. The first one, Senate Bill 1399, an act concerning a limited purpose trust company. This proposal would create a new limited purpose trust company charter with which the Department of Banking believes is redundant and unnecessary at this time. The banking laws of Connecticut currently provide for a trust bank charter, which allows for the chartering of institutions organized to function solely in a fiduciary capacity. This charter has been available for more than 40 years. The proposed bill would provide an alternative that does not feature many of the safeguards of the trust bank charter, including an asset pledge, a $2 million minimum capital requirement, and a well-defined rigorous application process. Connecticut trust banks, as their name suggests, are institutions consumers trust to manage what is, in many cases, their life savings. Simply stated, this proposed charter seeks to address a need that does not exist. The department strongly opposes the creation of this new charter type. Lacking the proper regulatory controls, institution organized under the proposed limited purpose trust would become more susceptible to instances of fraud and abuse, exposing consumers and industry to unnecessary financial and reputational risk with no clear benefit. The second bill is House Bill 7098, an act concerning various revisions to the credit union statutes. This is a couple of sections we support and a couple of sections that we oppose. Sections 1 and 3 of this bill represent agency proposals to make changes to the credit union statutes. Section 1 adds a definition for a loan officer employed by a Connecticut chartered credit union. Section 3 would allow Connecticut chartered credit unions that are certified community development financial institutions to accept non-member deposits. Certified CDFIs is a designation given by the U.S. Department of Treasury to encourage lending in low and moderate income areas. Currently, federally chartered CDFI credit unions may accept non-member deposits. Section 3 of this bill would grant Connecticut chartered credit unions parity with their federal counterparts. This change is aimed at increasing lending and investment in needed areas of the state to encourage economic growth and job creation. The sections that the department opposes of this bill, the department opposes Section 6 of this bill. This section concerns which organizations can receive credit union charitable donations and would change the limit for donations for which board approval would not be required. Currently, each donation requires board approval. This proposed threshold is too high. For example, under this proposal, a credit union with $1 billion in assets could make numerous donations up to $1 million without board approval. As a regulator, the department believes that such proposal would result in woefully inadequate corporate governance controls over charitable donations. The department also opposes Section 7 of this bill in its current form. As presently contemplated, the proposed bill would expressly allow for insiders, like senior executives and board members, to receive preferential loan terms more favorable than any programs available to other employees of the credit union. This is in direct conflict with generally acceptable standards of governance. Additionally, such arrangement may violate federal regulations related to insider loans. Finally, this is also a matter of basic fairness. A credit union CEO should not receive better terms on a loan than the credit union's tellers. The department supports a policy which would allow all employees of a credit union to receive the same preferential terms. We look forward to working with the proponents of those sections of the bill as the bill moves through the legislative process. Finally, for me, is Senate Bill 1398, an act concerning the Community Reinvestment Acts. We offer general comments on sections 1 through 5, which I won't address here, and we do oppose Section 6 of the bill, mostly founded on resource terms. So Currently, so section bill of this would require the department to conduct fair lending compliance exams designed to enforce federal fair lending laws. This requirement in the proposed bill would place extraordinary burdens on the department, which at its current staffing levels, the department would be unable to meet. The department licenses 470 mortgage lenders at this time, of which 70 meet the threshold of originating 50 or more loans proposed in this bill. On average, teams of 2 examiners can perform 10 exams per year. At this level, the department would require at least 14 new examiners to meet the requirements of the proposal. In addition, the department would require 2 additional attorneys and 1 paralegal position to ensure proper enforcement. This framework contemplates only our current number of licensees. As the mortgage industry follows interest rate trends, where the Federal Reserve may continue to adjust rates downward, the number of mortgages would increase, and with it, the number of companies captured under this bill, which would further strain the department's ability to meet its requirements. In addition, the department lacks the capacity to train new examiners to conduct these complicated exams. Since these are federal statutes, we would look to our federal regulatory partners to assist in training department exam staff. Given current uncertainty with our federal regulators, this will present an obstacle for the department. And I pass it off to Joe.
Thank you, Matt. My name is Joseph Chambers. I'm General Counsel and Chief of Staff of the Department of Banking. Thank you for the opportunity to testify on SB 1396.
Joe, I think your mic is off.
Thank you,
Perfect.
sir.
Thank you.
Thank you for the opportunity to testify on SB 1396, an act concerning earned but unpaid wage or salary income advances. Under Connecticut's current Small Loan Lending and Related Activities Act, as it exists today, licensed lenders may impose finance charges resulting in a maximum of 36% APR for loans under 5,000. And yet the EWA industry represents that it cannot operate profitably in Connecticut if it must comply with the Act's 36% APR cap. So, as the Banking Committee co-chairs encouraged, and the Governor's Office and the Banking Commissioner directed, Department of Banking staff have engaged in a months-long effort to explore an alternative framework for earned wage access advances within the Small Loan Act. We have met on numerous occasions with a 4-company coalition of providers to share ideas and exchange drafts. With those companies, we collectively attempted to provide flexibility and address the perceived unique attributes of EWA while preserving consumer protection. Although we were not able to reach a complete consensus with all companies on all provisions and all issues, SB number 1396 is a result of those efforts. Although the department would prefer that the requirements of the current Small Loan Act continue to apply, and the industry may prefer fewer restrictions that SB 1396 provides, the bill is certainly something that the committee should consider. SB 1396 would amend Connecticut's Small Loan Act to exempt certain earned but unpaid wage or salary income advances from the APR caps. As an alternative, the bank would cap the total allowable finance charge per advance at $5, including tips and expedited fees. In addition, the bill would cap total finance charge in a 30-day period for providers that operate a subscription-based model at $30 if other bona fide services are included. Notably, the bill would require both employer-integrated and direct-to-borrower providers to accurately verify a borrower's actual earned but unpaid wage or salary income prior to making an advance. And the bill would prohibit providers from making an advance in an amount greater than the actual verified amount. Other features of the bill include a requirement that providers offer a minimum advance amount of 75% of the actual verified earned but unpaid wage or salary income. This would prevent providers from undermining the $5 fee cap by strategically limiting advance amounts to reap additional fees. If the committee is inclined to move forward with SB number 1396, it may wish to consider 3 additional concepts described in the department's written testimony. If the committee wishes, I can go into the details of those three concepts. If not, in closing, I just want to make the committee aware of testimony that was submitted, I believe, yesterday by the Commissioner of Financial Regulation in Maryland regarding a bill that was introduced in the Maryland legislature, in which a public hearing is ironically occurring today. The testimony includes a report on Maryland's recent market study of the EWA and industry in that state, and it may be helpful to the committee as it considers SB 1396. And I have copies that I'll leave for the committee members.
Thank you. Yeah, I have a couple of questions, but I'll start by asking you to elaborate on the you said you had three recommendations for revisions.
Sure.
To the bill.
Again, if the committee is inclined to move forward with SB number 1396, it may wish to consider three additional concepts. First, the bill currently lacks a provision that would prohibit providers from making an advance to a borrower when another provider has already made an advance to the borrower on the same verified earned but unpaid wage or salary income. If earned wage access providers are to receive an exemption to the 36% APR cap for advances on actual verified earned but unpaid wage and salary income, they should not be allowed to make multiple advances on the same verified amount. The second advance should be treated like any other small loan and subject to the APR cap. Second, and related, to ensure that multiple providers do not make advances on the same verified earned but unpaid wage and salary income, each should be required to submit information to a third-party database regarding all advances made to Connecticut borrowers, and should be required to use the database to verify that no advance to a borrower would violate the act. The third concept the committee may wish to consider is to establish an upper dollar limit for earned but unpaid wage or salary income advances, above which the exemption to the APR cap would no longer apply. After that amount, they would be treated as any other small loan and subject to the 36%. So for example, the committee could set an upper limit at $1,000 or some other amount above which the advance would not be subject to the same APR cap, and then it would be subject to the same APR cap as any other small loan.
Okay. So to clarify, you said three things, but the first two are sort of one and the same, correct?
Right.
So we're
One's
talking
required.
about
It's a requirement to verify.
advances, right, that would be based on the same income. So in other words, a borrower would be going perhaps to multiple companies even, or multiple apps verifying the same income. Is that what we're talking about?
Correct. You could have an employer integrated provider providing EWA to an employee, and that employer integrated provider has access to the payroll data of the employer. Separately, and unbeknownst to that provider, the borrower could go to a second, say, direct-to-consumer app and take out and go through their verification process, which my understanding does not include access to the employer's payroll database, but through their verification process would be able to secure a second advance on the same amount of earned income. And in that situation, really, the exemption of the 36 APR cap just doesn't make any sense.
Okay. Got it. And then the third one, actually, something I was going to ask you about, because I think in the context, I think there was some comments that I saw, and we don't have time to get into all of the individual comments sort of from the industry on this, but there was a comment I read somewhere about the 75% of income that there may be, if somebody had a very high level of income, that 75% would kind of be sort of way off the scale of what we're trying to do here. Is that sort of related to the same issue when we're talking about setting an upper dollar limit?
The interplay, there could be an interplay before the upper limit concept and the 75% limit concept.
And I guess what's the purpose of the 75%?
Well, the purpose of the 75% requirement would again be to mitigate against a provider who strategically decreases the advance amount that a borrower would otherwise be eligible to take, merely to force the borrower to take out a second subsequent advance, and then pay a second fee. So instead of taking out $100, the provider could limit the borrower to taking out only $50. The next day could make the borrower eligible for a second $50. And instead of one $5 fee, there'd be two $5 fees totaling $10. So to prevent that, the 75% cap would be if the borrower is eligible for an EWA advance, the borrower is eligible for up to 75%. Now, I understand the concerns from specifically one of the companies. We had engagement on that issue as well as all the other issues. I think there's, again, I think the fruits of a solution or the seed of a solution could be in the upper limit requirement, and it could also be that the 75% limit would be a requirement only up to a certain amount. So you could have, and I acknowledge the concern of the provider. Right now, the 75% requirement would require providers to offer an advance of $50,000 because that's the upper limit of the Small Loan Act. If the borrower had a verified income of 66%, so 75% is 50,000. If they wanted to loan more than 50,000, it would be outside of the Small Loan Act. Requiring them to make an advance of that amount, or even 10 or 5 or 1,000, really doesn't make sense. Nor does treating large as, say, over $1,000 earned wage advance amounts differently than other largest small loan amounts really doesn't make sense. So the interplay would be as follows. The 75% requirement would only apply up to the EWA maximum amount, threshold amount, beyond which the ordinary APR caps would apply. For example, there's an EWA maximum amount limit of $1,000, let's say, and the borrower had 2,000 in verified income. The provider would only be required to offer 1,000, despite that the 75% amount would be 1,500. Or if there is a maximum amount of $500 and the borrower has $100 in verified income, the provider would be required to offer $75, but would not be allowed to offer up to $500 and still fall within, and would be allowed to offer up to $500 and still fall within the APR exemption.
Understood. So what would your recommendation be then for that number, if we were to set that max? And I'll ask the same question of, the industry as well. And obviously we can continue to have some dialogue on that, but what would you suggest at this point?
I think that when we, again, the Maryland market report in the testimony that I referred to a few minutes ago contains data. I'm sure the committee has heard data on what the average amounts of EWA advances are. If they're $80, $100 in that range, then I think the committee ought to be viewing EWA in that light. Some providers set a cap, no matter what borrower it is. There's say a $250 cap. So working with that cap, the committee, if it was in the range of say $500 to $1,500 for an upper limit, I think that would be a reasonable policy choice for the committee to make.
Well, thank you. And, I just want to say before we kind of, this is my last question on this issue. We could probably go on for a long time and we're going to hear from others today, but, I do want to acknowledge your participation and the DOB in the ongoing discussions that we've had over the last couple of years. Obviously, the changes to the Small Loan Act that sort of bring us here for this discussion today were made 2 years ago. I understand if you reiterated, a fair number of times for us that the intent behind those changes, they were adopted by this legislature and have been implemented, and we've had ongoing discussions. But notwithstanding that, you have engaged in good faith conversations again, involving the participation as well of this committee and the governor's office. And so I think that it needs to be recognized. And I think it should be recognized, especially, for those who are consumer advocates, to this discussion today here, not part of the industry discussion, to know that, the department's position all along has been, what we've adopted 2 years ago is now the law of the land, but we're willing to listen and have these discussions with the industry because, we recognize that, there is a demand in the consumer market for this product. And it's a unique product and developing product as most things in the fintech space are. So we need to continue to have these discussions. So I do want to acknowledge and thank you for your participation in the process.
Thank you.
And being involved in the communication. I did have one question about for Matt on 1399. Shifting gears a little bit. So we're going to hear later, I believe, from Attorney Rothschild, who I think was the main driver behind this concept and highlighted for the committee that it's similar to a process that's been adopted in Massachusetts and has presumably worked in Massachusetts. You mentioned that the department's position is that the proposal is redundant because we have the trust bank statute. However, I guess my reading of this bill, and maybe I'm incorrect, is that it would create a non-bank entity, a limited trust company, which my understanding is that in this realm there are trust companies and there are attorney trustees who manage a lot of substantial trusts that would otherwise be subject to regulation by the DOB. So the idea that that I'm getting from the proponents of this is that it would offer some additional flexibility and some more streamlined sort of regulatory framework to administer those types of trusts that aren't administered by a bank. Is that correct? So I mean, you said the trust bank structure already exists, but there are trusts that are administered by trust companies and by trustees that are unincorporated or are non incorporated entities, correct?
Sure. Well, I would offer that one, the bill is very light on what actually regulations it's subject to. It does leave some room for the commissioner to sort of plan that out. It does offer an exemption for attorneys who are engaged in this type of activity, which is, I think, also important to note. I think as outlined in the testimony, the fact that the trust bank does require an asset pledge, it provides some protections if something should go wrong. We think that those are important guardrails and were written in there for a reason. And this limited purpose trust company seems intent to sort of get around some of those requirements. We still think those are important because mistakes can happen, fraud can happen, and the person left holding that will be the consumer.
Well, that makes sense. And likewise, like I said to Joe, thank you for engaging in this discussion. This is a concept that was brought to us and I think is worthy of more investigation, which is why
Sure.
we have hearings on these issues. So appreciate that and would hope to have continued discussions on
Absolutely.
this. Senator Miller online has a question or questions.
Thank you, Mr. Chair. So Joe, I want to align myself with my co-chair's comments on the Department of Banking's willingness to sit down with the stakeholders, the EWA industry, to come to some type of agreement and to come to this product, which is this product that we have today. Joe, can you estimate how many hours that you sat down with the industry to negotiate this product?
It was a number of hours over several months, and I think they were good discussions. We obviously started the discussions really a year and a half ago with when the looming effective date of the legislative changes to the Small Loan Act were upon us. We started those conversations, and we continued those through the period of no action when the department agreed to hold off on enforcement. And then through the last legislative session. And, again, with the encouragement and at the direction of the governor's office, we spent a lot of time in the last 6 months with the 4-company coalition. And I think, made some progress.
Thank you. And I think it's important, as my co-chair mentioned, that the users of this product understand the hours that went into the compromise that we see before us today. So I believe in examples, and I was wondering if you're able to tell us how this product that we have in front of us today, how would it work for an employer integrated product and a direct consumer product?
It would work quite similarly. And specifically, both employer integrated and direct to borrower providers would have a meaningful verification requirement, so that they would need to have a mechanism to be able to verify the actual earned but unpaid wage and salary income prior to making the advance. For employer integrated providers, that is relatively easy because they are able to coordinate with the employer and get access to the employer's payroll data. For the direct to consumer, the direct to borrower providers, that's a little trickier. And currently in the bill that there are some things that are listed that could meet that verification requirement. And if there were others, that then they would need to go to the commissioner, have a discussion, and get approval for those alternative verification methods.
Okay, so you talked about caps, you talked about fees, and from what I understand, prior to us changing our law, I could just, if I wanted money, I'll get the app and ask for the funds and get in. I guess we would enter into a repayment agreement. If I couldn't make the repayments, or if I needed more money, I tell them, look, I need some more money. They give me the monies. We set up a new payment plan. They never come after me. This is what I was told. We were told that they never come after me for the monies if there's a default, and I could go my merry way. And so my question to you is, can I now, under this product, do that? Can I go back to the same company or go to another company provider and ask for a loan or obtain a loan?
If a borrower, say, works at a employer who has a relationship with an employer integrated, the bill would only require adherence to the fee cap and the other requirements, but that employee under this bill would be able to continue to access EWA advances through that arrangement. And similarly, customers of a direct to borrower EWA provider who wanted to have an advance would be able to obtain an advance as long as the requirements of the bill are met, including the $5 fee cap for providers that have fees like expedited fees or tips and other voluntary charges. And for those providers who have a subscription-based model, there would be an up to $30 a month subscription fee cap, where the earned wage access is included in those subscription models.
All right, thank you. You mentioned a suggestion that you think that this product would benefit, or I guess the consumers would benefit. And submit information to a third party to actually track it? Because I assume the product that we have in front of us today, there is no way of tracking whether someone has more than one, or the number of advances that they've taken. And so does such a third party exist already, or would the industry have to create something?
Well, early in the discussions with the industry, we had floated a proposal that there be a monthly transaction cap per borrower across the providers. So our suggestion was that borrowers be allowed to take up to 4 advances out, irregardless of who the provider was. And with that, we recognized that the providers would not necessarily have each other's information. We would expect them to have each other's information, so that it would require creation of a third-party database. We went in a different direction from the monthly transaction cap. As you'll see in the bill, that's not included in. But we also heard that the industry, didn't like the third-party database concept because of the burden in creating it. So we kind of moved on. Subsequently, the department learned that 12 other states require payday lenders and other small loan lenders to submit information to third-party databases to ensure a compliance with applicable lending laws. So, and even there's not yet a similar database set up specifically for earned wage access. However, there is pending legislation in Washington state that is cited in our written testimony that contains a provision to implement a third-party database to ensure compliance with other requirements in that legislation. So here we've suggested that the committee consider a prohibition on providers making an advance to a borrower when another provider has already made an advance to the borrower on the same verified income. And really you would need a database to be able to enforce that provision. Otherwise, the providers really would not know whether they were making a second advance on the same income.
So, Joe, what are the consequences of the violation of that?
Well, within, again, this framework within SB number 1396 is a framework, an alternative framework specifically for earned wage access advances, but it's still part of the Small Loan Act. And like our other substantive provisions within the banking law, the commissioner has, general authority under 36A-50 and 36A-52 to enforce compliance, including imposition of civil penalties and ordering restitution to be provided to consumers. So if there was a violation of these specific provisions, those same enforcement remedies would also be applicable.
Okay, well, thank you, Joe, for testifying before us today, and especially thank you for the work that went behind the bill that we're seeing before us today, because I know it was a long road, a year and a half that you've been talking to the industry, and they did pull out all the stops and had their consumers email us saying that we need this product. And I think that the governor heard, Department of Banking heard, and the committee heard the cry of the people. And so in some ways, I'm going to be honest with you, I think it can be predatory. But it's been a balancing act for all of us. And how do we meet the needs of the people as well as protect the people? And so I'm hoping that this product does that. And like we've done since I've been in the General Assembly in 2009, we always have to come back and tweak in case something does not work. And so I'm hoping that we don't have to tweak this. But again, I can't thank you enough, the commissioner, as well as you and your team, for being willing to sit down with the industry and come to some type of consensus. Thank you, Mr. Chair.
Thank you. Representative Dilnicky.
Thank you, Mr. Chair. And listening to the explanation here, it is quite the work in progress. And to that point, what the final product, how does it mirror what other states have done and produced in the way of a product and the associated moving parts as you talked about?
So I can tell you that there are similar conversations happening within public hearings in legislative houses across the US. The result of some of those over the last few years has been 6 states have adopted a registration requirement and a version that of a bill that industry supports largely, that provides some consumer protections, but does not treat earned wage access advances under small loan law. Nor in those states do they impose the significant consumer protection of the 36% APR cap. I think the commonality of those 6 states is that in those 6 states, payday lending and small loan lending wasn't regulated in the same way, and earned wage access didn't fall within existing regulatory frameworks. So those states where earned wage access advances didn't fall under any existing regulatory framework, those states, adopted that version that, frankly, is probably better than nothing. That's not, of course, where Connecticut is starting from with our Small Loan Act. Other states, significantly, Connecticut is not alone in applying its small loan law to earned wage access advances, nor is Connecticut alone in deeming tips, subscription fees, and expedited delivery fees, finance charges, and subjecting them to APR caps. Specifically, the state of Maryland Commissioner of Financial Regulation issued guidance that certain earned wage access advances are covered under Maryland's small loan law. Accordingly, in Maryland, like in Connecticut, most earned wage access providers are required to be licensed, and tips, subscription fees, and expedited delivery fees they charge are subject to applicable APR caps. And notably, in both Connecticut and Maryland, some earned wage access providers have recently applied for small loan licenses. Other states, I think Vermont legislature recently took up perhaps a similar bill to those 6 other states: Nevada, Missouri, Kansas, South Carolina, Wisconsin. I think the legislature, the outcome of those hearings was that more work was needed. So it could be that, Connecticut or Vermont maybe will continue to deliberate just like the committee has and come up with some other framework. 2 other states that I know of, there are probably others, but New York State has at least 3 pending bills. 2 are similar to each other. They would, among other things, require licensure, impose a fee cap, and give authority to allow the New York DFS, the Department of Financial Services superintendent, to set a rate cap amount, for example, an APR or a fee cap. They include tips and fees subject to the rate cap, limit the amount of the advance to percentage of earned income as set by the superintendent. The bill would require disclosure of the consumer of costs of the advances. The other state that has a pending one I already mentioned in the context of the database requirement, but Washington State has at least 1 pending bill. It appears to apply only to employer integrated EWA, but it would require licensure. It would limit fees to $5 advance, and then a $10 per calendar month cap. It would include expedite fees, subscription fees, and tips within that fee cap. It would, again, require the third-party database. And importantly, it would require the providers to check to verify that no advance would violate those statutory provisions.
The third-party database, who's going to be administering that? What information would be on there? And would any of it be protected by some level of confidentiality? Or would it have some identifiers that if it were ever hacked into would provide some bad actor with the information of some of the folks that are actually in the database based on their usage?
I think that, any database that would be created would be required to have best-in-class cybersecurity protections for the personal identifying information of the consumers that are on there. Likely, obviously, the other providers would not have access to those details. Only the third-party database provider would be. I don't know that we have delved too deeply into the mechanics about how a third-party database would be established and overseen. But it would certainly at a minimum need to meet the approval of the banking commissioner, how the database was set up and who operates the third-party database. I think among those 12 states, different states have it set up differently, but, and I believe that there is a person from an entity that is a vendor for at least some of these 12 states that either plans to testify or will testify or has submitted written testimony. So you may be able to ask those questions of that person as well.
And the selection of the third-party vendor, again, what would the qualifications be for a third-party vendor? And has any other state already done that so that we could mirror what's occurring elsewhere? And if there's any bugs, that we don't have any problems with that?
I believe that is the case. So there, again, 12 other states have set up, something similar. Maybe they don't operate all the same way. One template is Washington State, the pending legislation there, and they describe a bit on how the third-party database would be established and overseen. But I think the commonality among those states is that it's a third-party database, either established or approved by the commissioner or superintendent in those states, and that it meets the approval of the commissioner.
So
And
there
if
would
I
be
can
some
add something to that.
qualifications then.
I can add something to that as
Go
well.
ahead.
The commissioner does have certain authorities on the banking and credit union side when they use third-party vendors. So we do have in Connecticut banking law, something to look to that may provide some guidance if the committee should so choose to look at that as the bill moves forward.
Yeah, I just have concerns over, could that be something that gets hacked into, then there's some confidential data and
Sure.
some
And-
exposure
Mhm.
of people's financial well-being and
Mhm.
worse yet, perhaps a social security number or something like that in there.
And I think they would probably be subject to, or we could write it explicitly, to the privacy laws that are already in place here in Connecticut, which are pretty substantial.
So we're still fleshing that out, the third-party vendor language?
Concept.
Okay. Well, certainly I look forward to seeing what that is, and hopefully there'll be plenty of safeguards to, protect people's privacy, and to protect their data so that somebody can't go in there and hack it and use it for God only knows what.
Sure.
So, well, quite the deep dive you did there. And were there any EWA providers that don't want to go with this and may not be a party here in Connecticut? And you don't need to name anyone, but are there any other folks?
Almost certainly. In Maryland's market study, they identified 17 providers that provided data. So we have only had close engagement with 4 of those companies, and I think it's best to let them speak to where they are on the.
Okay. Well, thank you for your testimony here, and
Thank you.
try to think of the appropriate adjective, the hard work that you had going forward to bring everybody to the table. Kind of like herding kittens, maybe. Thank you. Thank you, Mr. Chair.
One final comment concerning this too is if you see the Department of Labor has submitted some written testimony that they do have some concerns and how this product might interact with the labor statutes and whether it meets their requirements. So it's something that I think as we move forward, we're probably going to need to engage with them as well.
Thank you.
All right. See no further questions. Thank you, gentlemen.
Great. Thank
for your
you.
testimonies today. Next up, Tom Mongello. Mr. Mongello, always a
Mr. Chairman, great to be here. And thank you to Senate Chair Miller, ranking members Delnicki and Berthel, and members of the committee. It's always a pleasure to be before the committee. Today, I'm going to be testifying on the first agenda item, which is Senate Bill 401. However, we do have written testimony that we've submitted on Senate Bill 1398, House Bill 7083, and lastly, House Bill 5503. And happy to answer any questions on that if anybody does have any with regards to that written testimony. As you can see, Senate Bill 1401 basically covers disaster savings accounts. We think this is a good bill. It ought to pass. In the previous public hearing, we talked at great length about a first-time home buyer's account. This is a similar type of a concept, only it is tax advantaged for those homeowners who essentially experience some type of a disaster and don't necessarily have the funds to cover all the costs, all the expenses associated with it. Think back to obviously the tragic flooding that happened around the Seymour area and the Naugatuck Valley area just during the summertime, and many people were underinsured. So this would simply permit homeowners to open up an interest-bearing savings account. Several other states also have similar accounts, particularly South Carolina, which I think is kind of like the standard, if you will. Mississippi and Alabama also have similar accounts. It would also allow the homeowner's employee to contribute into that account based on the language which is before you, up to about 10%, I believe that is, up to $2,500 per year. So a homeowner would be able to contribute $2,500 a year into this. And I believe it was a maximum of $15,000. There's qualified expenses, which are identified. It could be a number of different things. Certainly, I think when you take a look at the list, it covers just about everything. And the good news is, and I like the fact that it is not relying on a federally declared disaster to be able to use those funds towards expenses. It's basically wherever you experience a casualty loss, where your hazard insurance policy doesn't cover the required amount to essentially do the repairs. So it's very open as far as that goes. I think very useful for homeowners out there. And I think it also will increase awareness of for many homeowners to take a look at their flood insurance, to take a look at their hazard insurance. What will it take to completely rebuild a property should there be a flood? And that unfortunately happens and it's necessary to get done. There are a couple of changes which we'd also like to suggest to the committee. One would be that it be identified when it's being opened at a bank or a credit union as a disaster savings account. We think that will make it much easier to track. The homeowner is responsible to reporting from a state tax perspective that they have these accounts, that they're using the money properly, but it will be easier, I think, and much clearer to have it identified when the homeowner opens it up as a disaster savings account. We're also suggesting that it be limited to one account per person. The language we saw, at least my understanding of that language, is you can open up as many accounts as you want. That could be confusing when you're talking about the tax deductions as you move forward, dealing with annual tax filings. And the last thing is we didn't really notice that insurance deductibles were covered under qualified expenses. So we would suggest that that be clearly a bright line test, that be included in the bill, because in many cases, flood insurance is very expensive, certainly, and certainly hazard insurance in some areas as well. So with that, I'll stop and be happy through you, Mr. Chair, to answer any questions that the committee may have.
Thanks, Tom. And thanks for bringing this concept forward. And I think, I'll share, my understanding that, this, it came about as a sort of brainchild of the administration of Governor Lamont's sort of request the industry and of the Connecticut bankers to kind of put our heads together after the flooding this past summer. And so I commend you for bringing this idea forward. I'll note, personally, I sat in a hearing in the Environment Committee yesterday, and the governor's bill there, which is sort of a comprehensive sort of flood insurance and flood sort of response and flood mitigation measure. And this is, I think, not in that bill, obviously, but is sort of part of that package and is part of that response, and is all coming from the same attempt to respond to the issue. So it's a great concept. You mentioned South Carolina as being the one of these concepts that's sort of the most fleshed out. I wonder what the utilization is. Do you have any information on that? What that utilization has been like? in South
We have
Carolina?
not found out as of yet, but we're going to look into that for the committee and certainly be happy to get back to you with those numbers.
Because my first sort of instinct on upon hearing this is, well, it's a great idea, but are people going to really use it? Are folks going to be in a position that they're going to want to plan? And the more you think about it, the more I think, yes. I mean, depending on your individual circumstances, where your property's located, this may be something that I think people would take advantage of, for saving for insurance deductibles, maybe saving up for, say a shoreline, property and some, mitigation, projects there that they might be able to anticipate. It would be worthwhile for folks to save up for that. So it's a good concept. And again, appreciate your bringing it forward and being here with us today.
Our pleasure.
Seeing no questions, I thank you.
Thank you.
Not yet, Tom.
Oh,
Did
your
he
hand,
leave? Okay.
Senator Miller.
Is he still there? Thank you. I couldn't get to my hand quick enough. I'm sorry, Tom. So, my research with this account, I didn't even know this type of product existed until you brought it to the committee. So does this work the same way as a health savings account as far as reporting is concerned?
It's really more akin to the 529 educational plan savings account with regards to that tax incentive that goes into it. And it also allows the ability for the income associated with it to build up and to compound as far as creating, additional dollars in the account.
So the banks will provide all of the necessary documentation to the depositor or the holder of their account when it came to reporting?
So yes, that happens every single year. You're going to get an annual report. I believe it's a 1098, which includes balances, the interest earned, but it would be up to the depositor to essentially report that on their taxes. So that would become part of your tax planning and reporting, dealing with your accountant or doing it yourself.
Okay, thank you. That's all I needed to ask, Mr. Chair. Thank you very much, Tom, for bringing this to the committee. And in light of what happened last summer, it is something that we definitely need. So thank you very much.
Thank you, Madam Chair.
Okay. Going once, going twice, seeing no further questions. Thank you, Tom.
Thank you.
All right, next on my list is George Reimer from InstaFunding LLC. Yep, he's joining us online. Welcome, George. You can proceed.
Thank you, and thank you to the chairman and the members of the committee. My name is George Reimer. I am in-house counsel for InstaFunding. We're an MCA lender. I'm speaking to you today to urge the adoption of Bill number 1093, allowing a borrower an emergent cash advance to waive the rights of notice and allow prejudgment remedies in cases where the amount in controversy exceeds $100,000. I'm speaking to you today because the PGR, prejudgment remedy, is necessary to allow MCA funders to do our work of providing fundings to companies that are in need. I understand the concept of the NCA has already been covered by the committee, and not to educate anybody, but I just want to touch briefly. What we do as an MCA is we purchase receivables. Companies have already performed their work. They have not collected their receivables at that time, and they need funds on a short-term basis. So we offer to purchase their receivables. We fund at the time of signing, which allows them to purchase additional inventory, expand, make their payroll, whatever that they feel in their good business judgment they need to do. In return, a percentage of their income is diverted to us as the MCA. I should point out that frequently the companies are not able to make their payments. So what we do is we engage in what's called a reconciliation. The customer has the opportunity to approach us, let us know that for whatever reason, their income is perhaps not equal to diverting the payments, and we would have the opportunity to recalculate that payment up or down. That's a feature of every MCA contract. That's not just my company. I'm mentioning this because there is some concern as to whether or not the borrower has the opportunity to realize that they need to address the issue. The impression was given that we simply rush in and without notice start seizing assets. That couldn't be further from the case. The MCA contract requires us to engage in a reconciliation process. So this is not a surprise of any sort to the borrower. If we are not able to engage in a prejudgment remedy, what could happen is we could simply have those assets, that is, those receivables, may dissipate during the course of the litigation, and we are simply left holding a meaningless paper judgment at the end. This has happened time and time again. This gives us the opportunity to mitigate our risk a little bit and provide some coverage for the MCA company that is taking a chance on these small businesses. Again, I want to mention business over and over again because this is a business-to-business transaction in every situation. Every company has the opportunity to review the contract, get consultation on the contract from legal counsel if necessary, and have an opportunity to consider it before they go into it. Even on the bill as it is written, smaller companies, those with receivables less than $100,000 to sell, will still have the protections, and they will not be subject to the prejudgment remedies. We heard testimony earlier about some concern of bad actors in the MCA space. I propose that without the prejudgment remedy, we are constraining legitimate companies that are performing an important function in the name of going after these bad actors. When defendants are aware that they cannot simply use the judicial process to stall and move their receivables out of reach, they have a stronger incentive to honor their contractual obligations and to engage in good faith settlement discussions. This statute provides, again, the security that an MCA company needs to provide this function in trying in some uncertain times. I thank you very much for your time and your attention.
Thank you, sir. Good timing. Where are you joining us today from?
I'm presently in Florida. You would not know it because there's no sunshine outside, but I'm in the Sunshine State.
Okay. And how much business do you do in Connecticut? And I should ask, is your interest in this bill related to borrowers in the state of Connecticut, or do you conduct business everywhere, but you use Connecticut as a venue for
It would
recovery?
be regarding both businesses in Connecticut and businesses out of the state.
Okay, but do you use Connecticut as your choice of venue in the cases that you need to recover?
We have sought out Connecticut as a venue for the protections that are provided by the statute. Yes.
Why is that? Talk about that a little bit more.
Again, the opportunity for the prejudgment remedy allows us to collect against receivables which may otherwise be collected and dissipated by the time we get to a time of judgment.
Okay, I think that's helpful for us to hear. Okay, seeing no further questions, I thank you for joining us today.
Thank you.
I'm here, Mr.
Oh,
Chair.
I'm sorry. Senator Miller, my co-chair.
Thank you. Just a quick question. So you said you do conduct business outside of Connecticut. What other states do you conduct business?
We also conduct business in the state of Florida, in the state of Texas, in the state of California, and other states through the U.S.
So California's threshold is $500,000?
I believe that to be correct. I do not have that number in front of me.
And so what do you do with cases? Because ours is $250,000. So if someone in California defaults, where do you seek judgment?
Our choice of forum venue in our contract is for Connecticut.
All right. Thank you very much for your testimony. Thank you, Mr. Chair.
Thank you.
All right. Thank you, Mr. Reimer. Okay, next, moving on. I have Adam Mizrahi on my list, and he is also online with us.
How are you? Could you hear me?
Yes, you're actually coming in a little loud, so.
Okay, is now better?
That's a little better. Thank you.
Okay.
Please proceed.
All right, so first I would like to thank the committee for giving us the opportunity to speak. My name is Adam Mizrahi. I'm the founder of Cucumber Capital. And really what I would like to do is shed some light on the fintech merchant cash advance industry from an MCA funder's perspective. I think it's very important. I'm not an attorney, I'm just a business owner. And it's important to know that our agenda is really aligned. We want this industry to be fair for merchants. But part of protecting the merchants is really allowing us to feel safe in this environment. There are three main benefits of this fintech product we can all agree on. First is one that anyone owns a business can really relate to this. Capital is on demand. With technology, we've cut the traditional heavy 3-month underwriting process down to same-day funding. It's a crucial timeline businesses depend on. The second benefit of this product is you pay only what you can afford. And this part is really revolutionary. Unlike fixed loans, we take a percentage of the revenue. If revenue drops, payments drops. If revenue is zero, payments are zero, making this the most flexible financial product in history. And the third benefit is the only event of default, and this is also a big one, the only event of default is fraud or bad act. In contrast to banks and traditional loans, trigger defaults and PJR waivers over a single missed payment. We don't. The only event of default is fraud, like hiding revenue in a secret bank account to avoid paying us. Now about the bill and for the concern about abusing the waiver, I have a few points to make. Number one, we're only requesting to use the PJR waivers on funding amounts over $100,000, which is basically around 15% of the deals circulating in our space. And it's the amount that would typically motivate bad actors to commit fraud. Number two, if we approve you for $100,000 in funding, you're typically a large business. You need to be making 7 figures. You need to be making anywhere between $5 to $10 million in revenue. We're talking large companies, not small ones. And again, it's only 15% of the deals circulating in this industry. Third, the very essence of this product really prevents abusing the waiver. And the reason is you can only use the waiver in an event of default. And an event of default is only in the case of fraud or bad act, not missed payments. And I think last, even with the waiver, a judge must confirm fraud or bad act in order to take the funds. So we're not taking funds. This is not a confession of judgment. It just holds the funds. So our percentage of revenue, which belongs to us that we purchased from you, doesn't get swapped to a different account. And we can't take it unless a judge confirms. So even though the nature of PGR may seem aggressive, if you take a closer look, you will see that our industry can only use it against fraud, not mispayments. Merchant cash advance has natural safeguards that prevent the PGR waiver from being abused. And to summarize, if banks and traditional loans can use PGR waivers with a much lower bar than merchant cash advance, which has nearly an impossible bar for an event of default, should absolutely be able to use them. But ironically, we're the only ones facing this restriction. So I think to summarize this, merchant cash advance is the most flexible financial product ever created. Fortune 500 companies are adapting it because business actually works. I might have to leave early because my wife is in pre-labor, so I apologize.
Oh, okay. Well, then I thank you for your patience, and I will let you go then. Where are you?
We're in Connecticut. We actually, I was listening to the questions to I think it was InstaFund who joined before me. We actually, the only commercial real estates that we own is in Connecticut, and Connecticut really came to mind in really like putting all of our businesses in Connecticut because of this PGI waiver. We started off in New York, and we're like, listen, Connecticut is the leading state, and that's where we want to be. I was even speaking to my wife, moving to Connecticut. Well, it's also more affordable with 8 kids, and you need 10 bedrooms.
Okay. All right. Well, yeah, come back. Come back. All right. Well, thank you and good luck.
Thank you. I appreciate your time.
Okay. Next on our list, Alice Jacobson, who's online. Welcome, Alice.
Thank you. So I'm Alice Jacobson. I am with Payroll.org. We are a nonprofit association representing payroll professionals. Today, technology exists that would allow employees to receive their earned wages at any time. Yet neither government entities nor employers are prepared to manage the administration of on-demand pay. Thus, financial technology tools on early pay are filling in the gap. Payroll professionals would like these technologies to be more visible to employers and employees and be regulated to prevent predatory practices. Currently, we're seeing about 60% of full-time employees reporting that they're stressed about their finances. Studies show that financial wellness and income are not directly linked, which means that difficulties can occur at any economic level. Financially stressed employees are nearly 5 times as likely to admit personal finance issues have been a distraction at work. Thus, it is no surprise that 74% of employees want employers to help them with financial wellness, and that employers are trying to accommodate employees to increase productivity and maintain talent. To stay competitive, employers are implementing financial wellness benefits that focus on the immediate money management concerns employees are facing. Employees are driving the market for earned wage access. For payroll management, the most important provision is the definition of EWA that distinguishes these benefits from payday and other loans. EWA benefits work best when employees can focus on financial wellness and not be encumbered with things like credit reporting or debt on their records. Payroll.org supports SB 1396, but asks Connecticut to think about these tools in the broader context of the labor market and pay systems. New technology should be regulated differently, not jerry-rigged into existing laws that did not consider the technology or employee situations now. Thank you so much for allowing me to speak to you today.
Thank you, Alice, for joining us. And I think you were with us last year as well on this topic. Is that
That
correct?
is correct.
Okay, good. And did you submit written testimony for us today?
I didn't. I will send that in afterwards.
Yeah, please do. That is helpful for us. Any questions for Alice? Once seeing none, thank you, Alice. Okay, moving on to Ryan Naples from Daily Pay. And welcome back, Ryan.
Thank you.
Also with us again.
Yes, exactly.
Good to see you.
You too. So, chairs Doucette and Miller, vice chair Santos and Honig, ranking members Delnicki and members of the Joint Committee on Banking. My name is Ryan Naples, and I am the vice president of public policy at Daily Pay. Thank you for the opportunity to testify today in strong support of Senate Bill 1396, an act concerning earned wage but unpaid wages or salary income advances. We're grateful for the leadership of this committee, as well as the Connecticut Department of Labor for working with us and other EWA providers over the last year. We want to thank everyone for their time and thoughtfulness. In fact, I would probably estimate it to be at probably over 100 hours of work, frankly. The legislative proposal put forth today represents a significant step forward, we think, that enhances the business climate of Connecticut while protecting the financial health of employees. By ensuring that Connecticut workers have the option to use EWA, this bill will protect them from drastically more expensive alternatives like interest on debt, interest on credit cards, or paying bills late, which have a long-term impact on credit health. Connecticut is a leader in consumer protection and has been thoughtful about the unintended consequences of policies that can harm citizens, and we're also aligned in those values. As most of you know, Daily Pay allows employees to access what they've already earned but have not yet received ahead of their company's scheduled payroll. In all other 49 states, the service is free of charge for those who can wait until the next business day for their accrued wages. For those who need an immediate transfer of funds, there is a one-time technology transfer fee of only $3.49. Again, that's in all other 49 states. This service is not alone. Employees using EWA cannot transfer more funds than they have already earned to date in the country to designate EWA as a loan without exceptions. When these policies changed, it became significantly more difficult for our users to access their wages in advance, eliminating the instant transfer to their bank account. Ending the ability for workers to instantly access these funds left many of our users with only more expensive financial options. Since the new rules went into effect, nearly 9 out of 10 Daily Pay users reported in an in-app survey to have accrued late fees, overdraft fees, and increased credit card interest charges as a result of taking EWA away, rather than instantly accessing liquidity for a $3 transaction fee. Former EWA users are now left with high-cost loans, bank overdraft fees for unclear checks, or a pawn loan with an average fee of about $150. To confirm this in-app survey that we did, and we currently have a survey in the field with UConn professor Carrie Racian, who is doing this now until March 9th is when the study is going to be complete. So you'll have more of an accurate assessment, not just from us about what the impact has been, even though it was 9 out of 10 who said they were paying for more, which actually, to be honest, is not surprising to us. Senate Bill 1396, we think, offers a significant financial lifeline to Connecticut employees, as well as offering an important utility to businesses in the state. We understand this legislation has several more steps in the process. We continue to partner in this work, and thank you for your time. I guess I did want to just say like 3 quick things that I'd heard earlier today. So in Maryland, there is no lending license required. Maryland in the summer of 2023 put out guidance that they did not act on. Instead, we've been actively discussing and negotiating with the state since that time over how best to regulate EWA. The Washington state legislation, the database legislation is not finalized. Those negotiations are ongoing, but frankly, that's not really the vehicle. That we've also been talking to Washington State for over a year about how best to regulate EWA. And then finally there is no state that has a database for a couple of very specific reasons. I mean, one, no EWA provider has social security numbers or even the last four. So that would be a number one requirement. The privacy issue would be serious. Second, this is not a free database, right? So this would be around $3 per transaction that has to be that would be assessed for each transaction that would be reported into the database. Third, in July of last year, we were in conversations with the Biden CFPB to do a research study into this specifically about whether or not this was actually a real issue, because we had not been told throughout the process of the 4-year regulatory process in California, this ever came up, right? In California, we submitted very detailed information every fiscal quarter. And to be honest, we continued to do that until February 15th when their regulations are now finalized. So during that time, it never came up. And so we're not opposed to solving problems. There needs to be data saying that there's actual problem. The fourth is really logistical. Daily Pay has very accurate time and attendance data. We pull data 4 times a day. For this database to really actually be able to predict how much someone has in wages and how much they've earned it needs to have it needs to be just as smart as Daily Pay and ADP's combined processes of pulling down real-time wage earning information. So really it's why this database doesn't exist anywhere else. It's because our products, especially on the B2B side, it is real-time information.
Okay.
Loans are much more, they are individual triggered events. It's why it might work for a loan, like a database for a loan, but not for our.
Okay. All right. Thank you.
Yeah,
Thank you. I let you go over your 3 minutes,
Thank you.
but I was going to actually ask that question anyway. About your experience with your thoughts on the database compared to the way other states.
Yeah, I think a way to
approached it.
Sorry, yes. So I think a way that we would be comfortable, I do think on the B2B side, for that reason I just explained, which is that our technology is constantly working with, it's not just ADP, it's smaller payroll providers, it's the individual payroll systems that companies make. So we essentially would have to then be sending that wage information for individuals to the database for then other companies to kind of do their calculations off of. But then, so it didn't make much sense, which is why when we were talking in the beginning of, I think maybe it was back in September or back in November or December with DOB, it didn't make much sense for this, for our industry. That's why it's not in the bill.
Yeah. No, I hear that. And you make a good point too, for employer integrated products like yours. You are actually collecting the data, or the payroll information rather. And so I take your point that you are getting that information already as part of the process in extending those advances. So, but again, for the direct to consumer realm, that's not the case. So, I do take the point, and I appreciate you being part of this process as well. You're among a small handful of people that's been coming back here, engaged in the discussion and offering constructive feedback and comments. So we do appreciate that.
Yeah.
Questions.
Can I make one more comment? So
sure.
The other thing too is, another problem with the database is also just related to the information in a vacuum and how what else are the alternatives are really important for any sort of analysis of EWA. And so I think that's another piece that it's partly why it's not just us doing this in-app survey about what the impact has been. It's why we're using UConn also to now do the same thing, which is, if we were to go away, if there was a cutoff at, say, whatever it is, which is what the database is used for, all the other alternatives, they are not free, or $3 or 50 cents or $4, whatever the instant transfer fee is. So that's another complicating factor of what the unintended negative consequences of a database, which is just, it could kind of cut off access and lead people to more expensive options. If that makes sense. Yeah.
Rep. Delnicki.
Thank you, Mr. Chair. And I want to go back to this, the database comment you made. So if an individual was using an employer-based EWA, there would be no contact with the database per se in your scenario there. And if they went to a non-employer sponsored EWA, there would be transactions in more than one EWA. And I think the database is there to kind of prevent that or kind of act as a traffic cop. So how's that going to work if there is no database?
Right. So already in our terms and conditions there, everyone has to agree to not be using any other EWA product. So that's already something we would feel comfortable like having in the bill that there. I do also think that the speed at which the data is provided is also going to be really important. So the way that our system works is that it's, you know, it is instant. So the database would have to be just as instant as our platforms are currently in order for the database to like serve its purpose. I also think like part of the payroll and time and attendance process of pulling information, you know, we do it 4 times a day. There would have to be like a set number of times that a database would have to have information pulled from it for these calculations as well. I think that for these products to work the way people expect them, this would have to be like a state-of-the-art, never before created database that works instantaneously, especially based on kind of like the need that exists that, you know, is not being met right now. So it's not to say that I don't think there isn't a need for it. I think that like we just don't know if there's a need for it, and all of our research so far has showed that this isn't a large problem that is overwhelming people or getting people over leveraged. I think like research would be needed before we would feel like comfortable having to like kind of create this this very state-of-the-art database. It's not something that we would oppose. We would just want to really make sure that it's a real problem.
And did I hear you correctly that there aren't any databases currently in use?
Correct.
For
So
any
there
of
are
the
12.
EWAs?
Right. There are 12 payday loan. There are 12 states that allow for payday lending, and they have payday loan databases.
Okay.
There's no state where. So the closest that, you know, there are laws right now. There's 5 laws, 1 regulation where annual reporting is required to a regulator about like the number of transactions. One piece of the one data point required universally is about whether or not like the number of people who have been over leveraged in their paycheck. And that's there because California had been asking for that since we all signed MOUs with them back in 2020. So in California, we've been providing that information. But that's probably the closest, that sort of reporting is the closest that we have to any sort of database, to be honest. There's no active database.
So then your statement is there are no real databases.
Oh, yeah,
out
yeah,
there.
for sure. There's 0, yeah.
So there aren't any.
There are no databases that EWA products
Okay.
report into.
Thank
Yeah.
you, Mr. Chair.
Yeah.
So I have to say, I was happy to see that we moved away from APR because I was like fundamentally flummoxed about how to apply APR to a product that didn't have like the same loan duration. So I was happy. I thought this was going to get us to a place where a compromise was more viable.
Mhm.
And I'm hearing you say that because of the database, it's just that component that's the problem. Are we cool with the fee caps?
Yes. So the database idea is not in the bill. for all of these reasons that make, you know, make it really difficult to kind of fit our product into a database, like really at this time. I do think that like in times when this has come up in other places where they have payday loan databases, and with the Biden CFPB, we talked about doing research to determine whether or not this is really an issue in order to determine like how to scope a database that could be that had to be this nimble and this smart, but also would have to protect people's, you know, no EWA company asks for social security numbers either. So like that's like another big piece of this. Like, would we, you know, making an industry start to ask for that level of information? Like, we've got to make sure that it's like a really good.
But so just for clarifying, so otherwise you support the legislation as
Yes.
it's drafted?
Oh yeah,
Okay,
yes, it's been, yes, for sure.
okay.
Mhm.
Because that's, I think, an important lead, right? Is, so this is a compromise that's viable. It maintains economic viability. It sounds, I mean, when I read the tenor, I didn't see in person the Department of Banking's testimony, but when I read their testimony, it seems like there's consensus here, which is promising.
I think there's some companies that don't maybe, you know, have as much of a rosy picture, right, of every single provision. I think there's maybe one provision where related to like the unfreezing of like freezing and unfreezing of someone's account, which is like because we don't have recourse. Like that's there's one provision that prevents us from doing that, from freezing someone's account and then allowing them to be unfrozen later. But there's like, that's like a very small technical thing. Otherwise, no, we support the bill.
Okay.
Yeah.
I appreciate it. And so, I mean, looking through this test, you know, your testimony and thinking about the conversations that we were having previously, which seems like we're at a much closer starting point than we were previously. Are there any other considerations that you think would offer the same protection of the database without using the database concept? Is there another way to get towards the Department of Banking's goal that you would suggest?
I'd have to think about it. I think you know, there are a number of other a number of other ideas that we also offer to the Department of Banking related, like when we were having this conversation, like notice after 4 times that someone's used the EWA 4 times, and that there's, you know, a checkbox that someone has to click to acknowledge that they've used it 4 times, or a calculation of the number of fees that they've paid, or the amount of fees they paid, a calculation of the amount that someone's already accessed in relation to their paycheck, so they'd be able to not have to do the math themselves. So to us, that feels like maybe a more like workable alternative than like creating this, like it would be a pretty complicated database, which is why I think wisely it's not in this legislation.
It seems like there's a suggestion from a substitute language that was linked in the Department of Banking's of a database, but it looks like it might be state run. So would that achieve the same goal and not require a third-party database if it was a state-run database?
I think I guess it would depend on what the purpose of the database is. If the information that's sent into the database is to assess how much in wages someone, you know, has earned and has already accessed, I think for the B2B providers, it'll just be outdated the second we submit data into it, because we continue to track in real time, which is why I think a database is a bit of a is not an analogous, you know, so like it's why it doesn't really work for EWA providers, just because of the fact that the information is not going to be updated you know, once we submit it. Like the very next minute the database information is out of date, unless it's like literally our system.
One of the things that the Washington example uses is their database. The database indexes the EWA companies and whether or not they're consistent with their equivalent legislation. And that seems like something that perhaps the Department of Banking could do. And that would identify the good, bad actor sort of situation.
Yeah.
And certainly could say, here are the places that we know are consistent and operating within our framework. And here are the ones that are operating outside of the framework and have complaints that are like operating inconsistently with the statute. The third party part sort of flummoxes me a little bit because I don't think that like it looks like the director of the Department of Banking is administering it in Washington. So, but it still says third party. So I think that might be about the electronic company that's managing the data set. But I'm interested in seeing what the data comes out to look like when, because you've submitted for a third party independent analysis of your data. So I'll be curious to see that data when it's completed.
Yeah. And I should mention in Washington State that that legislation is still under consideration and almost certain to die. So the main vehicle that everyone was working on was in the House, which is dead, and the Senate bill is just kind of hanging out there. The concept of, I do think there is a lot of talk about this database here, which was probably like a little bit unexpected, but I do actually really truthfully believe that like step one is to determining like what actually is the problem, right? And if this is actually a problem, and just by assuming that there could be a problem, isn't really enough for all the other things that would have to come after in order for a database to make sense for an EWA industry as it stands. Just in terms of like the amount of information, the amount of times the information would have to be submitted, the amount of times information would have to be pulled from there. So I do think step one is really getting like data to figure out, is this really happening, right? And then I do think step two is, okay, if it is really happening, what is the solution? How nimble does this database have to be? If it has to be tied into our own systems, it's you know, I think that's very complicated for these companies like ours that are extremely competitive, innovating constantly, and really, you know, cautious about who gets our technology. So I do think like we would be open to both of those conversations. Like if this bill said you have to do research with DOB about like how many people are overextending their paycheck based on multiple EWA providers, I think that makes sense. I think jumping in and saying a database, which is the first in the nation, would be really expensive and convoluted. Yeah.
I was just going to ask, how about a cap on the total amount that you can offer? Is that something that you'd be comfortable with? Because that's another Department of Banking recommendation, is to cap the amount, an upper limit of what you can disperse. So $1,000 max. Is that something that your company would be comfortable with? And then it would apply to the loan APR calculation if it exceeded $1,000 or $5,000.
Right. I think part of that is a high number, right? $1,000 in a payroll period is a high number. I do think that part of the reason why there is no limit being considered like that here or elsewhere, and there is no limit obviously like anywhere else in the country, is because we know that once someone needs access to liquidity over whatever amount is set, the access to liquidity is very rarely structured in the way that EWA products are structured. So if there was someone who needed to access between $1,001 and $1,100, that's likely not going to be at a rate of either $0 for next day ACH or $3.25. Most likely it's going to be the minimum of $30 to $100. I could get back to you though on like what that dollar amount could be, because yes, I think that $1,000 is a high amount for our industry. But yeah, if that makes sense though.
Thank you.
Thank you. Senator Miller's hand is up earlier, but
No, Representative, she had asked my question. Thank you.
perfect. Okay, thank you. Okay, Ryan, thank you for joining us today. Next, we have James DeLises. Is he with us? James DeLises. Going once, going twice. No. Okay. I'm gonna skip James. After James is Jared Alphen. Hassett and George. Welcome, Jared.
Hello.
Dear Chairwoman Miller, Chairman Doucette, ranking members Berthel and Delnicki, and distinguished members of the Bank Committee. My name is Jared Alphen. I'm an attorney at Hassett and George in Simsbury, Connecticut. And I just want to thank you for the opportunity to testify today in support of Senate Bill 1093. First, I just want to address the infamous Bloomberg article that came out relating to the PJRs in Connecticut. I think the article put the industry, myself, and I think the PJR in a very negative light and an uncertain light. I'm an attorney. I pride myself on practicing law properly within the law. And this article seemed to have been written in a manner that suggested that there was something nefarious or improper being done in Connecticut, which it wasn't. This PJR statute's been around since the 70s, early 80s. And this remedy protects lenders. It protects other creditors. It's a unique statute in Connecticut, and it should be proud of this to have this type of statute. And it's a state that provides creditors with protections. The PJR exists in promissory notes, commercial leases, and other types of businesses where there's credit that's being extended. This particular bill that we're dealing with just simply seems to cherry pick out the MCA industry because of a couple bad apples, which is really what I took from the Bloomberg article, and what I took as to why the 2023 amendment was made. If you look at the PJR in general, this is to protect the lenders. It doesn't make sense to have a situation where a bank that lends money to the same small business has more protections and can use the PJR, but a merchant cash advance funder that gives the same business the same amount of money is not going to have the same protections and has less protections. So I think we need to think about that in terms of the slippery slope that we go down, where we're identifying a single particular industry that we're going to target that says you can't use it while other industries are free to use it. And I also just want to briefly talk about, I think you've heard from others, other MCA funders here. The only way that the MCAs are filing suits is when there's a default, and the default is not missing a payment. It's very important that the banking committee understands that. It's when the merchant that gets the money commits some type of fraud and doesn't follow the agreement. The agreement requires that there's a reconciliation, which in certain sense, you have a landscaping company that can't make their payroll and they're not able to support the funding that they have. So they go to these companies and they get funding. If their payroll, if their receivables drop, then the MCA company works with the funder to say, okay, well, what are they now? Let's adjust the payment. Let's let you work through this. That's the benefit. That's why this isn't a loan. This isn't you miss a payment and we're freezing bank accounts. That's not it. And I think the misconception is that just because there's a default doesn't mean there's a freeze the next day. And I really do believe that misconception was really in the Bloomberg article. There is an absolute relationship and a benefit between the merchant cash advance company and the merchant working together and working so that if there is a shortfall in the business, they help them. And that's the whole purpose. That's why these things are so beneficial. You can't get a bank loan as fast as you can get a cash advance. The bank processes take a lot longer. So I want to say that I candidly support and applaud the banking committee for the regulations they put in, because I think overall what you did was phenomenal. And overall, I think that having the requirements for the filing and having certain disclosures put in place, all of that helped the business, which candidly I'm in favor of. I'm all about disclosure. I'm all about transparency. I think that's vital. Okay, thank you. Your time's elapsed. Thank you for joining us. You mentioned the infamous Bloomberg article. I don't know if it's infamous, but a few of us read it. And I think you were one of the attorneys that was interviewed for that article, correct? Correct. And so to my earlier question of the other folks from the industry who spoke, you represent clients who are outside of the state of Connecticut, but your contracts choose Connecticut for the choice of law and choice of venue. Is that correct? Not technically correct. They're actually Connecticut entities. Some of them are foreign entities that are registered in Connecticut. They're conducting business and extending credit. And you don't want to call it credit, but we're not going to go there. Yeah. Outside of the state of Connecticut, correct? To borrowers outside of the state of Connecticut. Yes, there are companies that are registered in Connecticut or their place of business, and they're registered in Connecticut, and they're extending credit, or at least I should say, there's advancing money to companies and businesses that are either in or I should say all over the United States. It's not just one particular state.
Do those
So
companies have offices and employees in Connecticut?
to my knowledge, they have offices in Connecticut, and I believe they're registered in
Okay, I
Connecticut.
mean,
And they have registered their businesses with that, actually have, because you have to, when you register an LLC in Connecticut or a corporation, you have to have a place of
Sure,
business in.
sure.
You have to have a registered agent in
I
Connecticut.
get your point.
Yeah.
It's a little disingenuous to go down that road, but we'll leave it there. You mentioned that, and a previous speaker mentioned that a default only occurs in the case of fraud. Is that correct?
No, I think the case, it's not necessarily fraud. I don't know. There could be situations of fraud, but I think the default really enters when the merchant doesn't trigger the reconciliation provision by saying, my receivables have dropped. Here's proof to show. And the funder, the merchant just doesn't answer the phone, doesn't pick up anymore, doesn't go through that reconciliation process, which is critical to the whole relationship, or just blocks payments and goes off the face of the earth and runs.
Right. Well, because they could be having trouble with their business, correct? Because they got themselves overextended with this product and they're having troubles elsewhere. So another vendor, distributor, or their payroll, like you said, they're having a hard time making ends meet. So that's why they get into this anyway. But they could be, not paying. And I say this actually because I don't know if you've heard prior testimony. I had a client in my law practice who had a very successful number of restaurants who got themselves into trouble with this because bills started piling up, more advances kept coming in, and then whoops, they had this bill from their food distributor that they were just avoiding for many months, and then whoops, that person sues them. Now they're, they forced to basically close their doors because they got themselves overextended in this. So that's a default situation. That's not a fraud, right? I mean,
No.
you said that it basically just for fraud, and the previous speaker said, oh, it's the only time. There's no such thing as a default. There's no such thing as, we work with our lenders. So, I mean, there are situations obviously where you wouldn't be here if there weren't situations where you didn't have to recover and to pursue collection activities, correct?
Yeah, but I want to be, just so I'm clear to answer your question, Mr. Zett, the situation that I'm talking about is when someone gets, you said, overextended. The beauty of the merchant cash advance agreement is that if their receivables aren't there to make the payment, they have the right to adjust the payment. If they're not making any money, their payment's zero. So that there isn't a situation where the merchant cash advance company goes and freezes their account. The whole purpose behind it is for the company, the restaurant to say to the merchant cash advance company, we're having trouble right now. We don't have no money. We need help. So we can't pay you. Here are our receivables to show you that.
Right.
Okay, that I see you're having trouble. You don't have to pay us because your receivables don't support it. So the merchant cash advance company works with that particular company, doesn't go in and.
But then beyond that, there are cases obviously where you pursue collection activities against the borrowers.
If there's a default under the agreement,
including
yes.
an execution.
If there's a judgment and if we file suit because there is a default, we have to back up. If there is a default because they don't reconcile, they block payments, they go silent, they don't cooperate and talk to the merchant cash advance company. What's the merchant cash advance supposed to do? Just sit there and say, okay, they're ignoring us. They have all our money. We're going to do nothing. Of course not. They violated the agreement. So of course the merchant cash company is going to file suit when they dishonor the agreement. No different than when Bank of America finds out you're not paying the loan. Of course they're going to sue you.
Right.
But this is a situation that's very different.
Of course, but again, that was my point in asking the question.
Yeah,
because I feel like there was a contention earlier that, we don't really pursue our borrowers. We work with all of our borrowers. But the whole point in us having this conversation today is because of the execution process and the PJR waiver.
Because when the merchant doesn't pay and they don't then communicate, and they have the right to communicate but decide not to, which is a bad act under the agreement, and then they decide to block their phone number and go off the face of the earth and disappear, that's a problem. Otherwise, our client would never file suit as long as they're in communication saying, hey, I have no money this week, I can't pay you. Our client's like,
and
sure,
that's
no
why
problem.
and that's why the courts are open, right? And that's why creditors can pursue their debtors in those default cases.
Yeah, and
but that's notwithstanding, that doesn't necessarily necessitate the use of the PJR, which brings me to my second question. You said, that we're unfairly sort of targeting or punishing the MCA industry. But it seems to me that there's something fundamentally different about this product. And again, the evolution of fintech products generally under the broad umbrella of fintechs is such that, a product like this can exist outside of the traditional brick and mortar bank making a loan to its, neighboring Main Street business. In those cases, not only is the bank, subject to all kinds of regulation that the MCA industry is not subject to, but they're doing a whole level of different underwriting, and I would submit a higher level of underwriting than the MCA company is doing in extending credit to its borrowers. So again, am I wrong? It seems like it's a little bit of not quite an apples to apples comparison.
Well, I would say that the banks, for whatever type of underwriting they do for their purposes. A merchant cash advance is different. It's a faster, advance. There's is it 30? There's no 30-day, 60-day due diligence periods that banks may do. But also, you're not talking about the same people. The people that go to the banks are not the same. Those people, the people that are dealing with the MCA, they're not bankable. They're not able to go to a bank. They can't go to a bank.
Right.
They can't get money that fast. They
Right.
need that. That's why this product exists, is because the banks would turn all of those people away, and those people
Right.
would be on the street and they wouldn't be able to make money. The
Right.
MCA people provide them with an ability to run a business, and they
Right.
don't just say, we're going to go to court and sue you when you miss a payment. We're going to work with you. The
Okay.
banks come in and they give you a loan. You don't pay it. What happens?
Right.
Immediately, they're going right to the bank
Right.
to freeze your bank account.
So here's my question. It gets to
Yeah.
the heart of the matter then.
Yeah.
Why should those people have to play by the same rules as the bank in terms of the application of the PJR? The PJR waiver exists for sophisticated commercial entities entering into a transaction. You just said to me, which again is the whole point in my whole understanding of the industry, that this product is used by smaller, less sophisticated consumers who are unbankable in many respects and are not going to be going to the bank to get that loan.
No.
So why should those people have to also be subject to these commercial PJR waivers, which were devised for sophisticated commercial entities?
Because they're not the people that are not able to go to the banks are not necessarily unsophisticated. A lot of these companies are sophisticated, particularly the ones we talk about, this $100,000 threshold. The people, the type of companies that can get that kind of money are sophisticated, and for the most part, the merchants are sophisticated. They are just not bankable, because what happens is maybe they lost their house in foreclosure. Maybe they had business hasn't been around for long enough for a bank to say, yeah, we'll take you. There's a lot of different variables out there that differentiate that. But they come to the banks, they come to the MCA companies because of the time in which they can get the funds. And they're not unsophisticated for the most part, particularly at the threshold of $100,000 plus that we're talking about. Now, we're not talking about the nail salon or the bakery on the corner of the coffee shop. We're not talking about the small restaurant. We're not talking about those types of small companies. We're talking about companies that are able to support $100,000+ advance. That's not an insignificant, unsophisticated type of company. That's a company that has resources. And I think that the sort of compromise, so to speak, at the $100,000 level is going to solve the problem where you're saying that the small mom and pops are unsophisticated. That's the case, and you feel that way. And I understand your perspective. Believe me, those people will be protected by this statute because it will not allow the attachment of those smaller companies. But the companies that are able to get $100,000+, and you'll hear from other funders, they'll say, what does it take to get to $100,000 in advance? I can tell you it's not making $5,000 a month. I think that there is a difference, and the companies that are at the level of $100,000+ advances are not the same types of people that you're dealing with. And I think that the compromise of that $100,000 is a fair number. And I think it's going to allow, you'll see it'll allow MCA companies to give out and be more flexible and give out more money to people, companies that need it. And the bad actors of the industry, there's bad actors in every industry. But at the end of the day, those bad actors, they violate rules, they don't comply with us, they get punished, and they should be punished. And so, you know, I know they say it's a few apples spoil the bunch. It shouldn't, those few apples shouldn't spoil the bunch here. And there are a lot of good companies out there, and you'll hear from them today. You've heard from some today that are doing the right things. And those companies shouldn't be put behind the 8 ball because of a couple bad apples. And those, like I said, there's a lot of requirements that you have put into place, which I think are great. The banking registration, the disclosures, all those things are very helpful. And again, I personally applaud you because I think that this industry can be great. It should be regulated more, but not to take away a remedy. And we're talking about a remedy. We're not talking about anything else. And I think, you know, I think at the end of the day, I think you did a very nice job with the disclosures and everything. And I think
Thank
that's
you.
going to help.
I appreciate that. And
Yeah.
maybe, you know, we can revisit that at some point too and look at APR again. I think that would be
And I'd be all
great
I'd
thing
be
to
all
do
for the
personally.
all for the transparency. I just want you to.
Senator
seriously.
Miller online has a question.
Yes.
Thank you. A comment first, just to piggyback on what you were saying, Representative Doucette, that I don't think that when this bill, because you did mention that the law's been around for a very long time, and I don't think that the policymakers at that time anticipated the fintech, that they were anticipating brick and mortar. And also, I don't think that they were expecting other states, individuals from other states to come to this state to remedy their situations in the states where they have their borrower had defaulted or committed fraud on their loan. So I think that we have to evolve as industries evolve in our laws. And that's what we do as policymakers. Question. Has your business been impacted by the change of the law, which was effective July 1st, 2024?
What do you mean, my business?
So I'm sorry, I thought that you represented represented companies that wanted to come to Connecticut to pursue legal remedy against the individuals that either committed fraud or defaulted on their loan. So maybe I misunderstood.
No, we still are representing various clients in the merchant cash advance space. And we're still, you know, when there is a need to file suit, we're filing suit. But we're still, you know, representing them as we were.
Okay, so but your business hasn't been impacted by the change in the law, the threshold to 250 $250,000?
I would tell you, I think there's less, I would say, lawsuits being filed. At least I can speak. I'd say there's less lawsuits being filed based upon the change. But I'd also tell you that my clients, and you may hear from some, are going to tell you that they've sort of pulled back from giving out business advances to certain businesses that they otherwise would because of the $250,000 threshold, which has caused them to not give out money to people that need it, and that they, you know, sort of drawn back and tightened up with their belts. So, if I didn't answer your question, I'm sorry.
So, and my last question, Mr. Chair, and this is going to be a question that I ask everyone who's testifying in support of this bill, is that do you have clients that do business in the state of California where the threshold is $500,000?
I don't represent anybody in California, so, and I'm not involved in those day-to-day types of, I'm not in-house counsel where I see that, so I can't tell you who, but if my client do that, it's because I'm not aware that they're in California doing that, but
No, not that not that your clients are in California. The persons that they are filing suit against resides in California, have a business in California.
Oh, so you're asking, it's just so I'm clear, you're asking whether I represent a client in Connecticut who sues somebody in California. Is that what you're asking me?
Exactly, sir.
I'm sure we have situations where we've sued people in California.
Okay, and so why would they pursue California? Why would they come to Connecticut to pursue remedy?
So the company's based in Connecticut, the company that I would represent, I believe is some circumstances, for the most part, they're all registered. They're Connecticut companies, and they file suit in Connecticut because they're Connecticut entities. And obviously because of the PJR. That's why, you know, they're here. They use that as a remedy to eliminate the risk in some of these larger deals that they do.
Okay, so Mr. Chair, maybe we should look at where companies are headquartered when we look at this bill again. Thank you, sir, for testifying today.
I would
Appreciate it.
say, Madam Chair, I would say that the companies should not be filing suit in Connecticut and using the PGR statute if they're not registered and they're not Connecticut LLCs or Connecticut corporations.
Okay.
That would be, to me, I wouldn't take that, you know, they need to be registered properly. And again, LLCs and corporations exist independent of people. They're operated by people, but they are separate and distinct entities, which be understood.
So, just one last comment. This bill is a far cry. The new law, the current law is a far cry from what we initially put forward. And my co-chair and I thought that this was a great compromise with the $250,000 limit for both the industry as well as the merchant. And so I appreciate you testifying today. But my goal is to make sure that the individuals who are desperate to make sure that their business continues and to make sure that it remains solvent is protected in these deals. Because I'm learning as a chair on the banking committees that there are certain industries that are taking advantage of people's desperations. And I think that that's our job as a committee, is to also protect, not only allow businesses here in this state to operate in this state and protect banking, financial institutions, fintechs, if you may, but it's also to protect the consumers of this state. And with this law, although an individual may live in another state, if the legal remedy is in this state, it's our job to protect them as well. So I really do appreciate you coming before us today to testify. Thank you, Mr. Chair.
And I would just say that I agree with you, and we should be protecting them. And the $100,000 threshold, I believe, is a fair compromise, and I believe it will accomplish the goal that you're looking for. And I do believe that will solve the problems that you're concerned with, and that you'll see a difference.
All right, thank you. Appreciate you testifying today.
Thank you for having me.
Thank you.
Thank
Yep,
you.
seeing no further questions. Thank you, Jared. Next on the list is Harry Jackson, who's online with us. Harry, are you there?
Hi, I feel like I'm in the wrong meeting. Actually, I was here to get some answers and some clarity on the advanced earning wages access. Is this the
No,
right
you
meeting?
are in the right place. We just have a number of different bills on our agenda. So you are in the right place and the right time. Thanks for being patient with us, and you can proceed.
Okay. I've been a user of, I'll mention the company Earnin. That's the advanced app I have used since April of 2023. I feel like out of all the products that I have used, between cash advances, regular loans, they are the best. I was surprised that we were limited with that, because I understand that, well, I don't understand why they felt the need to temporarily stop that, because compared to predatory lenders that I have chosen to use before, this is the best option as far as no specific fees, no mandatory subscriptions. If I want to contribute any dollar amount at that time, that's an option. It's not a mandatory predatory situation. There are limits as far as the amounts. So it's not like I can, I've heard somebody mention about being able to take multiple advances from one company to another. So obviously I used one at a time. I mean, I've been on both ends. I've been a good consumer and I've been a bad consumer, but at least I feel like I should be, allowed the freedom of which vendor I choose to use. And the limits that they have in place, they don't even allow me to put myself in a bad situation, considering that they're short-term, small amounts from one paycheck to another. So I feel with that regard that we should be allowed to have it, take advantage of that specific product because I don't see any drawbacks to using the product. That's all my 2 cents.
Okay, thank you, Harry. Appreciate your testimony. A question for you. Are you still using EarnIn? Because my understanding is that EarnIn has suspended or scaled back.
Correct. It is still currently suspended, so I couldn't use it even if I wanted to.
Okay, so what have you been doing in the meantime? Are there other apps or places that you've been able to
There is only
get the same
one.
sort of advance?
There is only one other app, Clover, that still allows, but that has limitations as far as how you use it. I don't use specifically large money amounts for that particular app, but between Earnin and another one that used to be used, Money Lion, they had similar products. However, the advantage of using the Money Lion, I was able to gain a larger amount all at once versus earning. You're limited to literally $100 per transaction limit that you would have to wait on a daily basis. So, you know, like I said, different products, different advantages, but at least I had the freedom of choosing which one I wanted to use depending on the situation. Sometimes it was emergency situations, sometimes it was just a leisure option while I was seeking out the funds.
Okay. And when you used EarnIn, did you ever leave a tip?
Sometimes I did, sometimes I didn't.
About how much when you did?
Um, between $4, $8. Sometimes, like I said, sometimes it would be zero.
Okay. All right. Okay. That's all I have. Any further questions? Seeing none. Thanks, Harry. Thanks for your patience with us today, and thanks for joining us. Appreciate your
Thank
testimony.
you.
Okay. Bruce Adams. Welcome, Bruce. Welcome back. Welcome, as always, to the Banking Committee.
Thank you, Representative. It's good to be back. And a warm welcome to Representative Gajewski. Welcome to the Banking Committee. The water's warm. Senator Miller, Representative Doucette, Senator Berthel, Representative Delnicki, and to all the esteemed members of the Banking Committee. My name is Bruce Adams, and I'm testifying today in support of House Bill 7083. And I would like to sort of begin and thematically characterize my testimony today as being about the uniqueness of the credit union business model as a cooperative institution. While credit unions look a lot like a bank and the consumer has a very seamless experience between one and the other, the uniqueness of credit unions are what led to the initiation of a number of the provisions of 7083. Credit unions adhere to 7 cooperative principles, and among them are that the members of the credit union get to participate economically in the operations of that credit union, of that cooperative. So that means that as a profit is made, those profits are given back to the members of the credit union and sort of redistributed within the membership. And another principle is democratic member control. It's really important that the members of a cooperative elect from the membership their governing board. So we don't have a distracted set of investors or shareholders controlling the operations and diverting profits or cutting costs, let's say, or services against the interest of the member themselves. And so 7083 contains a basket of provisions, not all of which were initiated by the Credit Union League, that line up with the cooperative principle of democratic member control. So where you have, for instance, in employee discounts for one, for preferential loans, the membership, the board, excuse me, the membership of the board has an interest of retaining talent and recognizes the benefit of having a uniform policy apply to all employees. There is a provision in that particular section that would allow the board to give itself its members an additional discount, and we are in talks with the Department of Banking and our industry partners to craft mutually acceptable language. And I want to thank the department for raising these concerns and for agreeing to work with us on them. With respect to charitable giving, again, the idea is that when management can make more decisions more quickly and more efficiently, it can get back to the business of being the best credit union it can be. I thank the committee for its time, and we'll take any questions.
Thank you, Bruce. I wanted to give you an opportunity to respond to the brief testimony of the department on section 6 in opposition to section 6 and 7 of the bill. 6 having to do with the charitable donations threshold. And do you think that there's some place we can compromise potentially on that? And then 7 about the insider loans and their concerns about that.
Yeah, thank you, Representative. With respect to section 6 and the charitable giving provision, the thing that we're concerned about is not having it be bound by a certain dollar amount, because then that will just bring, invite more amendments to legislation. So wherever the threshold is properly set, we're happy to have something that would rise and fall or would, with the economy or just be determinable at any time. Certainly no one would complain about Bank of America management giving $1 million charitable donation. But maybe so for American Eagle. So wherever the percentage is should be set by statute. And I do recognize that the draft as currently written would allow management to make a series of gifts up to that threshold. And so we are more than open to providing some sort of a cap, an aggregate cap in any given time period. I mean, anything that would be acceptable to the department, we're happy to work with them on that. With respect to section 7, I think it's important to highlight the key sticking point in section 7, which is that the board can establish a policy which would give an extra preferential discount to insiders and senior management. And I think this is really an opportunity to highlight the fact that boards of directors of credit unions do not receive payment. They're volunteer. Recruiting and retaining that talent is really difficult. And while this provision may be, sort of offensive, I've read the banker's testimony. I respect that there could be, some other issues with providing an extra benefit to board members. But I think this conversation needs to be begun as a way of helping credit unions recruit and retain competent talent in their boards so that they may more effectively run their credit unions and serve their communities the best way they can.
Okay, thank you. Representative Bolinski.
Good to see you, Bruce. How are you feeling?
Thank you for asking. Representative, I'm here, and that's a good thing.
And I'm glad you are. You said something, and I have to apologize. I missed the front end of your testimony, but you said something that struck a chord with me when you talked about retaining talent. For whatever it's worth, for 18 years, I was a volunteer board member at the Metropolitan District Employees Credit Union. And I want to say for about 4 or 5 of those years, I was a vice president of the credit union. And never once did I get a paycheck, nor did I expect it. And when you touched on that issue about retaining good people that in many cases are volunteers that take their time for no monetary purpose other than to help their fellow employee, their fellow member, to help grow the credit union. I have to say that makes all the sense in the world what you said. And I just wanted to validate that for anyone that might question whether that really is the case, because it is. I can attest to that for the years that I volunteered on the board and never got any monetary reimbursement whatsoever. Maybe a grinder for dinner, but that would be it. So I just wanted to touch on that.
Well, thank you. And if I can respond briefly, I do think, credit unions need to be very careful about their unique business model. They are tax exempt for a reason. As a cooperative business, they should be viewed very differently from a traditional bank. But at the end of the day, as a safety and soundness measure, you want the best people running the institution as possible. And so there should be some ways for Connecticut credit unions to be able to incent their members, their individual members, to stand up and agree to serve. And I don't know how we do that in a capitalist economy without giving them some sort of pecuniary benefit.
Oh, we've got to figure that one out. Thank you for your testimony. I'm glad to see you here, and thank you, Mr. Chair.
Thank you, Reb. Senator Miller online.
Thank you, Mr. Chair, and hello, Bruce. Thank you for joining us today.
Thank you, Senator.
Bruce, in your testimony, you said that that the Bill 7083 expands access to capital for community development financial institutions. Can you expound on that?
I can, and in a few people behind me, Kathy Chartier is testifying. She's the CEO of Members Credit Union, and she will speak more deeply on that particular provision. But suffice it to say that a community development financial institution, a CDFI, receives that certification because it does extra lending into underserved and vulnerable populations. And so it's expanding access. Sorry, let me back up. Allowing them to have a greater access to capital means that they will have a greater ability to lend into those underserved and vulnerable populations. I mean, credit unions are by their essence service organizations, and they exist because the traditional banking system overlooked the underserved. And so when a credit union goes the extra step of obtaining a CDFI certification, it means it's going the extra mile beyond the 100 miles that every credit union already does. And and this was a Department of Banking provision that made it into this bill, and we support it as well.
All right, thank you for that. So Bruce, do you know how many of your members have that certification?
There are 3.
So there are three members?
Yes.
Do you know where they are? Where they're located? What cities?
Yes. I mean, you're putting me on the spot a little bit, but I mean, they've got branches and presences relatively east to west across the state.
Okay. So then let me rephrase that. Do you know how many communities? And if you don't, if you can get that back to me, how many communities they serve? So there are 3 that have the certification. I would like to know how many communities do they serve?
I'd be happy to provide you with some documentary information about their lending activity into those populations and in which communities.
All right. Thank you very much, Bruce, for joining us today and your responses to my questions.
Okay. Thank you, Bruce. No further questions, I don't believe. So appreciate you being with us today. I believe, are we going to skip back? Do we have
someone online who we skipped over? Okay. Number 11 on our list was James Delises. Well, I think, I don't see him, but is he, okay, so we'll skip him again, but okay, joining right now. Okay, there he is. James, are you with us, James? Joining. James, are you with us? James, tell you what, if James is not ready, he'll stay in the room with us, and maybe we'll go to Rafi Podolsky, who's next on the list, and then come back to James. Hi, Rafi. Welcome back.
Thank you very much. Representative Doucette, Senator Miller, members of the committee. My name is Raphael Podolsky. I'm a lawyer with Connecticut Legal Services, here on behalf of legal aid programs in Connecticut. There are two bills I want to say something about. I'm sorry you may not have written testimony because of a computer breakdown at my end, but I've filed it and I hope it'll be posted soon. Very briefly, the first one is House Bill number 7083, which is the bill about credit unions. I just want to tell you we have some concerns about Section 8, which is the section that deals with repossessions and has language that would allow credit unions to set a different policy from the standard. Bruce Adams and I spoke a little bit before his testimony, and we will continue to speak more about it. But the basic concern that we have is that it seems to permit a situation in which the protections that part of the statute gives to the debtor could be overridden by the credit union on a motor vehicle credit union loan. The second bill is the Earned Wage Advances Bill, Senate Bill number 1396. I'm very aware the bill has changed in a lot of ways since last year's version. I think a lot of the protections in it are important, and that is a positive step in the right direction. I do think there's some concerns that remain. It was interesting to me that some of those were actually mentioned by the banking commissioner or the banking department's representatives. I would say that the concerns that I have most, the greatest concerns come from the repetitive nature of short loans. The loans are short, but then there's the product is designed in a way that people, in a sense, are encouraged to use the product many times. And that then starts to create a pattern in which the cost rises. And this is, you're obviously, the committee is well aware of this. Things that in this bill, I'm certainly aware of. Number one is that there's no total price cap anymore. It's $5 an extension, but there's, at least if I understand the draft correctly, there's no, you can take as many extensions. There's no limit to the number of extensions per month that was in the bill last year. There's no cap on the total dollar amount, so that it has that, which plays into the problem of repeat use. So I would mention that as one thing in particular. There's no anti-stacking provision within the bill, which is to deal with the person who goes to multiple places. And so I've been interested in the conversation you've had about a database and ways of trying to address that issue. And if I understand it correctly, there's no APR disclosure. It's not merely that you're not going to use that APR in this proposed bill would not be the statutory max, the way it is for the rest of the Small Loan Act, but there's no alerting the consumer about the fact that they're paying at a fairly high rate. That becomes more important as the loans become more repetitive. I understand Representative Foster's concern about applying how the APR applies when you have like a single short-term loan. But as those short-term loans become recycling in a sense of your own money, then the APR takes on more and more incentive. Okay, I realize my time's up. The last thing I would say, and this is a question that Senator Miller asked me last year, is what's the alternative? And it seems to me that the two kinds of alternatives I see are this ought to be an employer paid benefit so that people don't have to pay to get their wage on time. And somebody ought to be putting pressure on employers, perhaps through the labor statutes, not to take 2 weeks to give a paycheck after the person's earned it, which would then take some of the pressure off of this industry. They could even hire people in this industry to do that work for them. They can do that. Thank you very much. And I'm sorry I went a little over my time.
Thank you. No, we appreciate that last point, and I think it's a good one. It's come up from time to time as we've discussed this, and appreciate your perspective as well. You've been around a while, I think, a few years, and I think you've seen the technology and the evolve, right, associated with extension of credit, and it requires us to stay on our toes and adapt and to these new products and make sure the same consumer protections apply. And I think you would agree with that. Can you give us just a brief overview? You reminded me at Section 8 with the car repossessions, sort of what the current law is, and I think either there was a bill or there was a change enacted within the last few years even to that procedure, or maybe it was just a proposal that didn't pass. But give us a kind of broad overview of where that issue stands in terms of the valuation of repossessed automobiles.
Right. The broader view is easier for me than the specific view, because I share your memory that there have been some changes. I'm not sure I know exactly what all of them are. The bill, the basic concept of that part of the statutes, which is part of it deals with repossessions, it was passed. Some of these rules were passed in the 1970s to stop the practice in which the buyer of the car, the debtor, would end up falling behind in payments. The car would be repossessed. It would be resold for next to nothing. That amount would be credited to the account. There would then be a deficiency that could be sued upon by the creditor, but the amount that was owed would end up being substantially the debt, because the amount of the resale was for such a small amount that it barely covered, if at all, the cost of repossession and storage. So the result from the debtor's perspective was they still owed all that they owed before the repossession, and they had no car. And that seemed unfair. And so that was what was behind the statute. It was the same time they adopted an election of remedies for cars sold for less than, at the time, $2,000. I think it's now $4,000, where if you choose to repossess, you can't sue. And they applied that across the board to other kinds of secured credit. So if it's a refrigerator, then it's a complete election of remedies. If you repossess somebody's sofa or their refrigerator, you cannot sue them. If you want to sue them, then let them keep the sofa and the refrigerator and go into small claims court and sue them. So that's where this comes from. So in that legislation, they put in a formula that said there's a rebuttable presumption that a repossessed car, if it was bought for less than $4,000, it's an election of remedies. So it doesn't matter. But if it was bought for more than $4,000, then there's a rebuttable presumption that what the car is worth. And the formula in the statute is it is worth the midpoint between its book value as a retail sale and its book value as a trade-in. So in effect, the difference between the two was to cover it would be to cover the sort of the repossession and storage costs. It was rebuttable, but it could only be rebutted by in-court evidence. So, which was meant to discourage creditors from bringing deficiency actions, because the evidence was that by and large, unless the car had been in an accident or something like that, the payment schedule on repossession is designed so that it roughly matches the declining value of the car as it becomes older, so that there shouldn't be much difference if you sell the car retail. It's only at the wholesale markets that it was a problem. So that's what this is about. So what Section 8 says, and at the time I read it, I couldn't figure out what it meant, but what Section 8 says is that for credit unions, it's a special exemption for credit unions, they can come up with their own mechanism of evaluating that formula. And my concern is that they will end up doing it in a way that will not protect the presumed value of the car to the same extent, which means that the debtor will end up with a larger deficiency judgment, or with a deficiency judgment when there otherwise would have been no deficiency judgment. So I mean, I'm very happy to have a further conversation with the industry about that. But from my perspective in talking to you is, I don't think you want to do something that loses that consumer protection for a particular lender, notwithstanding the fact that the lender may be more kind of user-friendly than, say, would be a bank. So that's you know, I didn't have an immediate solution to that other than to say, take the section out. But certainly there's no objection to looking at ways that if there's any room for adjustment there.
Yeah, that's helpful. That's helpful. And you jog my memory. It was the minimum value of the vehicle, I think.
I think we moved at some point, we moved it from $2,000 to $4,000. I mean, I tried to get a bill through a number of years ago that if you simply took 1976 when they put in the 2000 and applied a CPI adjustment, you were there probably as chairman at the time.
Exactly.
It would be up around 9,000.
Yep.
I mean, and that should happen because that the intention always was, if the car was more than 6 or 7 years old, then it was an election of remedies. But in any event, that part, they're way behind in terms of inflation adjustment.
Right. Okay. All right. Any other questions for Rafi? Seeing none?
Thank you very much.
Appreciate it. Okay. So I saw number 11, James was in the Zoom room and now he's not. So I'm going to go to number 16, Annie Harper, who is in the Zoom room. Annie, are you with us? There you are. Hi, Annie.
Yes, I am. It's good to be here. Thank you. So co-chairs Miller and Doucette, ranking members Berthel and Dilnick, and honourable members of the Banking Committee, thank you for the opportunity to testify before you today. My name is Annie Harper and I'm testifying in opposition to Senate Bill 1396. The views I express today are solely my own and do not represent those of any organisation or agency with which I'm currently or have previously been affiliated. So I'm an assistant professor at the Yale School of Medicine's Department of Psychiatry, and I conduct research into the associations between finances, poverty and mental health, including the connections between debt and health, primarily among lower income people and people marginalized in different ways. So the kinds of debt that I learn about: rent to own debt, fines and fees, short-term debt, including early wage advances. So through our research on debt, we've found maybe some unsurprising findings to some. Even small debts can pile up and become overwhelming. And we also found, and this is both of these findings built on other research, that when people are juggling multiple types of debt, which is common, even if they're very small debts, that balancing act can be extremely stressful, with the bandwidth required to keep up with all of the debts. Deciding which to pay when and how much can cause really overwhelming stress and anxiety. I appreciate the work, the many hours of work that the Department of Banking has put in to improve protections for consumers for these products. And I will say that I'm incredibly excited about the potential for fintech to improve banking services for marginalized and underserved populations. But my fear about earned wage access is that while the associated fees may seem insignificant, I think they will result in heightened distress for some people. We cannot see the fees in isolation from the juggling acts that far too many people are already playing just to keep their heads above water. And we know that the people most likely to pay for expedited access will be those who are already struggling and desperately need funds immediately to make urgent payments. And they're the people for whom even low fees can dig them further into an existing financial hole. And I know that there is an argument that of demand for these products must be useful for those who utilize them, and that it might be useful to have a short-term loan to manage a potentially catastrophic financial situation. But the research that I've done really does suggest otherwise for many people. So stories from those I work with show that many people simply take these advances because they have no choice. One person in a meeting I was in said, "I know I'll use this if I must, but it feels terrible to have to pay a fee to get my own money." When someone's desperate for a short-term fix to address a financial crisis, they may be glad of any opportunity for relatively easy money. But on the other hand, they're keenly aware that all they're doing in many cases by taking a loan is punting the problem down the road, and indeed that things may worsen when their next paycheck's less because of having taken the advance. And we know, again, from our research that one of the dimensions of poverty and debt that impacts health the most, and I mean, doesn't just make people stressed, but actually causes serious mental health and indeed physical health problems, is when people become overwhelmed with multiple obligations. And that limited bandwidth makes it impossible to keep track of everything, leading to stress, frayed tempers, as I said, ill health, and poor decisions in other areas of life. So the underlying problem, of course, is that wages and benefits are too low and the rent and cost of living is too high. But I think rather than adding yet another costly way for people to temporarily stave off crisis, we need to pass laws and develop policies that'll raise wages, reduce rents, make healthcare affordable, et cetera, addressing the overall cost of living. And as I understand, we already have regulations for loans in Connecticut, and I don't really understand why those can't just be applied here. Thank you very much for the opportunity to testify.
Thank you, Annie. Thanks for coming back to the Banking Committee. Always good to see you. We do really appreciate your perspective and your background and your advocacy. Any questions for Annie? Any questions? Seeing none. Thanks again. Thanks for your patience today. Okay, we're going to move on to Kathy. Kathy Chartier, who's with us online. Hi, Kathy. Welcome, Kathy. We can see you now, but we can't actually hear you. We can't actually hear you. You're either on mute or your audio is not connected to the Zoom. Nope, you're on mute. Now you're on mute. Unmute. Are you there? No. Kathy, do you want to maybe disconnect and then rejoin us and we'll come right back to you? I find that helps sometimes with the audio. Okay, thank you. Wonders of Zoom. Okay. So yeah, we're going to go to Tara Ryder next, who's in the room with us, and then we'll come right back to Kathy when she rejoins. Welcome, Tara.
Good afternoon, Chair Doucette, Chair Miller, and members of the committee. My name is Tara Ryder, and I serve as the Vice President of Policy and Government Relations for Bridget, a financial wellness company providing non-recourse direct-to-consumer earned wage access services nationwide. With certain modifications, we support the adoption of Senate Bill number 1396, an act concerning earned but unpaid wage or salary income advances. Much like many of my colleagues have already discussed, earned wage access is a vital financial tool for many of our customers that are bridging the gap from a bill's due date to their next regularly scheduled paycheck. I think it would probably be most beneficial to kind of address a lot of what we've talked today rather than reading the testimony that I've submitted or even the remarks I've prepared today. Earned wage access, I think the most important feature that we really don't talk about enough is that it is a non-recourse product. So that means if somebody takes a $75 advance on their paycheck, they don't actually have to repay that advance. Bridget also offers flexible repayment dates. So if the withdrawal date is approaching and they realize that if Bridget were to make that withdrawal, that might be a little bit short for another bill or an emergency popped up, they just need to reach out, or they can go in the app and they can change the date. They can continue to change that date at no cost. There's no questions asked. We really just want individuals to be able to operate their financial freedom as they choose. I think the way we separate ourselves from traditional credit, like a credit card or a consumer loan, is there's no interest. There are no late fees, there are no penalties. Bridget charges an optional $1.99 expedited transfer fee, which is much less than what you would see at your local ATM. And that is completely voluntary. So you do not have to choose to expedite to get that money in 3 to 5 minutes. You can opt to wait 24 to 48 hours through traditional ACH. And I think, to touch on one of the provisions in the bill, it's new section 2, provision 3, that would require Bridget to advance up to 75% of an individual's earned but unpaid income at any point in time in the pay cycle would not only put the consumer at risk of overextending themselves for something they didn't really need, it also would put our organization at risk because this product is non-recourse, unlike a loan where if they take $750 out and it's a loan, that's a contract, right? So they have to repay that. With earned wage access, there is no requirement to repay what you've been advanced. Therefore, we are at greater risk for non-payment. Bridget self-caps at $250 currently, and you are only allowed to have one outstanding transaction at a time. So the concerns around multiple transactions, or we're going to limit how much you can take, so you have to take multiple transactions in a week, that doesn't exist with our product. So I really just wanted to address that piece. And then also to talk about the database. The database exists for payday lenders. It does not exist anywhere for earned wage access. Payday lending does not exist in Connecticut. This product is not a loan, so it is not a payday loan. You do not have to repay it. So reporting it to a database for something that doesn't actually ever have to be repaid doesn't make a lot of sense. But we're definitely open to working with the department on ways to find a solution.
Okay, thank you. One question, we had some discussion earlier about the 75% and or a advance limit. Do you have an opinion on that or any suggestions? I mean, I guess first, what do you think a good limit would be? Not going to hold you to it, but just trying to help think this concept through. And I guess the second question would be, I mean, what is your average advance generally?
Sure. So I think every company operates a little bit differently. And one of the customers was on the line earlier saying how they were able to kind of choose between two companies, and they used one company for one purpose, another company for a different purpose, depending on the situation that they were in. I think that choice for the consumer is super important. And every company has a different model. At Bridget, we self-cap at $250. One, it's a consumer protection, and two, it's a business risk decision. So I don't want to speak for the industry as a whole and say that there's one finite number that would work for everyone. And I also think, you know, if Bridget's model doesn't work for a consumer, they don't have to use our organization. They can use another organization. I think we're also trying to solve for a problem that it doesn't appear to exist. So I think kind of maybe studying this issue and seeing if the issue exists might be a path forward, rather than legislating something and handicapping things and not really having an understanding of how the market works and what the consumer behavior is with the product. Might be a good alternative, rather than creating an arbitrary maximum, minimum, when, you know, based on our data points, we don't show this as being an issue. And our average transaction nationwide is about $76, and in Connecticut, it is $80.
Okay, thank you. Senator Honig online has a question. Senator.
Hi, thank you for being here, and thank you for your testimony. It sounds like you are a very low fee outfit. Is that correct?
Correct.
And I'm just like, how does your firm like generate revenue with fees so low?
So we have obviously our expedited transfer fee. We do also, separate from earned wage access, we have our subscription-based suite of services, which you are not required to subscribe to access EWA. It's products such as identity theft protection, credit monitoring. We have a 0% APR credit builder loan, which allows people with a thin credit file or no credit history to build that positive repayment history and build up their credit profile. So we have other products and services in addition to earned wage access. They are intertwined in the sense that you can access all of them, but you do not have to subscribe to access our earned wage access product.
So does like the majority of your revenue come from the subscription products?
I would say it's a mix of all of our products and services together.
Okay, because even your your expedited transfer fee, what was it, like $2?
Correct.
And does that like cover your costs of doing that?
Without really getting into the specifics of our various contracts, of how, you know, our company creates revenue, yes, we are able to operate with our current structure.
Thank you. Thank you, Mr. Chair.
Okay, any other questions for Tara? Seeing none. Thanks, Tara, for joining us again. Okay, now we're gonna try Kathy again. Kathy, please unmute. And oh, we can't hear you. I can see you, but I can't hear anything. I'm not sure what. No, I'm not sure. We can try again. Hang with us and we'll see if we can figure this out. Okay. Okay. Next on the list is Garth McAdam. It looks like Garth is with us in the room. I'm gonna step away for just a second. Garth, please proceed. Miller is online and got folks in the room. Please proceed, Garth.
Good afternoon, and thank you all for the opportunity to provide testimonies today. My name is Garth McAdam, and I'm from Zayzoon. We're an employer-integrated EWA provider, and we mainly work with small to mid-sized businesses. I'm here to express Zayzoon's support for Senate Bill 1396. So historically, Zayzoon provided EWA services to the employees of nearly 200 businesses in Connecticut. So this has admittedly slowed as we had to turn off a lot of the services in the past year. However, we do continue to operate on a limited basis and solely to provide our fee-free services to workers. The current approach to EWA in the state, unfortunately, has effectively ended a lot of worker access for this low-cost financial product. But we are hopeful that Senate Bill 1396 can move us forward, and so we can start offering our full services once again. So as you assess this bill, please consider the need for liquidity faced by so many workers. EWA provides a link between work and wages in a way that no other financial product does. If a Connecticut worker finds themselves in need of money today, they can access their earned wages. If their immediate need for funds is greater than what they've already earned, then they can pick up extra shifts and get access to those extra wages as well. So this connection between work and wages unlocks immediate low-cost funds for Connecticut workers. And I think that's what's unique and special about EWA and why I'm so appreciative of the efforts of everyone to get SB 1396 drafted. So EWA gives Connecticut workers power and an option that they just don't have otherwise. When we turned our service off, the fee service, we saw something pretty interesting last year. So a number of our Connecticut customers tried to change their address to out-of-state addresses in our system. They put in a different state address such that they could try to get access to their services. So we do have systems in place, so we were able to catch this, but the fact that so many people felt compelled to try to falsify their address in the first place shows how important EWA is to Connecticut workers. I would like to quickly address the two concerns that have been discussed today. I'll touch on them very, very lightly. The third-party database, we have significant concerns about that. I believe there is one third-party database provider who is speaking today, and we have heard that the suggested fee for this is $2.25 per transaction for reporting. Given that SB 1396 imposes a $5 per transaction fee cap, that would mean that the reporting fee cost would be 45% of the maximum amount that we're permitted to charge. So this is absolutely prohibitive from a cost point of view. And that's just speaking to the per transaction cost of the database reporting. So not the other concerns that others have raised, such as Mr. Naples from Daily Pay. So second, one suggestion that we would have on the requirement for the 75% of earned wages is to clarify that this is net earnings after legally required withholdings. For a worker in Connecticut earning about $50,000 annually, they can expect to see approximately 20 to 23% withheld from their paycheck for state and federal income tax, Social Security, Medicare, etc. If the customer has garnishments on their earnings, like child support, then this amount is reduced further. So we're already at the 20 to 23, and if it's reduced further for child support or other items, then if our obligation is to provide 75% of gross earnings, we could be pushed into a loss position just from the get-go. And so if it's clarified to be net earnings, then it's a lot more palatable for us. So we believe that SB 1396 provides a reasonable and well-reasoned approach, a responsible and well-reasoned approach to giving this financial tool back to Connecticut workers, while also ensuring that they are protected. And for these reasons, we respectfully request your support for this bill, and thank you very much for your time and consideration today.
Thank you, Garth. Garth, were you part of the negotiations with the Department of Banking? Was your company a part of the negotiations?
I'm very actively involved with industry, so I'd be, but so more indirect, not directly working with the department, but I'm actively engaged with PayActive, Daily Pay, and others in the industry for this. So,
and so we know this is a far cry from what is currently in law. And you said that individuals were falsifying their address so that they could use this product. Do you have a number by any chance of how many you were able to catch?
I don't off the top of my head, but I could certainly find out that information and get it to you.
Yeah, I would be interested in knowing that. And thank you for your testimony, your response, excuse me, mouth is dry, throat is dry. Your response to Attorney Chambers' suggestion of the third-party database. So as Tara mentioned earlier, I don't know if it was you or Tara, but that it only applies to payday loan, the 12 states that do have it in law. Well, thank you for testifying. Are there any questions from the members? Representative Delnicki.
Thank you, Madam Chair. In your testimony, you made the statement that people were falsifying their address just to use the product.
Yes. I'm sorry to interrupt. Sorry, please go ahead.
How do you know that they were falsifying their address?
Because our system permits them to correct certain data within their accounts, so they could change their email or update a phone number. So they were attempting to change their address within our system, but our system, because we partner with Payroll and employers, will pull the data regularly from Payroll, and so it will flag that the address that's recorded on Payroll is different than what's recorded in our system. So that's how we were able to identify it, that this was happening.
Well, I'm glad for that clarification. One final question. I would assume that at that point you would not conduct business with them.
Not on any sort of fee service basis. So we do still continue to offer the service just on an earned wage basis, like to our card or our other free products. But that is the extent of it. So, and then only provided like the address was not changing going forward. Yeah.
And getting back to your read of the proposed language from the Department of Banking, what's your thought on that?
In which regard in particular? Sorry.
Well, all the proposals that they put on the table pertain to how the EWA would work.
I mean, I think functionally it works. I think the reporting is extremely difficult. I think Mr. Naples addressed a lot of that. The logistics of that is extremely difficult to do. The monthly fee cap is challenging because I think it could potentially just delay for certain individuals the situation that they might end up in, because an overdraft fee is just hypothetically, if we made it 6 transactions or $30 in a month as the fee cap, a single overdraft fee can be as high as $30. So if they're in a position where it's capped at that point, and then they're just slightly later in the month, they're put in a position for an overdraft, whereas even one more earned wage access advance could have prevented that additional fee. So this is why it becomes difficult to set that number. I can understand the appeal to wanting to avoid that situation, the overuse. I believe that the average use of our customers is 6 times a month right now for across our customer base. I'm not sure in Connecticut in particular from the data before the changeover, but I believe it's comparable to our national average. So the 6 times a month is largely what we're seeing. We do have certain individuals who are who would use it more than that. In those situations, we actively reach out to those individuals. We notify them about high use. We notify them about our free options and how they can use it, about the card, which is always free for them, and just a more responsible base. So we do take a proactive approach already with high use customers. So I think from that point of view, the monthly fee cap would not really address our average user or would not really change their behavior. And we're already actively working to change the behavior of high use customers as well.
Well, thank you for your answers to the questions and your testimony. Thank you, Madam Chair.
Thank you, Representative. Are there any other questions from members? Seeing none, Garth, thank you very much for your testimony.
Thank you very much.
Kathy, will you want to try it again? Did she disappear on us? Yep. All right, so I guess she's trying. So we will go next to Jeremy Skites. He's in remote. No? Okay, next we have, and I hope I pronounced your name correctly, Bolinski Dayal, who's in person. Thank you.
Thank you, and you did pronounce it correctly.
Oh, great. Good afternoon, madam.
Thank you. Good afternoon, chairs and members of the committee. First of all, thank you for all the work that you're doing in crafting thoughtful regulation frameworks, especially in emerging and evolving landscapes within fintech. I think there's a small typo on the speaker list because I too am here to speak on SB 1396. My name is Vidushi Dayal, and I am the Director of Legal Analysis at Chamber of Progress, which is a tech industry coalition promoting technology's progressive future. We have over 30 partners across the tech space, including fintech companies such as DailyPay, Earnin, and Chime, but none of our partners have a vote or veto on our positions. So I'm here to express Chamber of Progress's support for SB 1396, which would regulate EWA services. We are strong supporters of providing consumers with better alternatives to predatory lending and junk fees at banks. EWA services help workers bridge the gap from today to payday and frees workers from depending on the payroll cycle and a financial system that frequently disadvantages them. You heard from a Connecticut EWA user earlier today, but I'd like to call the committee's attention to a survey that was also conducted by 3 direct-to-consumer EWA service providers, where an overwhelming number of EWA consumers said they understood how the service worked and considered it to be the best option for managing spending. EWA provides consumers the opportunity to stretch their dollar farther than the standard two-week pay cycle and enables them to avoid predatory payday loans. Notably, 8 out of 10 consumers felt that these services were the best options available, and 80% of users said their lives significantly improved after using these services. EWA gives consumers a safer alternative to paying the bills late and getting charged bank overdraft fees that can cause them to decline further into debt. So while SB 1396 establishes a critical framework for EWA, I'm aware that the bank regulator is also working on constructive changes to strengthen this bill. We commend this and look forward to seeing what that may look like. A few of these have already been raised, but we encourage the committee to consider the targeted amendments that would preserve consumer choice in tipping models, ensuring sensible advance limits, and expanding wage verification options to include members of the workforce that could be gig workers or at businesses without payroll integration capabilities. So with all of this in mind, we urge you to pass SB 1396 with amendment. Thank you again for your leadership in promoting a responsible regulatory structure that protects consumers, increases transparencies, and ensures that EWA providers can continue to deliver services that Connecticut residents rely on. Thank you.
Thank you. I have a question for you, maybe a couple. Who were the providers in the survey that you just cited?
So off the top of my head, I believe it is Bridget, Money Lion, and there is a third. We've submitted written testimony that cites to this survey, so you can find it there. But those are two out of the three that I remember.
Have you heard the testimonies regarding the party database?
Yes.
Do you have an opinion?
Well, I definitely would defer to the industry players on this. I think they make a fair point distinguishing themselves for needing the database in EWA versus other types of lending services.
Okay. And so you mentioned that you're a Chamber of Progress. Can you just tell us exactly what you do?
Yeah, so I mentioned we are a tech industry coalition, so we advocate across a variety of issues involving technology, and our overall goal is to ensure that innovations and benefits of technology reach as many people as possible. So fintech companies work with us. Crypto, we also advocate on crypto issues, free speech issues, competition issues, and artificial intelligence, as well as more civic innovation technology. So Airbnb's delivery, really across the whole spectrum.
And how long has your organization been in business?
I believe it was founded in 2021, at the
All
beginning.
right. So you're fairly
2021.
new.
Fairly new, but it's been one administration plus now.
All right. No, I appreciate it because I've never heard of your organization before, and so that's why I ask. And we need companies such as yours and also companies, watchdogs and different companies, because fintech is new. It's new and it's taken us into areas that we're not familiar with. We're used to brick and mortar and we're getting away from that. Companies are having their staff work remotely. And so brick and mortar is becoming a thing of the past. So are there any questions? Representative Delnicki, do you have a question, sir?
No, I don't.
Okay. So thank you. I apologize. I thought I saw Delnicki and it says Doucette. So I apologize. Didn't mean to put you on the spot. Well, thank you, Representative Doucette. Do you have a question, sir, before we?
I do not, but I'm back in the room and I thank you for your testimony.
Thank you so much.
Thank you, Senator. Okay, so
Kathy is back.
do we want to try Kathy? Unmute. I think you're still on mute, but if
Can you hear me now?
we can, yes.
Thank you for your patience. My computer was telling me my sound was working, but obviously it wasn't.
We've all been
So,
there. We've all been there, but we hear you now. Thank you.
okay. So I'd like to say good afternoon, Senator Miller and Representative Doucette and the members of the Banking Committee, and thanks for the opportunity to testify today on Bill 7083. My name is Kathy Chartier. I'm President and CEO of Members Credit Union in Stamford, Connecticut. I'm the one that requested Section 2 to the bill. We are a community development credit union and a CDFI, which is a designation from the U.S. Treasury Department because we qualified for because more than 60% of our lending is to people of very low and moderate income, and we have development services for them. We're a state chartered credit union, and we're seeking parity with federally chartered credit unions that are regulated by the National Credit Union Foundation, and they're allowed to take non-member deposits. So what I am looking for is parity with their language, which permits certain Connecticut chartered credit unions to accept deposits from any source within certain limitations. This bill would allow community development credit unions to take low-cost deposits from outside organizations or individuals. For us, examples that we would be looking for would be the philanthropic or community, not-for-profit organizations, credit union trade associations, out-of-state credit unions that want to support other CDFIs, or banks making a deposit for CRA purposes. This would allow our credit union and others in the same situation to lend and bring financial education and low-cost transactional services more deeply into the underserved community. And we serve very low and modest income individuals and improve their financial quality of life. So that is my testimony. You waited a long time for it. Thanks for listening.
No, thank you. And thanks for your persistence and sticking with us. Senator Miller has a question.
Thank you. So Kathy, I just learned about the community community development certification. And so I think there are a few in New York. What communities do you serve?
Our field of membership is Fairfield County. So yes, and we were in COSCOB for many years. And as we became a CDFI and spread into the community, we moved to Stamford because the biggest base of our membership is there. Second would be Norwalk. Third would be Greenwich, and fourth would be Bridgeport. So we're really along the lines mostly of Lower Fairfield County.
And so how do you know if the individuals that you're serving are underserved or that they're low and moderate income?
Because the way we track them is by the loans that they take, the applications that they put in. So we have all of that information available to us.
And so do you have to report that information?
Yes.
And where do you report it?
To the U.S. Treasury.
Okay. Do you have any type of programs that are specifically designed or catered to that population?
Yes, we all of our staff, with the exception of the very new, are all certified financial counselors. So when new members come into the credit union, if they're not familiar, we serve a lot of minority members and a lot of immigrants as well. So we give them financial training on how the U.S. system works, how to build credit. That's part of what they do all the way in. We really try to develop our members to become in a better place. We have low and no cost products for them to do that. We have credit builder loans. One of the probably the most beneficial things that we do for those members is to get them in a very good affordable car loan that they can afford to go back and forth to work. If they own a home already, we're often able to refinance them into a first mortgage with us and cut their costs drastically to improve their quality of life. We have relationships with many of the organizations in town, and sometimes I like to think of us as a social institution that does financial work. So we're very dedicated to what we do.
Is this a credit union only designation?
CDFI?
Yeah.
No, banks are also CDFIs. Loan funds also as well.
So Kathy, I really want to thank you for bringing this to our attention, because in my research and trying to bring products to the committee that serves the underserved or the unbanked and the underbanked. And I ran across, I believe it's Spring Bank in the Bronx in New York, who had that product, right? They had the certification. They were doing some of the same things that you were doing. I said,
right.
I wish that I could get, that in Connecticut. And I researched and I couldn't find a bank. I think maybe New Haven it was questionable, but I want to thank you because I think this is very important. And I would really like to sit down and talk to you to see how we can expand this product into other parts of the state, because we need to bring individuals into financial institutions so that they can save money, they can learn how to be financially stable and not spend the monies that they spend at other places like cashing places and the like. So I really do appreciate you bringing this to our attention. And again, I would like to talk to you at some point, maybe after session, so that we can talk about it and see how we can expand this throughout the state.
Well, you're welcome to come visit us anytime. So I'd love to show you the credit union and show you what we do.
All right, well, thank you.
I did want to mention, though, that one of the reasons this is important to us is when you're serving the low-income people, their demands are much more for lending than they are for saving. They have very little to save. So that is why this bill is so important to me, because there are organizations that help CDFIs with funding at very low cost, other than what I can go out and pay a bank for to sell a CD. So.
Right, and part of what makes this work, or it made it work in New York and the Bronx, was that they partner with other organizations. And
Exactly.
Right, and so that's what made it work, helped to make it work, because again, you don't have the funds that it need to assist these families whose needs are higher. And as far as loans, and I think it's important too that savings piece. We have to get people in the habit of saving monies. My mother used to say, "I don't care if you save a dime,
Just save something.
just to save something,
Yeah.
for that rainy day." But just to get them in the habit. And I really do believe that those kind of things are generational. That if you're saving, your children see you're saving, that they're going to do it as well. But if you're spending, your children see you spending all the time, then they're going to do that as well. So again, thank you for what you do. And I'm excited to sit down with you and just to see some of the products that you offer low income families. Thank you, Mr. Chair.
Okay, thank you, Kathy. And again, I echo my co-chair's comments. Thank you for bringing this forward and putting a face and real world application on this. And thank you for working with the league and the department on this. And we appreciate you joining us today.
Thank you.
Thank you. Okay. On my list, I believe we are up to Chris Fitzpatrick, number 22. Who is not with us online. So that means we are going to go next to Monica Burks, who is with us in the room today. Thanks, Monica. Thanks for your patience. Thanks for being here again with us.
Absolutely.
Good to see
Thank
you.
Yeah. Representative Doucette, Representative Delnicki, Senator Miller, thank you all for your time and attention. I am here to discuss the Earned Wage Access Bill, SB 1396 today. I submitted some written testimony that provides a summary, and we also attached a report that was published by the Center for Responsible Lending in the fall of last year that verifies some of the harms that we have been forecasting for the last few years around these products. I would ask that you really give the data that we have provided significant heft, because it's unbiased. It's checking account transactional information that was voluntarily provided by consumers. Among some of the findings there, loan stacking, which is what Joe Chambers highlighted, where consumers are using multiple applications within the same pay period. We see almost half of the consumers that we, from the data we analyze, are engaging in that activity. So a data tracking system would be one way to provide some safety net for consumers who may feel compelled, which we see a lot of times happens because as the accumulation of fees takes effect on their monthly income, there is an increased need to use multiple applications. There are other harms that I summarize in that letter, but really what we're asking is, when you all go back and look at what this bill is and where it is at this moment in time, please include consumer advocacy groups in those conversations. One reason for that is, you know, the industry is introducing bills all over the country, and they are negotiating much more helpful and consumer-friendly terms in other places. And we can provide you insight into what's possible. And, you know, the other thing about, you know, as soon as you say, you know, 36% we can't operate, that makes it impossible. Okay. Disclosing APR, we can't operate, that makes it impossible. Okay. In Vermont, the committee there asked to set the tip to $0 as a default and let the consumer toggle it themselves. They said, that's impossible. That would really, yeah, we can't do it. If you go look at the Vermont bill now, the default is at $0. So we are asking that you use this bill as an opportunity to infuse more meaningful protections for consumers who want access to this product in the state. A data tracking system could help, making it more accessible for consumers to have a longer time to repay, even if it seems like a small amount. $80 within a 10-day period. I took it out 10 days and I have to pay it back in 10 days. That's not enough time for me to actually recover from whatever perceived financial difficulty this product is purporting to solve. So there are a myriad of ways. We are asking to please be used as consultants going forward so that we can share the aggregate information we have about what's happening around the nation with this bill, and so that we can really ensure that there's sufficient protections against recorded harms. Thank you.
Thank you, Monica. And thank you for coming. We hear you, yes, and we definitely value your contribution to this and would like to see you more involved. So we appreciate you being here with us today. You know, a couple of things. You know, one I think you touched on. You know, I want to give you an opportunity to, you know, we've had some conversations about the data tracking today. You mentioned that. Don't need to sort of rehash that, but I wanted to give you an opportunity to talk about sort of some best practices that we could adopt into this bill. One of which you said is setting the tip to $0. Our current version says that the borrower may elect, a disclosure should be provided that the borrower may elect a finance charge of $0. That's not probably exactly the same thing. So our bill doesn't have a set to zero function, but that's something that you would suggest.
So I want to back up a little bit and make sure that the big picture is what consumer protection advocates have known for a long time is when you impose a 36% rate cap, it mitigates all of the evasions and the game playing. Right now, this bill is trying to piecemeal address some of the current evasions, but the only thing that's constant is change. So we could sit today and say set the tip at $0, but at the beginning, the most important thing or the most effective thing is the rate cap. But short of that, yes, at least you know, having a 0% rate cap. But honestly, you have to look at the whole idea of tipping in connection with a financial transaction, especially for people that have been identified to be financially struggling. It takes away so it's really hard to endorse a solution that says that soliciting tips from somebody struggling is an okay thing to do. It's really difficult.
And I agree with you. I do agree with you. I'm not a fan of the tipping. And again, I've been here on this committee for quite a while, and we went at that issue when we you know, included the tips as part of the calculation 2 years ago. So I hear you. I'm not a fan of the tipping. So but anything else in terms of that you want to highlight for us in terms of the experience in other states as other states are pulling together legislation or other regulators are prescribing things?
Absolutely. I want to be respectful of the time constraints of this particular forum, but at least there's a few states out west. I believe it's Washington, where there's a bill on the docket that does not allow tipping. You also have fee caps that max out at the end of the month in certain bills in other states. And I'm be happy to give you the details in writing. But there are ways, for instance, we heard, and this is our data verifies this, high frequency users, which we found in our study 6 times a month or more. If a person is using a product that frequently, maxing out what they would have to pay to receive those funds right away would be one way to reduce how much they're paying to use the loan service. So there are a myriad of ways to mitigate the documented harms.
Thank you, Monica. What is your thought on the database concept?
So yeah, as you've heard, 12 states implement this system. That's a lot of available market research. I mean, those systems have been in place for a very long time. Those systems were put in place when we did not have the current technology that we have today to do these things. So I think it's very achievable, and I think it's very helpful. I mean, we're talking about an industry that literally can use your GPS location on your phone to ensure that you're showing up for work. So to say that it's a burdensome or not achievable process to implement, I think is disingenuous.
It's interesting. Somebody testified earlier in the day that there was no database. They couldn't do a database. And now we've heard from you that, yes, they can. And they are doing it so as to have some kind of, for lack of a better term, regulation on the amount of times that it's used, et cetera.
Absolutely. And so they may not be, EWA, the industry has not been compelled to participate in a third-party database where they are all sharing what's outstanding, because that's what you have to do to make sure the companies aren't giving loans against the same pay period. What they do have, especially the direct consumer, they use a third-party platform to plug into your checking account, and they can see your history and activity for as far back, very, very, very far back. It cannot be that difficult to say, oh, they had a deduction from, earning already. They had a deduction from MoneyLion already. So when the question is it happening? They can easily discern whether or not it's happening. We know it's happening. And they can also they have the resources and they have the capability to create a system so that they can share that information for the protection of the consumers.
Well, thank you for your comments and, of course, your testimony, especially about the database. Thank you, Mr. Chair.
Thank you.
Senator Miller.
Thank you. Hello, Monica. Thank you for joining us again.
Thank you. I'm happy to be here.
Monica, I have a question. So you said the database, that they can do it. In Attorney Chambers' testimony, he stated that it's only done in the 12 states, done for payday loans. So how would you, with your knowledge, based on what you know of the industry, how do you think that they could apply what they do for payday loans to EWA?
Well, the tracking system is a technology, and these are fintech companies. So it's not about the label of whether or not we don't have to talk about the nature of the loan. We're talking about a technological capability, one that has been established for a few decades at least. So that's the perspective that I'm coming from, is something possible if we have the technology, right? So that's essentially what I'm getting at. It, regardless of the nature of the loan, we see documented harms. And yes, those harms may mirror payday lending, but we don't have to get into that. But we do know that these harms are happening, and one way to address one of those is to have a tracking system. And so, like I said, if they don't know how to do it today, they can quickly find out, because it is a system. I'm sure there are third-party companies that help with the data tracking. I'm sure there's all types of cybersecurity companies that can help protect it. It's achievable. I think in the history of just watching this industry operate, every time there's something that might be helpful for consumers, their first response is to say that it's prohibitive. That's why I brought up the instance of the tipping. 2 years ago, they said that would be really burdensome to implement. And now in Vermont, they've conceded. And it's because lawmakers are holding the line for consumers on certain points. And that's the beautiful thing about the legislative process is when we hold the line, that is where companies are compelled to innovate, to respect consumers' rights. And the thing we have to realize about this bill is it is saying, if you don't have access to other credit options, then you don't have access to our 36% rate cap in this state. And so if that is going to be the case, then what we do put out around EWA, we can put in other protections. And I think the data tracking system is just one achievable option.
Senator, you're on mute.
Sorry. Thank you, Representative. Monica, how do you track the data for stacking
So we
or collect the data?
So we obtained access to about 200,000 EWA transactions. Tens of thousands of users volunteered to share their checking account history and information and transactions. So by looking at their transaction history, we could see how frequently they were taking out loans. We could see how many companies they were using and so on and so forth. So we were looking at the raw data and we're able to establish the frequency of loan stacking and use and so on and so forth.
I'm sorry, I have to turn it off to make sure there's no background noise. How do you engage the individuals that you survey?
So one thing that I've learned since becoming a consumer advocate is there is a lot of pride and a lot of shame around being a hardworking individual and recognizing that you don't have access to the best credit options. So often it is difficult to speak directly with people about their financial business because it's private information. However, we have conducted several, as a matter of fact, I came myself in October of 2024. I went to Stanford for the weekend and I spoke to about 150 people in person, passed out cards and tried to engage them in a discussion around how they're managing their finances. And one thing that was really interesting, even though I live in Durham, North Carolina, I knew exactly where to go to find people who are being targeted by these products. They were at the laundromat. They were waiting for the bus. They were trying to manage their children leaving the grocery store. They were retail workers. They were, restaurant staff. And like I said, they did not necessarily want to speak with me directly about what was happening, but many of them, the first thing when they heard Dave or Chime or scam, I didn't even have to explain what the products were. Their general sense is even if they had used these products, they recognize that it's not a fair transaction, And I agree with the sentiment that if a person wants choice in their financial management, I can respect that. But I also can respect making sure that the laws that everybody else who doesn't have to choose these products is privy to somehow translates to me too. Just because I feel compelled or this is the only option or I'm cut out of traditional banking markets, please let the laws reflect the rights that other people are privy to, So yes, it's hard sometimes to get people to speak about these issues, but what we have seen is people want to be at a place that middle class place where they have a home, where they're not anxious about paying their rent, where they're not anxious about losing essential utilities, and these products become an additional burden on that path. These products put themselves as an additional bill because they can't not take it out the next pay period without suffering the gap that comes. It's basically like pawning your pay. If you don't take it out again, that money will be gone, and now your cash flow is ruined. So people are smart, they understand. But they deserve significant and the same protections that everybody else in the state can apprise themselves of, even if they're making more money and can use other credit options. They deserve those same levels of dignity in the way that the laws work for them.
Thank you for that. And the reason why I asked you about the stacking is because when we first started this work a couple years ago, I wanted to know how the product worked. So I went and I went into one of the apps. The next thing I know, I had invitations from everyone asking me, and it went on for like a month. And so I find that the industry can, not that they do, but they can prey upon people's weaknesses and needs. And people can stack loans unintentionally. And so I think that there needs to be some type of tracking system or something in place to, like this bill, that will monitor that and keep it at, and I should just say monitor, because again, I loaded the app, or I went into the app, not with the intentions of stacking, but by the time I finished, I had, like I said, I had invitations from everyone. So I think it is a very good point, Monica. And I think it's something that we as a committee is something that we have the fiduciary responsibility to make sure that families are protected. The challenge for me has been, and you and I spoke about this at great lengths, is how do I balance protecting people and making sure their needs are met? Because I know how it is when you don't have enough. You can work and you have a great job, but you don't have enough to buy food and pay the utilities, especially in Connecticut at this point, with our utilities rates, our bills are so high. But again, thank you for coming here once again. And thank you for the work that you do, because financial literacy is very important these days, and people need to know how to balance the finances in their lives. And so again, thank you. And we do welcome you in the conversations, but we weren't involved in these negotiations. So we just want to let you know that for this bill. Thank you.
Thank you.
Thank you, Mr. Chair.
Monica, I did have one other question. I wanted to give you an opportunity. We've talked about a lot about stacking in the context of the data tracking today. I wanted to give you an opportunity because I know your testimony includes other information about the negative repercussions of getting trapped into that debt cycle, particularly, overdraft fees. And we talked about a lot of this stuff last year. And I think our committee is well cognizant of these things. But I wanted to give you an opportunity to talk about that, what your findings are with respect to overdraft fees. And then the second part of that question, in terms of negative repercussions, is a lot of these companies have the ability to claw back or have the ability to get into your bank account, essentially. Are you seeing much of that? Do you have any data with respect to that? These products, we generally heard it said that they are non-recourse, but I think there are instances where they do have recourse, and I wonder if you have any information on that.
Sure. So I will address your second question first, and hope I don't forget the first, because that happens sometimes. So as we speak, you can go into the terms and conditions of many providers, and in that fine print, they will use continuing access to your checking account to withdraw the loan after the due date. And even if it's not the full amount, if they see a portion of their money available, you authorize them to take that smaller amount. So that may be one of the reasons that our research found that people who integrated earned wage access loans into their financial management experienced an increase in the overdrafts that they incurred. And it was so significant that folks who did not previously have overdraft, once they started using EWA, suffered overdraft. the other thing about the continuing access to the bank account, I also did some market research and signed up for a few, and it was not easy to cancel my transaction. One provider asked me, why? What is there, or do you understand that if you don't pay, you'll lose access to the service? It was not it was much easier to get the money than it was to cancel the repayment. And so in Maryland, we already know that about 97% of these loans are repaid consumers because hardworking, there's this, we all understand that we want to pay our obligations. That's an essential value. You learn that from a very young age. So 97% of people repay. In Maryland, they disclosed in a hearing last year that even the ones who don't pay right away, they'll be back. They'll be back, right? And it's because what consumer advocates have identified as a group of people who deserve systems that allow them to move out of the margins of our economy. They've identified that as a target market that they believe, and reasonably so, will continue to be there, right? And so if you look at Connecticut, they were operating an evasion of your laws for over a decade. And as soon as they took that product away, the people that were using it, they had to establish a fund to reimburse them overdraft fees. So you're telling me you're providing a financial product that's supposed to help someone, but after a decade of operating, your consumers are still in the same financial distress that they were in when you offered them the solution, right? So yes, the overdrafts increase across the board, and it's illusory to say that these are non-recourse loans. The data and the way that it works in practical reality just doesn't bear that out.
I appreciate that because, again, we hear, lots of contentions from the industry about the nature of the non-recourse. And again, I'm not saying that folks are necessarily misrepresenting, but I think when you come with your perspective, it presents itself in a different light.
Yeah.
Sometimes when we're talking about the same thing. So it's good to get all those perspectives and all that information out there. Okay. Any other questions? Seeing none. Thank you, Monica.
Thank you
Appreciate
all.
your time. Okay. I believe Jeremy Sykes would be next, who is with us. Yeah.
Good evening, everyone. Good morning, good evening. I'm sorry about my appearance. I am Jeremy Sykes. I am a Connecticut owner operator in the trucking industry. I am for the 1093 bill. I've been using this product for a while, alternative financing for a while. It provides the additional capital for my business that I need in order to continue to grow in slow seasons, whether that's getting me through payroll, a major breakdown. I own and operate several trucks, and in this industry, there's always something going on. And in recent years, I haven't really been able to get the funding that I've needed due to the legislation constraints that have been happening. Prior, I can get upwards of over $100,000, and in recent years, they've kind of scaled that back on me. The Connecticut lenders have kind of scaled that back on me to maybe $50,000. I love the product. The product it works. It is meant to use as quick infusions of cash for your business. And so long as a merchant is using the cash for the business and not anything else, then their business essentially will grow. And what I mean by that is I typically, fuel is one of the higher costs of my industry. If I get a $50,000 advance and 40 of that goes to fuel, and it all goes to fuel, which it does, a good portion of it goes to fuel, that $40,000 can make me $80,000 just off of that alone. The daily payments don't bother me. They do it in a meticulous way where it is affordable to my business. And they do that by assessing my cash flow and the cash flow of the business. And when they do that, They only take it out Monday through Friday. So any money I make on the weekends it's solely mine. The money, the product itself is such a great product, and the businesses that provide this product are so great because they work with you. Unlike a traditional bank, when I fall on hard times, a bank is far less likely to adjust my payment in some way, shape, or form. And for me, for this product, it's only a matter of a phone call. I pick up the phone call. I tell them whatever I'm going through for the moment. We'll go back and forth, and we'll come up with a new daily rate until my business picks back up to sustain the original payment. They constantly work with me, and there's no way I can default on this product unless I don't pick up the phone call. So I don't think there's any way any merchants can default on this product unless they simply stop paying and stop communicating with the lender. And that's the beauty of it. For me, the advantage for me is them being able to work with me. I do fall upon hard times sometimes, and I immediately pick the phone call up. They're very receptive of that phone call, and we work right through it. And I'm back up a month later, 2 months later.
Okay. Well, thank you. Question for you. What do you know about prejudgment remedy waivers?
I know it allows, if I were to default, it allows the lender to come in and essentially get a judgment on my bank account. I waive the right essentially to, I guess, like a trial or arbitration or some sort, where they can come in and rectify what they're owed.
Okay. And so why do you think that would help somebody like you have access to this product?
Because someone like me doesn't have any intentions on defaulting on the product. For me, if a PJR is something that I would have to sign in order to get this dollar amount that I fully intend on repaying, it's a no-brainer for me. I have no, again, the only way they're going to execute something of sort is if I completely just go off the map with them and stop paying.
Yep. Right. And to your point, yeah, it's easy not to worry about it if you know that it's never going to be a problem, if you're confident that everything's going to be good with your business and so forth. Is that provision in your contracts now? Are you aware?
Yes. Do I have a PGR in my contracts now? Is that what you're asking?
A PGR waiver? Yes.
Yes, I do.
Okay. So what's the average size of your advances? I mean, how much do you have out typically at any given time?
Well,
what's the maximum? Let me ask it that way.
Prior to, I would say, the last year or so, it's been about $120,000 I use roughly a year with them. This past year, it's only been about 50 grand.
Okay. All right. So this arguably wouldn't necessarily affect you. You wouldn't be subject. You're not supposed to be subject to the PJR waiver. Your contract, if it's under $250,000, is not supposed to have that waiver in it. So I guess, first of all, I'm a little curious about if yours does. But secondly, what we're talking about here is the limit. So under 250, where we have a bill that says we go to 100, that arguably wouldn't affect you anyway, unless you wanted to go over 100. So it doesn't affect your ability to get the product. I mean, I think what we're talking about today is that in the aggregate, it would help the lenders to do business, with more people and basically have less potential losses from bad loans. But that doesn't necessarily affect you. But I'm curious about what your contracts say, if in fact your contracts are legal.
Well,
under our relatively new law.
Well, I can tell you this. I'm not 100% sure if my current contract, which is currently out for $55,000 right now, I'm not 100% sure if it has that in it. I will tell you my previous contracts over 100 grand have had it in it.
Well, again, it depends on, because the implementation date is fairly recent. So if we're talking a few years back, then it very well may have had that, even if it was a small contract up to 100,000 or something like that.
I certainly would like more money. That's for sure.
Yeah, I hear you. I hear you. Actually, last question that I have is when you sign that contract or enter in, and I don't know if it's all electronic or if there's actual paper that you have to review every line or initial on pages or whatever, but what is it? Do you do it by advance, and does your contract have like an aggregate limit? So say you get an advance for 50,000, and then you want to go back and get another one. Do you understand that you have like an aggregate limit, or do you do it on like a sort of advance by advance basis when you're trying to figure out how much you need and how much sort of credit they're extending you?
Correct. I do it more on an advanced basis. I do know that when I do pay a certain percentage in, I am allowed to come back in and ask for more money, but those terms are not, the dollar amount is not specifically outlined what I can ask for. But what is outlined is when I get paid in up to 50%. When I get paid 50% in, I can come back in and ask for more money.
Okay, but is it sort of like a line of credit? Like they say, hey, you're approved for, 250, or you're approved for $500,000, and you say, okay, well, I only need an advance for 50, and then I can come back for another one, or no? It's
yes, it works like that as well. Yes. It really depends on the Connecticut limit that I go with. There are ones that have that structure where it's more of a line of credit. You're approved for $250,000. There's other lenders where they just say, hey, here's 50 grand. You're approved for 50 grand, no more, nothing less. I typically take the max dollar amount that's offered to me.
Okay. That's interesting too, because it occurs to me too that if they want to extend credit to you for up to $251,000, then they can avoid this provision, so that's interesting to hear that as well. Okay. I'm not sure if other committee members have questions. Did I see a hand? No?
You answered my question, Mr. Chair.
Okay. All right.
Question, I should say.
Very good. So I think that's that. We appreciate
Great. Thank you.
you joining us today.
Thank
Jeremy.
you. Thank you all.
Okay. Next on my list is Manuel Alvarez, who's with us online.
Good afternoon. Can you all hear me?
Yes, sir.
Great. Good afternoon, Representatives Doucette and Delnicki, Senator Miller, and honorable members of the Banking Committee. My name is Manny Alvarez, and I served as California Banking Commissioner from 2019 till 2022. During my tenure as commissioner, the California Banking Department started to see EWA products enter the marketplace. And at that time, the California legislature had also proposed a licensing bill for EWA products. That bill, however, did not pass, which left the banking department at the time in a bit of a lurch. How to regulate new financial products that didn't fit any existing regulatory frameworks within the state, while also serving critical market monitoring and consumer protection needs. The department solved this conundrum by entering into separate agreements, MOUs, which you've heard some folks reference earlier today, by entering into these separate agreements with some, but not all, of the EWA providers at the time. The advantage of this approach is that it allowed the banking department a modicum of oversight of the EWA product, but the approach lacked comprehensiveness or consistency from company to company. I offer this, and I offer the distillation of the following three observations in the event that it's useful or illustrative to the committee as you all deliberate the bill before you. Number one, EWA products do provide a lower cost alternative to payday, pawn, or other costly short-term liquidity solutions. There was obvious customer demand for EWA products, and some of the customer feedback, in fact, was that they preferred the philosophical framework of accessing funds that they had already earned as opposed to a payday or some other costlier alternative. It was my opinion as commissioner then, and it continues to be my opinion, that consumers ought to have choice and access to better short-term liquidity solutions. Second general observation I would share is EWA did not fit within our existing personal loan frameworks in California. One can always draw parallels between new and existing products, but the reality was that the emergent EWA product did not fit into any one of the existing regulatory frameworks without having to shove, the proverbial square peg into a round hole. And as such, it seemed important to the department at the time to adopt an agile regulatory approach, which is why we sought to enter into these MOUs, which again was good, but an imperfect approach. And the third and final observation I would share is consumer protections and rules of the road are necessary and very much achievable. I'm a proponent of consumer protection and financial literacy. I'm also a proponent of promoting ample choice and competition through robust consumer financial services marketplace. The MOUs that some of the EWA companies had entered into in California had the advantage, again, of affording the banking department some oversight. But the disadvantages were that they did not translate to universal rules of the road that might be achieved through a thoughtful legal framework. And with that, I'll conclude my remarks, and I appreciate the committee's time and happy to answer any questions related to my testimony.
Thank you, Mr. Alvarez. I appreciate you joining us. Where are you now? I assume you're still in California, or?
I reside in Sacramento. At the moment, I am in Los Angeles. Don't hold that against me.
Okay. And what are you doing now? Are you still in government, or are you?
I'm no longer in government. I advise and sit on various boards of financial services companies. So I sit on the board of the largest minority depository in the country. I advise other family offices and a variety of fintech companies. So my general ethos as a former attorney and now kind of strategic consultant is I am interested in product solutions and policy orientations that seek to expand quality access to financial products and services to underserved markets.
Okay, interesting. So what is the current state of play in California? We've had discussions over the last couple of years here in Connecticut, and California has come up, as have other states, and there's varied approaches, as you know. I understand, sort of the MOU model is what we're dealing with, it seems, in California. There was an attempt at a rulemaking, but it sounds like that rulemaking was not necessarily conclusive in terms of promulgating, regulations. Is that accurate? What is the current?
No, so the current state of play is that there has been a rulemaking, there's now a final EWA rule within California. So there is now a registration framework for the EWA product. So call it a more refined approach to the MOU Band-Aid that we applied back when. So the current state of play in California is there's no legal licensing framework, but there is, however, this new registration scheme with attendant consumer protections and market monitoring expectations, which were promulgated by my old department, the DFPI.
Right. And why do you think why do you think that was the result and not a licensing scheme and some actual metrics in terms of APR and so forth, like we're considering?
I will speak very candidly. It is my belief that a bill could not pass because there were too many stakeholders that could not coalesce around. There wasn't enough consensus, I think, to get a licensing bill across the finish line in California.
I hear you, man. I hear you. No, that's very interesting. Very interesting to hear. Okay. Any other questions for Mr. Alvarez? Representative Delnicki has.
Yeah, real simple question. You're talking about how California handled the EWA, and we've heard pro and con on the database. So where is it? We've heard that the database doesn't exist, and we've heard in conversation that it does. What's your opinion? Because I know when it comes up and people testify, hopefully on it, I'll be able to ask that question.
I appreciate the question. Unfortunately, I do have to confess a bit of ignorance on the question. I do not know if said database exists relative to the EWA industry. Certainly, to my knowledge, no such database exists at the state level, within the state banking department level, and I'm not necessarily aware. I am not aware of any kind of closed loop or any sort of database that exists within the EWA industry. I would offer this additional perspective. I don't pretend to be an engineer, but I do suspect I have no doubt that the technology exists, that the technology that would be needed to build such database exists. I don't think that is, that's not typically where problems emerge, in my opinion. Usually problems emerge around the attendant services and human capital needed to maintain a database and to, get data out of the database into some kind of reportable function. So in other words, what I'm trying to say is, I think it's important to remember that there are, of course, attendant costs in maintaining that database, whoever builds it, whoever maintains it. And so kind of the threshold question is, where does that responsibility reside, and who bears the cost?
That's an interesting take. It seems to me that it can cut both ways. The database would make all kinds of sense when it comes to somebody that might be abusing the EWA, and abusing is probably the wrong term, is addicted to use of the EWA versus somebody that isn't. But nonetheless, there needs to be some kind of check and balance there. And depending on what we've heard from state banking, it sounds like something's going to have to be there like that. Well, I certainly appreciate you coming online, and I hope you have a great day.
Thank you all. Appreciate it.
Okay, thank you. Okay, seeing no other questions. We are going to move on. I'm going to call next on John Barnes from Catalyst, who's number 27 on the list.
Good afternoon, Mr. Chair, members of the committee. Thank you for the opportunity to testify today. My name is John Barnes. I serve as the Vice President of Government Relations for Catalyst Regulatory and Compliance, also relevant today as one of the database companies. So greatly appreciate the opportunity to be a part of this conversation. For nearly 25 years, Catalyst has partnered with state financial regulators to implement real-time compliance solutions for non-banked consumer financial products. Today, only 27 states allow payday lending. We provide a statewide regulatory enforcement database in 14 of those states, ensuring that consumer protections are properly enforced while allowing responsible businesses to operate under established regulatory guidelines. Our experience working with small dollar lending regulation has proven that real-time transaction monitoring is one of the most effective and efficient tools for enforcing state law. In states that require lenders to use a centralized compliance system, every transaction must be checked against a database before it can be approved. This ensures that borrowers meet eligibility and prevents them from over-leveraging their next paycheck. This approach was developed out of necessity in 2001, where Florida legislators faced a growing problem. Consumers were borrowing from multiple providers simultaneously, all without the providers having any visibility into what the consumer had already advanced. The same issue you all have been talking about here today. To solve this problem, Florida decided they needed a centralized database enforcement tool and a real-time compliance database, a system that now has been adopted by 13 other states, such as Washington, Nevada, Indiana, Illinois, Delaware, and many others. We are now seeing and hearing about some of the overextension concerns that are emerging in earned wage access. Many providers operate independently, meaning they have no way to know how much a worker has already borrowed from another provider. Without real-time tracking, someone could take multiple advances from different providers within the same pay period, and none of these providers would have any way of knowing that that part of the paycheck has already been committed elsewhere. Reports from the California DFPI, who just testified, the Center of Responsible Lending, who spoke earlier, have highlighted these. They've confirmed it. In California, the average consumer took out 36 of these a year and went as high as 100 in 1 year. A statewide database would allow Connecticut to address these issues without imposing burdensome restrictions on EWA providers. This type of database ensures compliance at the point of issuance, preventing transactions that would violate state borrowing limits. At the same time, it respects consumer privacy, as it does not report to credit agencies, does not collect creditworthiness or determine creditworthiness. Only the regulator has access to the full transaction history, providing real-time insights into lending activity while allowing for efficient audits, fraud detection, and streamlined enforcement. As Connecticut's evaluating options for regulating EWA, a real-time compliance database is one tool that has already proven effective in similar markets, preventing overextension, keeping bad actors out of the state, and ensuring that EWA remains a responsible financial tool rather than a form of unregulated short-term lending. Thank you for your time and consideration. That was pretty good. We did good. And I welcome any questions.
Very good. Very good. Thank you. So we've heard some testimony today that products like yours aren't currently used in the EWA space. So I'm assuming what you're referring to in the states, you say that you're providing the product is with respect to what we call traditional payday lending. Is that?
That's a great question. So to my understanding, 5 states out of 50 have passed legislation around regulating earned wage access. I believe the first one was 2 years ago. So in the last 2 years, in those 5 states that have done this, none have taken on the database yet. As was mentioned earlier, Washington has advanced database legislation out of the Senate committee. There's database legislation introduced in Kentucky and some other states. But to your question, right now, of the 5 states that passed EWA legislation, none of them had a database enforcement mechanism in there.
Tell me then how your product, your company's been around a while.
Absolutely. So
Florida is basically being the first.
Florida was the first. Yes, Florida was the first in 2002. Alabama, Kentucky, Illinois, Washington State. All of these states have different requirements. So some states you can only, Washington, you can only have out 8 small dollar loans at one time. All year. Florida, you can only have out 2 at a time. So what the database does is, again, and the way it could work with earned wage access providers, it's a simple API mechanism. The technology has been, like someone mentioned earlier, we are a technology company. This is what we do. We've actually spoken with providers from the direct consumer side and the employer integrated side about ways our technology could work for what they provide. And so, again, it's a simple interface into the API, and it would collect the data that you, the legislature, would provide. So whether that be some sort of unique identifier, some states use social security numbers, some states use other unique identifiers. But the main point being to make sure that John Barnes taking out one from here, it runs into the database before the transaction happens again to ensure it doesn't take out over 1,000 or $1,000 limit or three advances, whatever it might be.
Going to be my next question. What data would you have to collect? So we've heard it said that these providers currently don't collect social security numbers. So is there some other data point that can be used to create that unique identifier? How would you envision this working if we didn't want to change the data that we were forcing the providers to collect?
Yeah, great question. So in Virginia, they don't use social security numbers. We operate the database there. The state banking department came up with some sort of unique identifier. We'd work with the department on that. But basically, in the legislation, it could be saying that a unique identifier as determined by the state banking department, for this proper enforcement of the regulatory compliance. I would like to say too that 20 5 years ago when we were having these conversations, the lenders were concerned and there wasn't a need for this. And, there's all these other ways that they're already self-reporting. And I think a big thing is when the data shows you what we've seen out of California, what the Center for Responsible Lending saw, we're not opposed to, EWA. That's for you all to decide. But the matter of if you have a concern of stacking, if you have a concern of people taking more than just one at a time or from multiple providers, it's not something that you can ask the industry to do themselves. I mean, you've got to have that, non-biased third party who reports directly to the DFI or the state banking department in this case.
Senator Miller has a question.
Yes, and if I sneeze, excuse me, because it's right there. Thank you for testifying. I have a couple questions. Someone testified before you and they talked about cost. And so how much is it per transaction?
Yeah, great question. So that is something that is determined from each state. That ranges from less than a dollar historically. Some states go up to $3 for this small dollar lending product. But again, that is something that there's no set price. There's not a $3 set price, or someone said $2.25. I can't negotiate what the price is here today, but it could be less than $1. That would be something that if we were, fortunate enough to, get a bid on, that's when we do those conversations with the state banking departments.
Okay, so I did hear you correctly that it's the state that collects the data.
Oh, sorry. I'm so sorry. I thought you asked about cost.
No, I did. No, because it goes back to when you
sure,
said that's
sure.
not something you control and is up to the states. Because I heard you say the legislature collects the data when you don't do that.
No. I apologize. So every state is different. Some states have written into law what the fee would be. Some states have done it by rule or order. And so as far as the data goes, we are a cloud-based system. We collect the data, but we only release that data to the regulator. And I know I shouldn't say it, and I hope that no one from our company is watching, but 25 years, we've never, and so we haven't had a breach. We haven't been hacked. Nothing like that has ever happened. And so this is what we do. We're a regulatory support company. We take data privacy and data security very seriously.
So who monitors the number of loans that are taken at one time?
Yeah, it's a great question. Thank you so much. So it's kind of like a traffic light is how the best way to think of the database. So if John Barnes was going to take out an EWA advance, and let's say that there was a limit of $1,000 and I'd already taken an advance from store A, I go on to get it from store B for another $1,000. If they are using our database, it would not allow store B to offer that advance. The system would automatically, because of that unique identifier, it would automatically stop the transaction from happening. The provider would be sent a note, hey, John Barnes was denied. It would not say who I already took an advance from. It would not say how much I took an advance out for. But again, if the only rule was that you couldn't have more than $1,000 out of time, I mean, the provider could figure out that it was $1,000. But a lot of the states where we operate in, there's 5 or 6 different, you can't take out more than 25% of your gross monthly income. You can't have out more than 3 advances. You can't have out more than a certain amount. So to answer the question, Senator, the database does that in real time. So, we heard earlier from one of the providers talking about how their system is in real time. That's fantastic. That is exactly the way the technology needs to be. Our same system in that API. As soon as they update that, John Barnes took one out, the database sees it in the exact same real time.
So your contract is with the state?
Yes, Senator. Every state's different, but yes.
Give me an example of how they differ.
Well, our contracts with the state. So, for example, some states it's through we've done the RFP process. Some states have said, hey, these are the providers who the state has recognized as, I don't want to misquote the terminology they've used, but certified providers. And then you report directly to, it's still always with the state. It's always usually with the Department of Financial Institutions, the state banking department, whatever their equivalent might be across the country. But our contracts are with the states, not with the providers.
Okay. And that's so is there an infrastructure set up for this product? with the state? Because now it seems like it's a cost to the state to maintain this.
Oh, no, thank you so much, Senator. No, there's zero cost to the state. So that's where the cost, it's a per transaction cost. There's no cost to the state to set up the program. There's no cost to run the program. In fact, it's a cost saving mechanism for the state because the state is able to use less FTEs because it's all virtually right there. So the state, instead of having, now I guess EWA is a little bit different. Historically, all the providers have brick and mortars. I don't believe there's any brick and mortar EWA stores in Connecticut, but historically, there's been the brick and mortar. So this still provides the regulator that efficiency of being able to go in. They can run reports. We've got dashboards for the regulator. We've got data sets. All of this is completely cost-free to the state, making their job easier to identify fraudulent behavior or bad actors in the space.
So then the consumer bears the cost?
Great question. Every state is different. Some states, the consumer pays the cost. Some states, the provider pays the cost. That is something that would be established by rule, order, or, in the state law saying that, this cost can't be passed on to the consumer or this cost can be passed on.
So if you could, I would appreciate it if you could send us a summary of the different states that you serve and what that framework looks like.
Absolutely.
So whether it's with the state, it's the state bears the cost, the provider bears the cost. But if you could do that, I would really appreciate it because it just seems like it's interesting, and I'm missing a couple pieces. I'm trying to connect the dots. And
no problem. Yeah. So again, just to totally clarify, the 14 states, there are some situations where the consumer pays, some situations where the licensee pays, and then there's a few states where they have passed, they actually do the funding instead because they want the service. So you could technically do that, but in the majority of it, it's a service that's paid by either the consumer or by the lender.
So one last question, Mr. Chair, if I may. So the licensee pays, how does that look? What does that look like?
Yeah, so great question. It's directly, again, the technology and people much smarter than me through the API process. So when there's the data fields, if the licensee is paying it and it's it's a 50-cent fee, they would just we bill the licensee at the end of the month the total number of transactions that they put out on the database. If a transaction is denied or canceled, it wouldn't be charged. In EWA, they offer, I believe, there's the free option. If there was a free advance, there would be no database fee on that. So that honoring the way that the providers try to offer that free option, we would be doing that as well.
Well, I would just be interested to know, in the states that you do serve, who bears the cost? So whether it's the licensee, the state, or the consumer. So
Yeah,
if you wouldn't mind just sending us a list of that, I would really appreciate it. Just a list.
Happy to do that, Senator. No
Thank
problem.
you very much. And really appreciate you bringing, being here today to testify.
No,
and
thank
making
you.
us aware of this product.
Thank you for the opportunity.
Thank you, Mr. Chair.
Rep. Delnicki.
Thank you, Mr. Chair. So we've unequivocally proven that there are databases out there, operational.
100%. There are operational databases out there that provide a very similar service. So there's no confusion of the 5 states that have passed legislation for earned wage access products. They have not put a database in them as of March 4th.
And these databases are not hackable because there's a unique identifier that for the individual users of EWAs, regardless of which EWA they go to?
Yeah, so Representative, again, people much smarter than me, they would never want to say nothing is, but to answer your question, it's a very similar structure to what we've been doing for 25 years. And for 25 years, we have not been hacked.
Kind of like what an access database in the old days we used to use. Unique identifiers, unique tables.
Correct. Yeah, I mean, that's, it's the main point of being able to, we want as little information out there as possible. I know the EWA providers do the same thing. They're incredibly careful with the consumer's information, but they have to have ways to identify them as well, whether that's through the payroll systems on the provider, on the employer integrated side, on the direct to consumer side, they've got ways that they do it. And so writing it as a unique identifier would allow everyone to come to the table to discuss the best way to do that.
And let's say I was going to EWAs, a number of them, that would raise a flag with the database, and would the database somehow communicate to the EWA provider that Representative Delnicki should not get any EWA advance based on what's going on?
Well, Representative, the way you write the law would determine that. So again, I'm just trying to use simple things. If you said there was $1,000 limit and Representative Delnicki tried to take out 1,001, you get a red flag. Now, if you try to get it from a certain provider, they would say Representative Delnicki, tried to take out more than allowed by state law. So if you re-entered it for 1,000, they would let you. But then if you ran over to John Barnes's shop and you tried to do it, you get a flag, and not just a flag. I mean, you would be denied. The only way you could get an advance would be circumventing state law with this database in place.
So basically it covers the issue of people taking out too many EWAs, going to too many companies, actually endangering their own credit rating on what's going on, all with a unique identifier so that it couldn't be hacked. And it is operational, as you say, in Florida and a number of other states.
That's correct, Representative. 13 other states. And it provides the regulator with a dashboard that has clear transparency. So there's no longer a question of how many of these are out in Connecticut, where are they coming from, who's using them. The regulator will be able to see company by company, provider by provider, exactly what the answer is there, and transparency, which is critical for the success of this industry.
And last question on how this all works. So it gives a go, no go to the EWA provider?
That's correct. And so that it protects the EWA providers as well, because then they don't have to worry about accidentally, advancing someone who would be out of compliance with state law. So it protects the consumers from over advancing. It protects the providers from, accidentally breaking state law or regulation. And it helps ensure that, while we heard earlier, it's non-recourse, and I think someone said 97% of the advances are repaid, it still will help cut down on, folks taking out advances who might not be able to repay the product.
Well, thank you for coming forward. And it's nice to know that we have a product available that could actually meet the needs going on here. And I suspect that I'm not taking business away from you, but I suspect there may be other companies that can actually do that also.
Listen, competition only makes people better. So we appreciate, the opportunity to be here today, and we appreciate the time of the committee.
Well, I appreciate all your comments and the information you provided us, and actually address some concerns that were expressed by other speakers. Thank you, Mr. Chair.
Senator Miller, have one follow-up?
Yes, please. So Representative Delnicki had asked the question that I wanted to ask, and I don't think I didn't really hear you give an answer. So are there other companies that provide this product?
So there are hundreds of companies that provide real-time databases. As far as again, I know, like we said, no one is offering this in EWA right now. There have been other competitors in the space on the small dollar lending side, the non-bank consumer credit space. Yes.
All right. So yeah, so that's what I'm asking, just in the space that you're in, the small lending, I'll say payday loans. So in that space. So they are.
Yes, Senator. There have been other companies that have historically provided this service as well.
And so, and you answered my second question, whether if you knew of any companies that's trying to develop this product for EWAs.
So to clarify on your first question, I want to be crystal clear. We are, we think we're the best. Okay.
I was going to say you're the best. Yeah.
We're proud of our record. We are in the 14 states that allow this. We are the provider in those 14 states. As far as this space, I would imagine that as volume continues to come out and show the tens of millions of advances that are being done in states across the country, my guess is there probably will be more providers who want to step up and help, regulate and help protect consumers and support healthy marketplaces.
All right. I just didn't know if you had the monopoly on that type of product that you offer. So, but that's all, Representative. It's late. It's getting late.
Senator Walker, no, I
Representative.
completely understand.
Thank you, Representative Doucette, and thank you for being here today. We really do appreciate the insight that you provided.
Senator Walker, thank you so much. We will get those answers to you, and thank you to all the members of the committee. We will be putting a written statement online. If it's not there yet, I apologize. And any additional comments or questions that you may have, please don't hesitate. We look forward to continued trying to be a solution to this as we go through the process.
Okay, thank you.
Thank you
for
so
joining
much.
us. Safe travels. Okay, where were we? We had John Carroll. Yes, John Carroll. Another John is online with us. Hi, John.
How's it going, guys?
Thanks for your patience. Thanks for joining
No problem.
us.
Yeah, of course.
And that's a beautiful palm tree you have in
Thank
the
you.
background there.
So,
you must be in Southern Connecticut, real far.
I'm in Miami. I'm in Miami right now, but our headquarters is based in Connecticut.
Okay, thank you. Please proceed. You can.
So I just wanted to touch on something that I've been hearing throughout in regards to this about the sophistication of the borrower. I came from traditional banking. I was a financial advisor for Bank of America Merrill Lynch, and then I moved into this space about 6 or 7 years ago. And the perception that all these people that are taking these merchant cash advances that are not bankable, they can't go to the traditional banks, that's just simply not true. Almost all of them can go to traditional banks. 75% of the time, like a Bank of America, Chase, Seacoast Bank in Florida, they are the senior lender on all these accounts, whether it's a line of credit, an SBA. So it's not that like these borrowers are not sophisticated. Where the merchant cash advance companies come in are in the cases where the banks fall short. For I'll use the construction industry for example. Say you have the opportunity to get this contract on a huge job, but you need the money for materials, labor, etc. You can't go to Bank of America. You can't go to Chase and say, I need this by Friday. And that's basically where these come in. And we're basically offering financial products to the same customers as a Bank of America or Chase. But we just have limited protections, and which basically, and the PJR is something that basically prevents us from fraud. So in Miami, where we originally located, we actually moved our headquarters from Miami to Connecticut because of the PJR, just because there's really no protection in the merchant cash advance space for fraud because it's uncollateralized. Like banks have their own remedies and other stuff like that. But when it comes to merchant cash advance, because it's uncollateralized, we can't do the things that banks can do. And when typically we go for a judgment or there's a case of fraud, yes, we can sue, we can do all that. But everybody knows how long those cases can take. And then and most of the time without the PJR, the defendant doesn't even show up. And we usually get a judgment for them not showing up. And then we try to collect on the judgment, but by that time, the money's already gone. And like taking away this remedy or this PJR isn't going to protect anybody. It's just going to limit the amount of people that can take advantage of these MCAs, because the people under that limit may they're just not going to get them. Like it's not like, and to touch on something that you guys were talking about earlier that you were asking in regards to our contracts, all of our contracts, at least the legal ones and mine in particular, we list the prejudgment remedy on all of them. And it's the law, the waiver, all that, and it lists 250 and above, blah, blah, blah. But regardless of the amount, whether it's 50K, 250K, it's always on there. But obviously the amount is whether or not we can use that.
Okay, thank you. And that I appreciate answering that question that came up earlier. And thanks for sticking around with us and listening.
Yeah, of course, no problem.
Any questions for John? No? Seeing none? Thanks for joining us.
Of course, yeah.
Okay, Lucas Rockland next. Lucas is here. Hi, Lucas.
Hi, how are you?
Thanks for hanging in with us.
Of course. Good afternoon. Thank you for allowing me to speak today. My name is Lucas Rockland. I'm an attorney at the law firm Newbert, Pepe, and Monteith. My practice is commercial litigation, and among the clients of our firm are companies that provide merchant cash advance financing. I'm here today to speak in support of Committee Bill 1093. This bill aims to amend Connecticut Statute 36A-868 to better balance the interests of MCA funders and the businesses that rely on MCA financing. It does this by allowing the use of prejudgment remedy waivers in MCA agreements if the amount of financing is more than $100,000, while on the other hand, continuing to restrict the use of prejudgment remedy waivers in MCA agreements when the amount of financing is $100,000 or less. Approximately 15 to 20% of all MCA transactions involve financing amounts exceeding $100,000, meaning that this bill would only affect approximately 15 to 20% of MCA transactions. The remaining 80 to 85% of all MCA transactions involve financing of $100,000 or less. The proposed bill would continue to restrict the use of PGR waivers in these agreements. Significantly, the businesses that can qualify for six-figure MCA financing are by definition larger, more sophisticated businesses that have substantial annual revenues. The committee may have recalled testimony earlier today that a business may need to have 7 figures of annual revenue to qualify for such amount of financing. At bottom, MCA agreements are commercial transactions. They are not consumer transactions. Commercial parties should have the freedom to contract. Businesses approved for MCA financing over $100,000 are larger, more sophisticated businesses. These businesses have access to legal counsel, negotiate terms, and do and should understand the terms of MCA agreements, including the implications of PGR waivers. Increased access to capital, allowing PGR waivers for advances over $100,000 reduces recovery risk to MCA funders and thus encourages funders to provide more favorable terms and lower rates to merchants as their risks are better managed. Conversely, without the waivers for larger advances, MCA funders may tighten underwriting standards or raise rates to offset risk, limiting businesses' access to capital. Competitive advantage for Connecticut. Allowing PGR waivers for larger advancers helps maintain Connecticut's appeal as a jurisdiction for commercial lending, attracting more capital into the state. Connecticut's PGR laws are unique. MCA funders have moved into Connecticut due to these unique laws that are favorable to the creditor industry. This influx has brought revenue and has benefited Connecticut. This committee bill will responsibly continue Connecticut's attractiveness to MCA funders. I will mention that many states have unique and favorable laws designed to attract specific industries. Delaware, for example, attracts corporations and financial services with business-friendly regulations. Nevada attracts the gambling and entertainment industries. Texas attracts energy industry through industry-friendly policies. California attracts technology and firm industries through tax incentives. South Dakota attracts lenders by having no usury laws. I'll mention Citibank has their credit card operations there. I'd like to reserve the rest of my time to respond to Senator Representative Attorney Jacobson. He spoke earlier today. He was very critical of the MCA industry in general and use of PGR laws. I'm also the attorney on the other side of the case that he mentioned. If you have any questions, I'd be happy to answer that. With respect to the MCA industry, this is not a new financial product. This product goes back to early 2000s. It was spawned by the need to provide a more accessible financing option than traditional loans. It's quicker, it's less paperwork. In an MCA transaction, the funder purchases a revenue of the business's future. It purchases a percentage of the business's future revenue. I see that my time is up. Am I going to be cut off here, or should I just wait to questions if there are any?
I have a couple questions.
Sure.
So you can summarize your thought, or we can get into questions.
Your preference.
Okay. Well, thank you. You did touch on a couple things that I did want to ask you about.
Sure.
And I take your point because it's come to mind repeatedly about different states serving different industries. Query whether or not that's one that we necessarily want to be in the business of, or whether it sort of happens by accident. In this case, it may be just a creature of our, PJR statute and the way it reads. But I did want to ask you about the actual practice, and I did want to ask you about Representative Jacobson said a lot of things. I am not a litigator myself, so in terms of procedure, one of the things he mentioned was the actual PJR application and the execution. He made reference to, and I don't know if it was the actual case that you were involved in, where the actual application or was held before it was returned to court. So the execution was served, but the application and the underlying summons and complaint was held for a longer period of time than he thought was appropriate. Can you comment on that?
Yes, yeah, I would be happy to. Just initially, I'm a little bit uncomfortable commenting on a pending case. I will briefly mention, though, that Attorney Jacobson neglected to inform this body that the most recent decision in that case came after a half-a-day evidentiary hearing at which our client testified, his client testified, and the court issued a 10-page written decision finding the conduct of our client to be permissible, that we have a valid claim, didn't find any wrongdoing whatsoever. So I disagree with his representation, although I do think it's somewhat inappropriate to comment on a pending action. With respect to the process itself, Connecticut statute requires that when you start a lawsuit, you choose what's called a return date. That's the date that triggers the date by which the opposition needs to appear and file an answer, etc. That date is set by statute. It can be no more than 2 months from the date of the complaint. Okay. The statute requires that service of that complaint be served on the defendants no less than 12 days before that return date. And then the action must be returned to court no less than 6 days before the return date. There are no other obligations. In the case that we have together, that Attorney Jacobson, and by the way, we talk, we are friendly. I have nothing but fond things to say about him, so I want that to be clear. I think he's a good person and a good attorney, and I'm sure if we went out for a cup of coffee, we'd be fast friends. In our case, we returned it back to court 20 days earlier than the return date, much quicker. There may have been an implication that we purposely didn't return it as a leverage or gamesmanship. I disagree with that. That's not what happened here. Furthermore, we complied with the law. Again, the law requires you to serve 12 days before the return date and to return it to court no less than 6 days before the return date. Both those obligations were done. The court found that to be the case.
Is there a different rule for, and again, forgive me, I'm not a litigator, for executions and PJR applications?
There is not. If that were a concern of this body, I think it would be entirely appropriate if we were trying to balance out competing interests in this industry, that we could potentially build into this bill that if you're going to use an ex parte commercial waiver or an MCA transaction, that the return date can be no more than, for example, 4 weeks. That would require that it would be returned to court much quicker, or that it be returned to court earlier than 6 days before the return date. There is no such requirement right now, but I can envision one that I think would be mutually beneficial and acceptable to both parties in the transaction.
Okay. So what's your practice now, and has it changed since the new law took effect with respect to the service and the actual execution as part of the
yes,
prejudgment remedy?
That's a great question. So anecdotally, I would say that the influx of business coming into Connecticut has slowed down. The MCA industry has, the growth has stopped or receded. It would be my impression. A lot of the business coming to Connecticut was due to this favorable PJR laws. There's been some discussion about. So I do think it has slowed. And maybe the growth has receded as a result. I know that relatedly, there's some issues or questions about residency requirements. Who are these companies? Are they really located in Connecticut? The MCA companies are suing parties all around the country. why does that happen? Is that okay? And I don't know if this body is a concern. I'm happy to address some of those issues if that was. I heard some of those concerns being raised, but essentially, there is an embedded process for a lawsuit to be maintained in Connecticut. Connecticut has to have what's called personal jurisdiction over the defendants in the action, which means Connecticut has to have like a nexus. Connecticut has to have some dog in the fight, for lack of a better word. And the way that's established is that in this instance, or in any instance, before a lot of this litigation occurs in New York as well. The analysis is the exact same, whether the MCA lawsuit's filed in New York or in Connecticut. But you have a company that is required to be registered in Connecticut. They're required to have a Connecticut address. Their contract has a Connecticut forum selection clause and Connecticut venue clause. The MCA funders will put on their website that they're a business that operates in Connecticut. These MCA funding companies, before they provide the advance to the recipient, the merchant, they almost all do what's called a pre-funding recorded call where they go over the material terms and conditions. We have advised our clients to inform the other side that they're a business, an MCA business, including that has office in Connecticut. As a result, Connecticut law applies. So in other words, if there's a default, the whole idea is to inform the other side they shouldn't be surprised if there's a lawsuit, and that lawsuit would occur in Connecticut. Any sort of business that does business nationally isn't going to have attorneys in all 50 states. Rather, they're going to centralize litigation in one state, and frankly, they'll do it in a state that they believe to be friendly. They have friendly laws to their industry. So with respect to the prejudgment remedy in commercial waiver, the prejudgment remedy laws in Connecticut under the current statutory scheme have existed since the early 70s. They've been shown time and time again to be past constitutionality. There is a fair high bar. You have to, the defendant has to sign a contract that has a clear, unambiguous waiver. It has to be commercial transaction, cannot be consumer transaction. The plaintiff must file an affidavit saying that they have probable cause that they're going to likely win the ultimate collection matter. Connecticut attorney must review and approve it. You have to engage a marshal and pay court filing fees. Just the cost alone to attempt an attachment can be approximately $2,000. If assets are attached, defendants have due process rights. The plaintiff is required to serve them with court forms, including a one-page document where they can check a box saying they dispute it. They file it with the court. The court's obligated and does immediately hold a hearing to determine whether the attachment should be dissolved, modified, whether the plaintiff should post a bond, et cetera. So there's all sorts of procedural safeguards in place right now.
And so you're currently only doing that in cases where the underlying debt is 250 or more, correct?
Yeah, the statute right now permits use of the prejudgment remedy waiver upon commencing an action if the amount of financing is more than $250,000.
Right. And we heard a little testimony earlier about what the contracts actually say, and it sounds like most of, and I don't know if you probably are not involved in or you may be involved in the drafting of the contracts for your clients as well, but it sounds like they have sort of a catch-all saying where they'll throw the prejudgment remedy waiver in there with the caveat that if this only applies if the advances are above 250. Is that your understanding?
I think that's accurate. The statute speaks more about the enforcement. So I mean, many contracts in many industries have all sorts of provisions that are unenforceable, et cetera. Doesn't make the rest of the contract unenforceable. I do some landlord housing law, and sometimes you'll see in lease agreements that if the tenant defaults, then the landlord can throw them out and do all sorts of things that are legal. It doesn't mean the rest of the contract is. So it's less about what the language says about what are the parties to do with that language. They try to enforce something that's unenforceable, I think would be the primary concern.
Okay. All right. Other questions for Attorney Rockland? Any? Seeing none.
I appreciate everyone for their time and attention. Thank you very much.
Thanks for sticking with us. Okay. Diana Koch.
Hello, how are you?
Hi, how are you?
Thank you so much for giving me the opportunity to speak today. My name is Diana Koch. I'm the Executive Funding Manager at Funders Group LLC, and we are an MCA company dedicated to helping small businesses access the funding they need when traditional financial institutions, like banks, are unwilling or unable to assist. And we specialize in providing these merchant cash advances to the businesses that cannot secure financing through these other traditional methods. And because we operate in such a highly risky environment, unlike traditional loans, we essentially enter into a partnership with the business owner, which means that if the business fails, our ability to recover the funds is limited, unlike the standard loan structures. And this industry is unique because it is a flexible and adaptive solution for businesses facing financial difficulties or seasonal fluctuations. And I'm here to offer strong support for Bill 1093, which proposes a crucial change to the existing legal framework regarding the PJR process for financial transactions. And as a funder in Connecticut, where we are based out of, we've seen a significant reduction in our ability to assist these small businesses due to the near elimination of the PJR remedy. And this resulted in a lot fewer opportunities for us to provide funding to deserving businesses. And I think that this proposed adjustment, which allows the use of the PJR for transactions exceeding $100,000, is a very fair compromise, as was stated from previous testimony. And this will provide us with the necessary flexibility to offer much needed financial support to small businesses and big businesses, in which many cases are unable to secure any other types of traditional financing. And I think it's important to note that businesses receiving MCA funding of this magnitude, like I said before, are not small, non-bankable businesses. These are businesses that either have a high amount of revenue, or even if they have a small amount of revenue, just to qualify for such funding, they must provide very detailed bank statements and financial documentation to prove their ability to repay the advance. And that means that these small businesses benefiting from these amounts are generally larger or on the larger scale, and they're more stable entities that are still excluded from traditional bank financing. And this Connecticut PJR process is particularly well suited for high-risk financial transactions like merchant cash advances, because they help ensure that we can recover funds if a business defaults, particularly when debtors attempt to move or hide funds after a default. So in our case, defaults only occur when a business intentionally prevents us from obtaining necessary financial information to adjust their payments, which was talked about also before in previous testimony with the reconciliation process. We as funders want to be able to work with small businesses to give them this funding to continue to operate. We know that in America, we run on small businesses. This is how people make money. And so we want to be able to give any type of remedy to these small business owners to continue continue working. And if they're unable to meet these requirements, we do a reconciliation process where we update their revenue, and we basically go off of the flow of how the revenue is. If they're not making money, we lower their payments, and if they are making more money, they stay on their continued payments. And if a merchant, for example, operates as a seasonal business, like landscaping or something like that, where there's a slow period, where there's no receivables, the MCA contract that we have specifically in our contract allows for these payment adjustments, which helps the small businesses. However, this requires,
your time has elapsed. You can briefly summarize and may have some questions.
Yes, just one point that I wanted to make is a lot of the other people that were testifying were talking about, you were asking them if they were in Connecticut or not. And I want to say that one of the decisions we've made as a company is to choose one state, in this case, Connecticut. And you might ask why. And the reality is that it's simply impractical to have 50 lawyers each stationed in every state where we operate, which is not cost effective for us, and more importantly, doesn't serve the best interest of our company or our clients.
Okay. Thank you. And that I was going to ask that and we've covered a lot of ground today, and I appreciate your patience and sticking around. Yeah, I was going to ask where you were, and I also, we haven't really covered this because it's not, specifically within the domains of this bill, but I'm curious your thoughts on Connecticut's regulatory framework right now. We have sort of a registration framework. We don't require like a full licensing scheme. And I wonder how you find our regulatory framework, and if there are any other states that that are sort of more onerous, or if there are states where you have to be fully licensed. What can you tell me about that?
Well, I know that in Connecticut, there is the NMLS, which is the banking commissioner on which you register your company in order to do banking in that state. And so we do business in all 50 states, but Connecticut is the one state that we chose and for our form selection clause to be able to be fully licensed and do all our business in. And so I know other states have different types of licensing requirements, but Connecticut seems to be the best place to operate in terms of these type of agreements.
Okay. And that was one thought I had as we're talking about the PJR. That's something that's unique to Connecticut. But then on the other hand, when we're talking about a regulatory framework, which we discussed pretty in depth in this committee 2 years ago, we opted to actually go for something a little lighter because the industry was telling us that what we were proposing at that time would be way too onerous and would kind of make us an outlier. So it's sort of a trade-off, I guess. If we've talked about different states being a great venue for different industries. If we wanted to go that way, it seems to me that we would also have to revisit our regulations and look at things like calculating an APR, which we currently don't do now.
Right.
But it's an interesting
And just wanted to point out what Senator Miller said previously. She said, we are trying to adapt as the industry adapts and as life goes on and as we make all these, new transactional banking requirements, we're trying to adapt to the industry as well as the small business owners. And that's why I think merchant cash advances are very important now, because there are businesses that cannot go to banks to get these small loans, and their only other choice is to close their business. And so as much as there are problems in the MCA space, which is merchant cash advance, I think that there are also a lot of good companies that are trying to help small businesses really thrive and do what they started to do, which is to be a small business in America.
Right. And that brings out again another point that we kind of discussed, like the whole trade-offs within the sort of internal conflicts as we have this discussion, that those companies that are sort of harder to help and are outside the traditional banking system, perhaps in my mind, from a consumer protection standpoint, it need a little bit more protection. And the commercial waivers exist for commercial transactions with sophisticated borrowers getting financing from traditional financial institutions, which are heavily regulated. So what we're talking about here is something a little different. So again, we keep coming back to that point. I think we've got to consider that as well. But
absolutely,
Miller has a question.
Thank you. Thank you for joining us today. I had a couple of questions. In your testimony, you made the comment that at the level of $100,000 and above, the use of the PJR will allow us to better protect against those small businesses that might attempt to take advantage of the transaction. So can you explain that a little more?
Are you talking about the for small businesses that take out over $100,000?
Right. This was in your testimony.
Oh, in the written testimony.
Right. Mm-hmm.
Okay. So, basically the way that it's structured now is if a business takes out more than a certain amount of money, right, there is a certain regulatory kind of provision that they have to abide by. And I think, I don't know, I don't have much knowledge in terms of, past PJR and how it kind of evolved, but I know that businesses who take out this money now, whenever a merchant cash advance tries to go to litigate, we're having a harder time in getting that money back because of the provision. And so I think that's why it's important for the PJR to be for these types of high risk transactions.
So I know you said that that you're in Connecticut, so you don't do business in California at all?
We have done businesses in California, and as you know, there are the disclosures that we send out for any type of business or funding that we do in California, which, like was said previously, I think is a great asset to this type of industry, the disclosures, because it really gives the merchant a transparent view of the money that they're taking and their financing, so they can feel safe and secure in the money that they're getting and the money that they're paying back. And just back to the note of the level of 100,000 or above, the use of the PJR allows us to better protect those small businesses, like you said, that might take advantage of the transaction. But without the PJR, the businesses that need financial assistance will be negatively impacted. And so, we want to help everybody, but we also want to protect ourselves as well.
Oh, okay. Thank you for that. Everyone has said that's come before us in the testifying in support of this bill, said that in their organizations, their MCAs have said that they were in their businesses here in the state. So we know you have to register in order to do the business.
Yes.
In order to proceed with your remedies. So when I Googled your name, a couple things popped up. So one of the things that popped up is an address in Florida. And the other was a court case in, I believe, DC, because it stopped me, but I could catch DC, that says that you did business as Credible Advance.
I can't speak to that. I will say that we have an office in Florida as well, where we are registered in, but we are also registered as an entity in Connecticut. As to the court case, I can't speak to that because I was not at the company during that time. I'm not really sure, and I don't want to misspeak. But I also just want to, I do have a law degree. I've been trying to get more into the legal space of the MCA field. So when I joined this company, I started off in a different position, and now I am pursuing a more legal approach at this company. So I will be learning more about whatever cases, but I don't have any information on that case specifically right now.
So where is the company physically located?
So we have an office in Connecticut in Stamford.
Okay, you have an office, but
yes.
Where is the main office?
Florida.
It is Florida. Okay.
Yeah.
All right. That's what I needed to know. Okay. So your company has basically done what other companies have done, is they've just set up shop here. So
I'm in the Connecticut office, and I have my other team members in the Florida office as well.
Okay. And do you live in Connecticut?
Yes.
Okay. All right. Well, thank you, Mr. Chair, for allowing me to ask my questions. And is it Koch or Coke?
Koch.
Koch, thank you for being here today.
Thank you so much for having me.
Thanks, Diana. Don't see any further questions. Appreciate your patience.
Thank you.
Okay. Next on to Gideon Rothschild, who's online with us.
Good afternoon, and thank you, Representative Doucette and Senator Miller and members of the Banking Committee. I'm here to encourage support for Senate Bill number 1399, an act concerning limited purpose trust companies. I've been a practicing trust and estates lawyer for over 40 years and retired recently to my permanent residence here now in Connecticut, which I love after being in New York for 40 years. I am a trustee in my individual capacity for a number of my clients, my past estate planning clients. And as a trustee, I began to think, well, why doesn't Connecticut have, I would prefer to act in as a trust company. And the reasons for that, in the brief amount of time we have, are basically to allow for continuity, so that the beneficiaries don't have to seek a successor trustee should something happen to me, die, resign, a disability, what have you. We don't have to go to probate court to get another trustee appointment, but rather, if a trust company were designated in the trust instruments, that trust company would continue on indefinitely, and it would presumably have a board of directors that would comply with the need for any continuity and hiring of any additional people to replace perhaps my efforts. And so I reached out to the banking department initially to see whether there were any provisions similar to Massachusetts statute, which allows limited purpose trust companies and which has been utilized by a number of the large Massachusetts law firms, such as Nixon Peabody, Choate Hall and Stewart, Ropes and Gray, to establish their own trust companies under their umbrella and act as trustees for their clients. I didn't see anything. The banking department doesn't have anything like that, allowing folks to operate in that fashion without subject to the regulatory requirements, which are quite restrictive, significant capital requirements, security examinations, etc. And with all due respect, I listened to the banking department representative discussing this, who said, I quote, "It would be redundant and unnecessary to pass this proposed legislation." I think that there are reasons why it might not be redundant and unnecessary, and I think I point to the fact that recently in 2020, the Connecticut legislature passed a new trust act. That trust act allows for such things as asset protection trust, which is currently, Connecticut is the 20th state to adopt such legislation. It allows for the modern flexibility trust known as directed trust, which allow individuals other than the trustee in a fiduciary capacity to direct investments and direct distributions, rather than putting the trustees' fiduciary liability on the stand. Did I just freeze here? Looked like I don't know. Hopefully I'm not frozen. Can you hear me? Hello?
Yes, we can hear you.
Are you still with us?
Okay, good. Thank you.
There you are. Okay, Gideon, we lost you just for a moment on our end.
Oh, so I was saying that recent legislation in 2020, the Connecticut legislature passed a new trust act, which enables.
We did get that part.
Okay.
We did get that part.
Okay, sorry about that.
Your connection or our connection froze, but your 3 minutes has elapsed. If you want to summarize real briefly, I know we'll probably have a couple.
So I think, the banking department is concerned about security, and I think regulations can be appended to the bill through a regulatory process to assure them. But I think that the main point is that the banks have not stepped up to be interested in these trusts, and particularly smaller trusts, where the middle class wealthy, not the ultra wealthy, they might do Medicaid planning, they might have special needs trusts, they might want trusts for protection from a beneficiary's creditors or spouse, and the small banks have the many banks that have trust companies, trust divisions, they require $10 million to $20 million minimums in order to take those on. And so I think there's a gap here of where these limited purpose trust companies that can't accept deposits and make loans that we can fill with this limited purpose trust act. I'm open for any questions, and thank you again for allowing me to appear.
Yeah, thank you, and appreciate your thoughtfulness and your work on this and working with us. And I did wonder, one thing I just learned is that the law firms that do a lot of trust work sort of operate these. How does that look? So you mentioned Ropes and Gray, for instance, or Choate Hall and Stewart in Massachusetts, under their statutory scheme, actually forms, and is it like a small sort of
captive trust company, if you will.
Exactly. It's a captive trust.
And then the attorneys.
It's a captive trust company, and if this way, their trust and estates lawyers can designate that company as the trustee of record for their trust instruments or wills. They could act as executors. They have fiduciary responsibilities and obligations. And but what I did find out since I started this process here with your committee and with the Department of Banking is I found out that there are a number of other states that have legislated: New Hampshire in 2015, Maine in 1997, South Dakota, Nevada. There are a number of states that allow for these limited purpose trust companies not to take on deposits and are not allowed to make loans. And those statutes are much less restrictive and rigorous than the Massachusetts statute. So what I found out by inquiring among these law firms is that they went to New Hampshire to file there, register there as limited purpose trust companies, instead of relying on the Massachusetts statute and the regulations of the Department of Banking there. Apparently because New Hampshire is much less restrictive in terms of their operations. And yet they operate in Massachusetts as a New Hampshire trust company now. It seems that that's the way that's going.
Interesting. So tell me, how does it work now if you were to be representing a client, you know, as an individual attorney? What do you have to do vis-a-vis the Department of Banking? And I know some trusts, it's like testamentary trust would go to the probate court. You'd have to report to them. But if it's not, what's required of you as a trustee via the Department of Banking currently?
That's an excellent question. An individual can act as a trustee, doesn't have to be an attorney, doesn't have to have any qualifications. I can appoint my sister as the trustee of my trust for the benefit of my daughter, and she would be the trustee. The problem with that is once she becomes incapacitated or dies, I may need to, you know, the successor trustee, if there's one named, would be able to take over. But if there's no successor trustee named in the instrument, then the beneficiaries would have to go to court to get a trustee to accept the trusteeship and have the court appoint the trustee. Now, I've had situations where that has taken over a year in New York, and during COVID, when the courts were closed, we couldn't get anyone appointed as a successor trustee. And there were a number of trusts that I had where no trustee was acting and all the assets were frozen during that period until we could get to court. Whereas a trust company that would have been appointed in the trust, designated in the trust instrument, would continue to be able to operate even if one of their directors or one of their principals had died.
Okay, thank you. Senator Honig, who is online with us, has a question for you.
Thank you, Mr. Chair. And Gideon, thank you for being patient to testify here. The banking department, I guess, was concerned about regulations like minimum capital requirements and security, asset pledges, that kind of thing. And when you operate as an individual, are any of those things taken into account?
That's an excellent question. No, as an individual trustee, you have no requirements to put up some security or bond. In fact, most of the trust instruments and state wills that I've drafted over the years provide that the trustee is not required to put up a surety bond. Of course, you can require it if the client thinks it's necessary, but it is unusual, let's say, for a trustee to be required to put up a bond. As an individual, you rely on the courts to enforce the laws, and if a trustee breaches their fiduciary duty, they can be taken to court and be surcharged by the court under the trust statutes, and that's the backup, I suppose. Now, there certainly have been instances where trustees have stolen money from clients, but that has not resulted in any state that I'm aware of that would require an individual trustee to put up some sort of security or bond for their performance.
Thank you for that answer. And earlier in your testimony, you talked about how banks and trust companies in Connecticut don't want to take on a lot of business from smaller accounts. Why is that?
Well, the problem is it's not economically feasible for them, I guess, because if they require $10 million minimum, they charge a percentage on the amount of assets that are being managed. So if it's 1%, 100 basis points, which is a very typical charge on 10 million, they would be earning $10,000 a year, if my math is correct. Or no, I guess it's $100,000 a year, 1% of 10 million. Whereas some of these trust companies that are captive by the law firms, or Delaware trust companies, South Dakota trust companies, Nevada, I've referred clients to them, and they charge as little as $4,000, $5,000 a year fixed fee, regardless of the amount of assets that are in the trust. And the reason for that is because Connecticut's, for example, directed trust statute, just recently enacted, allows a trustee not to have any management investment responsibility. They have custody of the assets, but the investment responsibility is that of someone designated in the trust instrument as the investment director. And so if the trustee has no fiduciary liability for investments under the current Connecticut statute, then the trustee, the directed trustee, can charge a minimal fee, say $5,000, and not have to worry about investments. They might make distribution decisions, and they might even have that taken away from them by the trust instrument. But basically, if I was establishing a trust company, I would charge a flat $5,000 fee per year, and the trust would probably be, as my current trusts are, typically they're under $5 million in total assets, which are probably not too attractive to any of the financial institutions in the state of Connecticut. I would also add that I know of no bank currently taking advantage of the new asset protection trust legislation that the legislature passed in 2020, and therefore most clients are still going to Delaware and Nevada and South Dakota as being the top three jurisdictions, because there's no trust companies in Connecticut that are taking this on. Not profitable for them is my guess.
Thank you for that answer, Gideon, and
Yep.
appreciate your testimony and your patience here. Thank you, Mr. Chair.
Thank you for your time.
Any other questions for Gideon? Senator Miller.
Thank you. And thank you, Gideon, for bringing this product into committee, because this is new for me. I have a question regarding the abuse of someone's fiduciary responsibility. If a the person in charge of the trust account, if that person steals the individual's money, what kind of recourse does the owner of the trust account have?
Well, the owner
under current law, and then under what you're proposing.
So first of all, the owner of the trust account is the trustee, the legal title.
Oh, that's true. I forgot that changed once you give it to the trustee. So the beneficiary, is that what you're going to call them?
That's always been the case, but the trustee is accountable to the beneficiaries.
Mm-hmm.
And the beneficiaries at any time, they typically would get a annual report from the trustee, because the trustee can't take his annual commission without giving the beneficiary an accounting of what went on during the year. So they'd get an annual report, and that annual accounting would suggest to them perhaps that something is not right, that the trustee made speculative investments, the trustee put money in his own pocket and wasn't permitted, et cetera. And at that point, the beneficiary would have to hire a lawyer, presumably, to go to the probate court and file a proceeding known as an accounting proceeding to compel the trustee to explain what happened during that period of time with respect to the trust assets. And the court would require the trustee to submit a formal accounting and would determine whether or not the trustee has breached their fiduciary duty and made improper investments of the trust or stolen money.
Would that change under what you're proposing under the trust companies?
Well, that would still be the case if a beneficiary thought that something was awry here. In my opinion, if there are significant requirements to create a trust company, as I'm proposing, then that would defeat the whole purpose. Because If the requirements are going to be similar to what a bank has to put up in capital, minimum capital requirements, millions of dollars, and security, then why would for example, a law firm want to create a trust company when they can continue to operate without any regulatory oversight as individual trustees?
Right, but how's the beneficiary's assets protected? So if you have someone who
they won't be any greater protected or less protected than if an individual trustee is acting.
Well, that's what I'm asking you. Is there an advantage or a disadvantage, or an advantage to having a company? Like you would say that the board of directors would be responsible as opposed to just the individual.
The advantage would be, the advantage is twofold. One advantage is that there'll be this continuity, so that the beneficiaries don't have to go to court and don't have to risk the possibility that the court's delaying the process. So for months and months and months, the trust might be unable to do anything because there would be no trustee in place. That would be one major advantage. A second advantage would be that there'd be non-bank institutions willing to take on trust business that is of much lower value. So, for example, a lot of modest net worth, someone who has, let's say, $500,000, a trust company would not be interested in managing $500,000 today. But they may be advised by their trust and estates lawyer, if they want to qualify for Medicaid, nursing home coverage in the future, they should put their $500,000 into a trust. It's called an income-only trust. And that trust will pay them income, but will protect the principal for their spouse or for their descendants. Now, usually what will happen is the lawyer will take on the role of trustee if the client doesn't have a close family member that they trust to take on the role of trustee. By allowing for these trust companies to operate, that would be another option that's available to the client. And if the banking department wants to have minimal requirements, not the same, $2 million in capital, but let's assume, $100,000 in capital. I'm just throwing out a number. I'd have to do a survey to see what other states require. It would at least give some additional benefit to the individuals who need to be protected.
Right, but I haven't heard who would be responsible for the misuse of the funds. Would the trust company be responsible? Like the trustee would be responsible?
Presumably the trust company would be responsible because they are named as the trustee, not the individual.
Okay. All right.
And presumably there would be directors and officers liability insurance carried. And the trust company can also, I carry insurance for myself, acting as trustee, fiduciary insurance. So it's kind of it's an errors and omissions type policy. So if I make a mistake, I don't file a tax return on time, the trust suffers some penalties. My insurance company would cover that claim potentially.
Okay, well, thank you for your answers. Thank you, Mr. Chair.
Thank you for having me.
Thank you. Thank you, Gideon. And, we hope to continue the discussion and perhaps get the department involved. That last point in particular, in terms of sort of recourse to the trustee and whether it's insurance, a bond or otherwise, that we may be sufficient in the eyes of the commissioner. Those are details that I think we still would need to.
I'd be happy to work with the department.
Right. Good. Okay. Well, thanks for your patience today.
Thank you.
Take
Bye-bye.
care.
Have a good night.
Okay. Next on our list is Orson Aguilar. Is Orson Aguilar with us? No, I don't think so. Jason Quizdala is online with us. There he is.
Yes, thank you very much.
Welcome.
Thank you, members of the Banking Committee. I'm Jason Quizdala, Chief Technology Officer and co-founder of Immediate. Immediate is an employer integrated earned wage access provider, and I wanted to express our support for SB 1396. This legislation represents a significant step forward in ensuring that Connecticut workers have access to responsible and regulated earned wage access services, which provide critical financial flexibility while fostering economic stability. Immediate advocates for clear, transparent regulatory oversight to ensure that earned wage access providers operate with accountability and consumer protection measures. SB 1396 rightly establishes a licensing structure under the Banking Commissioner's authority, ensuring that EWA providers function as a responsible and accessible financial tool rather than a predatory lending mechanism. On some of the points made earlier, specifically on the database requirement, I wanted to clarify data being used for several purposes. One is used from an auditing standpoint. In other states that have passed earned wage access laws, we are required to send data to the state to make sure that we're operating in compliance with regulations. And as Ryan from Daily Pay pointed out, it isn't called or considered a database. We support sending that same requiremental data to Connecticut to make sure that we are compliant with this program as it's established. What I heard earlier is more using a database as a real-time registry to prevent stacking, but I don't see that as a practical solution. For context, I have 10 years of past experience integrating with healthcare data registries like state immunization registries. It tends to not be a technology problem. As pointed out, these are APIs. We integrate with APIs every day. But if you look at other industries and how they've taken these on, it took significant state and federal funding through meaningful use to put infrastructures in place to support this. We believe that this real-time database without that financial funding structure would add significant cost to providing the service that already has capped fees and no recourse associated with it. We expect the third-party database would add $1 to $3 per transaction to integrate with, and which would make the solution even more expensive for consumers for any transactional cost model. Additionally, with an employer integrated model, we already can make sure that the employer doesn't have multiple solutions on place by looking at deductions and direct deposit information and information we have in place. It's to our benefit that they're not using several services, because that would prohibit our ability to get repaid as part of this. Also, the devil's in the details of this, that employees change jobs and pay periods all the time, and we're relying on that real-time payroll information to provide our service to them. And this means that someone who's not employer integrated could be operating off a different data set than someone who is employer integrated.
Thank you. Okay. Your time's elapsed, but I appreciate that. You again touched on a point that I think is a valid one, and that is, you are collecting all sorts of data that direct-to-consumer providers aren't necessarily collecting. So it creates a little bit of an additional sort of challenge as we think about how this would work. But I appreciate that perspective. Did you?
Can I make one more quick point on that? Employees can also have two jobs. It is also foreseeable that an employee could be at two different employers. Each employer is contracted with a different earned wage access provider. And so if we're all looking at just some unique ID attached to the person, that would prohibit the employee from participating with employer B's program as part of that. And so that's where the devil's in the details on this, and it's not just a technology problem. I thank you for your time and consideration today.
Good point. Yep. Okay. Any questions for Jason? Seeing none. Thank you for joining us today.
All right. Thank you.
Okay. Next on my list is Art Corey, who I do not see. And I know they have submitted written testimony as well. So next is Craig Clark. Thank you for your patience, Craig. The button. There you go. Yep, hit the button. Either one.
Okay. All right, thank the Banking Commission and thank everybody for allowing me to come here and show my support for the 1093. I know I met Doucette and Bolinski before, and we had conversations about this, and I don't want to be repetitive with what you heard today. I kind of just want to fill in some of the gaps. I've been established in Connecticut since 2009. I've been in the business since 2007. At 2009, I started on my own, downtown Hartford. I have not left downtown Hartford since 2009. I went up from 0 employees to up to 100 employees. I actually started homeless out of a truck, out of my friend's basement. So when I say I know this industry, I'm very familiar with this industry. 2016, I went from a broker to a funder. At that time, the industry was changing. I seen 2008, we had an increase in business because obviously the housing market crashed, banks had an issue. I was around for that. I seen when the transition with presidents, uncertainty in the economy changed things, banks kind of slowed down. We had another burst in growth, new people came into the industry, so things were changing. Me having an opportunity to be a lender, I wanted to make sure I had a contract that made sense, right? I didn't have, I came from New Britain, Connecticut. I'm third generation, getting it from here. My dad was a factory worker. I didn't have somebody I can go to and say, hey, give me $100 million to put money on the street. I took profits, started off very small. So I went to a lawyer, looked at different options that are out there. I seen that commercial leases were using a prejudgment remedy. Mind you, I didn't know as much about it as I do now. Commercial leases were doing it. I found out the state government was doing it to different towns. I seen that credit unions do it. So I seen a tool that was being used that could be applied in the same way. Now, the way the contracts have been since then, it's always been a percentage of the future sales. If there's no sales, there's no default. That's plain and simple. If you do have bad characters that are doing something outside that, that's not in what's in the agreement that both parties actually have to sign. And is explained 3 times at minimum on a call. One at the beginning, at a pre-funding call, during the interview is usually explained, and at the end of a call right before funding, they're usually either doing an online checkout outlining each individual situation that can cause a potential default. So they're typically aware. So I just kind of wanted to address that, the contract and how that works. The ex parte, which became a conversation today, that is something that is only used in an event of somebody intentionally trying to get out of a situation, not pay. Now, I do understand that we're trying to protect a certain class of business owners that potentially we say might not be as astute, but I would disagree. I have funded deals from, and these are public, so I'm going to put it out there. I remember one time you said to say the names. The Brookstone that you know, I took them out of bankruptcy with a $200,000 cash advance. Now you would say, is Brookstone astute? I would say they was. It was a hedge fund that came and had to get a deal done to get them out of bankruptcy so they can switch from being retail to more in airlines to the online store. So I have those all the way to McDonald's, Dairy Queens, down to the small ones. So I do understand. But we're not trying to put these businesses out of business. There is a reconciliation process. The things that we already put in place, just to cut the licensing, disclosures, and I don't think anybody else is against even doing the APR. I literally have to do that in certain states already anyway, so I'm not changing anything by adding that. So those things are not really an issue. The question about California, California is not really getting funding in our space anymore. It's not just from the APR. They did go, I think they overreached years ago with the licensing, like you're saying. They wanted to set certain things at certain bonds that certain people just couldn't do. And now that's a state that's not really getting funding in our space. You do have some, but there's a lot that's not funding. Last week, there's a lender that left Connecticut that doesn't even use the PGR. And I had a conversation like, what's the issue? Well, I'm just not sure what's the landscape there. I'm like, what they're doing is not even affecting you. So there are opportunities. We are trying to help business owners. It's a range of business owners that take this product. So I want people to just think that, hey, these are just desperate people. Yes, there are some people that need payroll. There's a business that handles 95% of downtown buildings and with their HVAC. I've been funding them for 10 years. When I first started doing business with them, they were doing 1.5. Just to kind of real quickly, and I'll wrap it up here. It's an $8 million business. But because of things on his background that have been there that couldn't get rid of, that he's still working on, He can't go get a term loan. Can't go to his local bank. He's tried. I actually brung him to banks to try to get him funding. He can't. So he realizes I meet 4, 5, 6 times a year. If a large contract comes up and he has to fund $500,000 in payroll plus expenses, this is where he's going to call it. Can I do it all at once? No. One last thing I want to answer for you. You was wondering how the people come up with the money, like the underwriting side. So we do have internal kind of industry rules, right? We're never going to give, just make it very simple. You're never going to give somebody more than 100 to 125% of the actual revenue, 3 months average. And this is just baseline stuff, right? So if a guy's doing 10,000 a month, you're not going to give him 20. They're doing 100, so forth. The other side of that is industry-wide, you're not going to have more than 30% of the revenue. Now, that's only if in your situation, when you're asking about, is it multiple contracts? So if one person funds, you don't want to be more than 10%. Like you're not going to say, hey, more than 10% of the revenue on average. Some might skew that. Now, if somebody tries to stack, what you heard with the other situations, 2 would be, 20%. So that there is a kind of a rule in place industry wide. Is it, like is it a bill? No, but there is a way that we are formulating how much a business owner is getting money without putting them in a bad situation. And they're always advised because our side is unsecure.
Okay. All right. Well, thank you. That's helpful. For the client that you just mentioned, this provision wouldn't apply anyway, right? Because they're likely to be extended well over 250.
Well, it depends. No, it depends because they don't always come for that amount, right? So if he says, "Hey, Craig, I got this new contract. I need 100,000," or which always happens at the end of the year, he's waiting for AR to come in, and a lot of companies either pay or don't pay and put it to the next year. He still has to cover those 2 weeks of payroll that at the end of the year. So sometimes it might just be 100,000. But in that situation, let's just say he says, Craig, you know what? I'm defaulting. I'm not paying you, or take the money and leave the country, which I've had happen, like immediately to people. I have no way to recoup. There's no provision in place for something.
And your contract is not in the aggregate. You don't, and maybe the industry doesn't function this way at all, but nobody does. I mean, it sounds like nobody does like, okay, I'm going to, congratulations, you qualify. We're going, 10% or whatever. Looking at their financials, congratulations, you qualify for 500K. We're going to sign you up today for 500K, even though they're only looking for an advance for 100K at that time or something like that.
Okay. So that answered, yes, I did hear that earlier. So that's a totally separate product from what you heard today. Those are unsecured line of credits.
Yeah.
Just to give an example, Amex bought a company that offers something like that.
Okay.
Yeah.
Okay. They had a different licensing scheme.
Exactly.
And everything. Okay. Well, thank you for being with us today. Thank you for being a Hartford guy. And, we've seen some palm trees behind folks testifying today and stuff, but you're a Hartford guy and you're here. And I do appreciate that. Other questions for Craig? Any other questions for Craig? Okay. Seeing none. Thank you. Next is Ed Hawthorne. Hey, Ed.
How are you?
Good.
Feel a little duck out of water in banking, but
yeah, welcome.
Well, it's good to be here. Good evening, Senator Miller, Representative Doucette, Representative Delnicki, Representative Foster, and I think Senator Honig's joining us online. My name's Ed Hawthorne. I'm proud to serve as the president of the Connecticut AFL-CIO, federation of hundreds of local unions representing 250,000 working people here in the state of Connecticut, in the public sector, private sector, Connecticut State Building Trades. It's on their behalf I testify here today. In strong opposition, the Senate Bill 1396, an act concerning earned but unpaid wage or salary income advances. Concerns is really for potential for predatory lending practices that can harm Connecticut's workforce. The regulatory oversight, EWA provides there must be a license and regulated by the Connecticut Department of Banking. It ensures compliance with consumer protection standards. They can already operate, but we have a regulatory structure that's very strong. One of the leaders in the nation in that. APR calculation, all fees and voluntary tips must be included in the annual percentage rate. APR must be disclosed to customers. Law caps the APR at 36%, preventing payday loan style exploitation. It's all something that is worth protecting. Fairness and disclosure, it ensures the true cost of borrowing is clear to the workers taking advantage of it. The potential issues with it, it facilitates hidden costs and high fees. Without strong regulatory oversight, EWA providers could disguise the true cost of borrowing through voluntary tips and hidden fees. Research shows, and we've heard it time and time again, that they function similar to payday loans with the EWA, with effective APRs far exceeding the 36% cap. If they didn't, they wouldn't be here advocating to have a new structure to work under. It encourages a cycle of debt. Many workers use EWA repeatedly. The average, as found by the Consumer Financial Protection Bureau, is 27 times per year. Practice reduces take-home pay, puts workers into a cycle of borrowing for meeting just basic living expenses. According to the California Department of Financial Protection in 2023, 80% of the transactions were between $40 and $100, which is approximately 6 to 50% of the workers' pay. It weakens consumer protections by sidestepping Connecticut law. We want the laws to be transparent, enforceable framework for regulating EWA advances. This bill would create exemptions that would allow companies to bypass that 36% APR and transparency requirements, ultimately harming workers. I think Senator Miller eloquently put it best, where the industry can prey upon people's weaknesses and needs. And I think that's something that we really don't want, and this bill, I think, would do. As I said before, Connecticut's been a leader in protecting workers from predatory financial practices. Hence, we don't allow payday loans. And we should really focus on the root causes of this. People needing money multiple times, time and time again. The Harvard Kennedy School in June of 2023 said fund users, 75% of the users were using it to pay bills. So thank you. I hear I'm getting the gong over there. So I'll be happy to answer any questions you all may have.
Thanks, Ed. I appreciate that. Welcome to the banking committee. Yeah, we don't see you around here too often, and
Glad
you're
to
in
be
the
here.
building almost every day. So it's nice to have you. I hear what you're saying about root causes too. I mean, we've been having this discussion for a few years now, and we've heard from people. We've heard from at least a couple today, and I think there's a few more on our list who are, just working people who use these things, and they use them responsibly, and they like using them, and so they're here to tell us that they utilize them as a solution to their, day-to-day cash needs or week-to-week cash needs. And I hear what you're saying, and I totally agree with you that root causes, like, those folks, to get a leg up probably deserve maybe a better wage, or, we shouldn't, there's inflation, there's everything else that affects working people. So, I mean, I hear that. And, the other thing I'll tell you is that, that we talk about the APR and the 36%. And, it's good to hear that, because frankly, we get in the weeds a lot with this too. And we hear, okay, well, let's talk about the product. Maybe it doesn't adapt well to our current conventions of measuring these things like APR because of the time period and everything. So we get in the weeds with that stuff too. But, it's a useful reminder. Question for you.
Sure.
Have you thought, or have you heard any discussion about going at this from a different angle, that is from the employer angle? So we have some of these products and apps in the industry are, what we call employer integrated.
Yep.
We talked a lot about that last year as well. But certainly an employer could elect to provide this service basically on their own, not having to use a third party or an app or whatever. What are your thoughts on that?
The employer integrated ones tend to, I mean, I don't speak for every employer, but from what I've learned through delving into this, is the employers will often take on a lot of the fees themselves if they're choosing to use a third party. I mean, when I worked for the state of Connecticut and we had a provision in our contract, we could request that our pay be advanced to us for, I believe it was up to 2 weeks. I don't think I ever really used it, but there was that option that we could have that directly from the employer, not through a third party, through the state of Connecticut, the people in this building. So that was written into our union contract, and there was no issue with providing that in advance. They knew I was taking vacation time that was going to be paid, and they could simply write a member a check in advance. The third parties are really preying upon desperate people. I think one thing that's worth looking into, and something that I quoted often when I was working at DOL and writing my decisions, was the frequency of pay. So you have the option, it's written into the law that it's weekly or biweekly. So if people are getting paid biweekly, they can be semi-monthly or monthly with an exemption that you have to apply for and be approved. But if there really is that problem and really is this need for it for people using it, maybe look into the requirement to have weekly pay be the standard rather than weekly and biweekly. Because if people can't wait that extra week because they need the money now and they're turning to these companies that could be charging them fees or asking for tips or anything like that, that may exceed a 36% APR, that's a root cause right there. That if these people are working and then getting an advance on that work, why not just have the employer pay them weekly rather than biweekly?
It's interesting you identified, and we didn't have you last year, you know, the intersection between labor law and what we're talking about here, the financial regulation piece of it. So appreciate hearing that. Senator Miller.
Thank you. I just wanted to make a comment. You know, I never looked at it from that perspective, the frequency of pay. I know I went from weekly to biweekly, and it was difficult for me to manage my finances when I went biweekly. And it's not that I spent more, but it was just something about not having that cash available every week, saying, okay, I know I'm going to get paid this week. And so that's something that, you know, a lot of companies, they did. They switched from weekly to biweekly, and semi-monthly is even worse. And so, you know, that is a very good point. And I wish companies would take that into consideration when we think about the needs of the people, because, and I've said this time and time again, that I struggled with this product because I came from a family where they had to use loan companies because they weren't making enough, right? And so, and they were predatory loans because they were at high interest rates. And I just wish that we as a society would look at ways of making sure that families can survive, that families can, you know, parents can take care of their children and they can pay for their expenses. But it just seems that, and I'm getting philosophical now, that we're just more interested in monies these days, making money as opposed to people, and just making sure that I'm going to use the term, making sure that our families are whole. And so as my co-chair stated, we're listening to people today that say, hey, look, I need this. You know, if I, as a parent, if I had a choice between paying the rent, buying food, or taking a loan out, I'm going to take the loan out, knowing that maybe next week I won't have the money. So you're always behind the eight. But thank you for that, because I never looked at that, you know, from that perspective, that maybe if the frequency of pay would increase, that maybe people will have more money to work with. Theoretically, I mean, the money's the same, but it's just being able to manage it better. Let's put it that way. Thank you, Mr. Chair.
Thank you, Senator. Rep. Delnicki.
Good to see you.
See you.
You know, it was interesting when you made the comment about weekly. And I never thought anything of it because I went to work at MDC and it was weekly, and to the point that I retired, and I don't know what it is now. I'm guessing it still is weekly and should be. But I couldn't help that frown, huh?
I couldn't tell you. We can look into it though together.
So the point being, every company, it would be nice if we could get every company to go back to that, because it was so much easier for me to make ends meet, knowing I had a paycheck every week, came every week, and direct deposit, no less. And that was a great thing to have. So is that something that's going to be in the Labor Committee?
It's just something I thought of today. I mean, I thought back to, I did unemployment compensation appeals for over a decade at the Department of Labor. Where this used to come up was people not getting paid on time. Their employer wouldn't seek the exemption to get the bi-monthly or the bi-monthly or the monthly, and just start paying people on a monthly basis, going up from 2 weeks. And then people either go up and quit, and then I would rule that it was for good cause because they violated wage law at that point. So that's really what made me think of it, was my experience at DOL. And really what this is a advance on the wages that you are earning. So it just means that there's too much of a delay to get the money that they've already earned, and they're paying a fee in order to access those funds. But if they were paid on a more regular basis, maybe that would solve the issue and really cut out some of this need that there obviously is for this, because people are struggling. I mean, people are living paycheck to paycheck and just struggling to get by, especially with the high inflation, with the tariffs that we've just seen come down today. It is only going to get worse. The stock market's crashing, the S&P 500's down. This is not going to get any better. And we need to make it as easy for working people to get by and to just live and work towards making them thrive. And I just don't think earned wage access is a path towards people thriving. It's a path towards people being in a cycle of struggle and debt.
Yeah, I can see the stress and strain put on a family budget. And I think the senator, she made a good point, though. You know, if you've got to feed your kids or get oil to heat your house or whatever you got to do, you've got to do. And that's really the bottom line. Now, I will ask you one question pertaining to what you've heard here today.
Sure.
The discussion by state banking pertaining to what they're looking at doing to put some controls on EWAs. What's your opinion on that?
I wasn't here for that testimony. This is my third committee of the day. So I was either in labor or higher ed at the time. I have tried to be here most of the day, as you saw me sitting over there, but I always see you around. You're always accessible. Happy to have that discussion with you offline once I've had a chance to review it.
Appreciate that. I look forward to it. Thank you, Mr. Chair.
Thank you. I appreciate your written testimony. I've always struggled with this bill because intellectually, I believe that it's not meant to be a solution to not having inadequate funds. And I actually don't believe fundamentally, if wages are not adequate to cover your cost, your pay frequency, like, although it intellectually might make it easier to balance things, fundamentally cash flow is the problem. And so it might change behaviors, for example, like teachers who spread their costs of their incomes out so they receive it. They might plan things differently and change the way that they behave because they receive their money one way versus another. And that makes sense to me. But the frequency of pay, like 1 week versus 2 weeks, if your salary is too low to afford what you're doing living wise, neither increasing the frequency of your pay nor EWA is a solution to the problem. And so what I guess I've really struggled with is, like, we're characterizing this system as like a predatory loan, but the risk inherent to it seems by an economies of scale very different than the risk inherent with actual payday loans. And so, I used this example last year, and I think Rep. Miller or Senator Miller's example is similar. Is like, what happens if you have like a one-time unexpected high cost, and generally you can make your balance work, and this is like a one-time thing that makes it work. For example, like my son 3 months ago was in Connecticut Children's Hospital's ED 3 times. And we got struck with a $500 bill each time. Now, we made that work, and that's fine. But some people might carry significant interest on a credit card to pay that. Or if they use EWA, the interest actually might be lower than carrying that on a credit card balance. And so sometimes options like create the ability that you could incur a little bit less interest and the debt. So like if you did a cash advance, like if my husband and I both pulled that instead of putting on a credit card, that might have made the total interest paid lower because of how this works. And so I guess I sort of am struggling with the characterization. So I'm curious, like, if members are using these and finding negative experiences, because I guess, like, intellectually this seems problematic to me in the way it's being characterized, because it just doesn't, like, it's incongruous. I'm confused about like how it's gotten so off the rails, I guess.
Well, first, I'm sorry to hear about your little one.
He's good now.
Oh, good. As a parent whose daughter had health issues at birth, I know how scary that can be. I want to focus on the low risk part of it, because it is secured in wages in the end, right? And that's why there is currently a structure that they can operate in, but they're just choosing not to. There's a 36% APR cap with a low risk loan. How is that not reasonable?
Well, so I think this is actually the thing that I struggle with is when you add the APR calculation and the loan period is less than a year or 6 months, the APR, like you've created an inflated denominator. So the APR calculation just fundamentally doesn't work because the loan period is so short. And so if you restructured APR, then it could be less than 36, but like even if the fee is only $5, it's like meets the Department of Banking's cap that they've proposed. Even if it's the fee's only $5, there's no interest and there's no, I like had a spreadsheet on this last year. Like your APR is 500%
Yeah.
if the pay period is a week. And so that makes no, like that's not really a true APR, because if you compared that to the APR on a credit card, that you actually are accruing much more in your payment year over or month over month in your, paying the minimum balance. Like this you could actually end up paying a lot less in addition to the principal payment under EWA than using a credit card, for example, or a payday loan, even though technically the APR makes it look huge. And so my big problem is like APR doesn't work, which I thought the Department of Banking's proposal this year, I think sort of addressed by capping the fees, because then I think you get at the protection. So I don't know if I have a specific question, but I think, you have the fairness and disclosure. I don't think people really understand APR as a general rule. The whole public hearing that we had last year where we talked about APR, I was like, no, like you just are messing up a denominator. And so like the number's crazy. And that's not the same as, it's not the same. You're putting a decimal in the denominator. So you've created this like artificially inflated APR. And so I guess I just struggle with it, because if it's hurting members of AFL-CIO, like if it's hurting your members, I'd like to know how, because if it's about not having adequate wages, that's different than this thing costing more money. And I guess it doesn't, like the math doesn't math for me. That this is more problematic than other loans with higher interest rates. I'm not saying that I have just really fundamentally struggled with this. So I don't know if you have thoughts about the APR calculation because you think it's working.
The APR calculation is what it is now, and it provides a backstop to it. And to allow these companies to exceed that, I think, is a slippery slope. It could become predatory very quickly. So why seek a change to something that is in law and is regulated? And Connecticut's looked at one of the leaders as a state on regulating these types of loans. So I understand what you're saying on the weekly basis, but when you do multiple transactions on these companies can still be profitable by doing that, because 36% still is a lot, and that's the cap. So,
and I think a lot of them are saying that they don't allow you to have multiple transactions carrying balances over. Like you're only allowed to have one advance at a time, and until that's paid off, you're not allowed to do it again, which is different than a credit card where you could carry an unhealthy balance on your credit card month over month, and then suddenly you get like an increase and you are paying huge interest. You're paying the minimum each month, and you're paying way more in interest than in principal. And so technically in my mind, this might actually be a healthier financial risk proposition than carrying a credit card balance, which I think is the alternative people might be doing, especially I imagine in your membership, because I think people probably would be eligible for a line of credit similar to the amounts that they have, because they have stable and reliable jobs and job protections in place. So I don't know. I think just intellectually, I have a hard time wrapping my head around the proposals, because it feels like we're like incongruous somehow with what I think the risks are and what I think the solutions are proposed here. Because I think basically we're saying we're fine with this model not existing and your members don't need it. And that's interesting to me, because I think they're saying they have a big customer base here and not, as far as I can tell, a lot of complaints. So yeah.
as one of I mean, our members aren't coming to us and saying we're using this, please protect it. They're not coming to us and saying, please, have the fee. I represent, like I said, approximately 250,000 members. We have the highest of the high, and we have some very low. We have people that, talking about our paraprofessionals that make about $25,000 a year. Clerks at Stop and Shop are very well paid, are well paid, but still low wage workers. We're talking about people in nursing homes, people in group homes. So we do have some very low wage workers. I mean, you can go through the testimony on some of the bills that we put forward from our members, and people are living in their cars and struggling. That's why we have to start talking about the root cause of it. Why is there a need for earned wage access? And that's really what we need to address. I don't think weekly pay is going to solve all of our problems. There'll still be a need for it after that because people don't make enough money. When your raises don't keep up with the rate of inflation, you're actually getting a decrease in your pay. And that's the cycle we're in now. And it's only going to go down more and more with our trade wars, with our closest trade partners that we see coming down now.
Yeah, and your point about paraprofessionals, like I have a pair of email in my inbox where they end up having to pay if they exceed their contractual days off. They end up having to pay to take the day off because their insurance premium that they're paying as their contribution exceed their daily salary.
Oh yeah.
So once they exceed their PTO days, they end up having to pay to take time off. And so like in that situation, like EWA really isn't the answer.
Yeah.
And that's just fundamentally like a societal problem we have to contend with. But I don't, it's almost like this is a product that works in a different income bracket, and it might work in that case, but not in another. And so I think the risk is inherent to income, which is separate from the product, which is, I think, what I'm struggling with. But I appreciate your answering my questions and allowing me to work that out in my head. So thanks.
Thank you.
Rep. Delnicki for the second time.
Thank you, Mr. Chair, for the second time. And this is not germane to the EWA comments that we've been discussing here, but you're right about when you said paraprofessionals, because I have a dear friend who works in Eli Terry, and I hear the comment that, gee, if I worked at Walmart, I'd make more money and I'd have health insurance, but I love the kids. And that's a real takeaway there.
Oh yeah. If you look at the jobs, and not to get completely off track, but if you look at the jobs that the people really are struggling, it doesn't pay to care for other people. And we need to support them and make sure that it does. And our Secretary Treasurer at the AFL-CIO is an amazing paraprofessional, but a paraprofessional in Hartford for many, many years, and is the head of the Paras Council at AFT Connecticut. So I invite you to talk to Shelley and learn from her experience and the experience of her members and the people that she represents.
And I want to thank the chair for the indulgence to make a comment that, quite frankly, doesn't refer to banking, but nonetheless is salient to what we're talking about here. Thank you, Mr. Chair.
Of course. Ed, didn't you have fun at the banking committee?
I always have fun at the bank. My mother was in banking for many years, so she's going to be happy that I was here.
Well, we're happy you're here as well. So thanks for joining us.
Thank you.
All right. We are going to go to Paul Vega, who's with us online. Welcome, Paul.
Good evening, committee. Thank you so much for sitting through this entire day with us. I wanted to start by apologizing in advance. I'm certainly not as eloquent as many of those that have spoken here, but I am honest, and I hope that you will find some value in what I have to say regarding my support for Bill 1093. I've been listening to the others that have spoken in support of 1093, and it sounds like many of us are on the same page, so please pardon anything that sounds redundant. My name is Paul Vega. I am the operations officer for Funders App LLC. Funders App is a merchant cash advance funder. It's been in operation for 6+ years, and we currently have offices in New York, Florida, and Connecticut. The company is, at this point, has worked with thousands of small businesses spread out across the United States and has deployed hundreds of millions of dollars to date. I myself have been in the MCA space for over a decade. And as I was listening to others talk, it brought me back to thinking how I started my career in this space. And I remember one of the driving factors for me to decide to jump into this somewhat new section of the finance world. One of the driving factors was the opportunity to help owners of small businesses. Now, as we all know, the small business is the backbone of this country, but all too often they don't have access to the capital that is needed to support, never mind grow the company. And the hard truth is this, that many companies are shunned by the banks. So we, the MCA community, has stepped in to fill this void, providing opportunities for these small businesses when others wouldn't. But unlike the banks, MCAs are revenue-based and require less documents, and this adds to significant risk by exposure to fraud. We're seeing it skyrocket over the past 18 to 24 months. And the prejudgment remedy process helps protect us against bad actors from taking the funds and running, then moving the money to another unknown account. I can't stress this fact enough. It's important to understand that by limiting our ability to protect ourselves, will ultimately hurt the very businesses that we're trying to help. By forcing us to overcorrect our funding process and limit which businesses we actually fund. Again, the prejudgment remedy is only a tool that is used against bad actors, not against good businesses. By the time our company makes the decision to employ the prejudgment remedy, it is painfully obvious that we're dealing with a bad actor and not just a good business that has fallen into a bad situation. Let me paint the picture for you. You have fallen behind on your mortgage. Do you call Citibank and say, hey guys, I'm having a bad month here, please assist me? No, of course you don't. But that very same call happens every day within my company. We assist, we make adjustments based on the merchant's condition. Every day this happens. Basically, we don't force a good business into a bad place. We do our best to allow businesses to get through the hard times when they occur. And mark my words, hard times are coming. Given what's currently happening with recent tariffs that are being put in place by the administration, we're going to be seeing many more small businesses looking and seeking for our help. Let me demonstrate how a company like ours, a good company like ours.
Paul, your time's elapsed. If you could just, you can continue just briefly.
Sure, I'll finish this up. I have just a few more sentences here. A good company like ours, right? How we deal with good merchants that have fallen in hard times. 3 weeks ago, I traveled from New York to Colorado to visit a merchant in order to negotiate terms, in order to allow the merchant to forego additional expenses associated with having to settle his advance. And just today, coincidentally, okay, we settled that file. And in a very small way, we helped him from going over the cliff and possibly filing bankruptcy. Like I said, I got into this industry to help small businesses, not to do them harm. Please help us with the tools that we need to ensure that we are protected so we can continue small business community, to help the small business community when they need us most. Thank you, committee members, for your time and most importantly, your consideration.
Thank you, Paul. Thanks for your testimony. Very valuable. Appreciate what you're saying, and we hear you. Any questions for Paul? Seeing none. Thank you for joining us.
Take care, guys.
All right. Next on the list is Amy Boss, who is online with us. Hi, Amy.
Hi, good afternoon, members of the committee. My name is Amy Boss. I'm the Director of State and Federal Affairs at NetChoice. We're a trade association based in Washington, D.C., dedicated to protecting free enterprise and free expression on the internet. I did submit written testimony. We have some concerns with Senate Bill 1396. We want to see a bill passed, understand there needs to be compromise. We think that the bill still needs some work, but really appreciate the sponsors' willingness to work with stakeholders in this area. I will say, we believe EWA platforms provide a very critical lifeline for workers. These innovative services do allow employees access to wages they've already earned. This isn't a loan, it's accessing your own money early. These platforms help workers manage financial emergencies, avoid costly bank overdraft fees, and most importantly, stay away from predatory payday loans that can trap people in debt. For hourly workers, we represent folks in the gig economy and those with regular income streams. These services can mean the difference between covering an urgent car repair or medical expense and falling into the cycle of debt. I do just briefly want to mention, I know that there's been some concerns raised about the tipping model. Again, we're a trade association dedicated to free enterprise and free expression. We believe that the voluntary tipping model isn't just a financial mechanism, it is a form of expressive association. When users choose to tip, they're supporting a service that helps millions avoid, again, that predatory lending. And the Supreme Court has consistently protected solicitation rights. Laws that impose prior restraints on voluntary support have been struck down. So happy to follow up with the committee on some of those concerns as well. Again, appreciate the sponsors. I think this is a step forward. We still would like to see some amendments to improve the bill. Thank you so much for the opportunity to testify.
Thank you, Amy. Not familiar with your organization. Could you tell me a little bit more about it? I don't think you've testified on this issue with us.
I don't think so. So yes, we are very similar actually to a prior witness, Chamber of Progress. We're a principles-based first trade organization. So we have about 40 members. Everyone is listed on our website at netchoice.org. But we're principles-based first. And what that means is, our members don't serve on our board. We stick to those principles of free expression, free enterprise. We really have been involved in the states in regards to free speech matters, again, the gig economy, on content moderation issues, on antitrust. So work on a host of tech issues, both in the state and the federal area.
Okay. And is your sort of interest in this primarily with the tip question or the voluntary payments?
Yeah, I mean, we support the business model. We support innovative tools. We want competition in this market, and we really feel that having a tool such as this really empowers people. I totally understand the need to address root causes of people needing money earlier. That's a much obviously larger discussion, but we believe that tools, EWA tools, can be extremely beneficial in this regard.
Okay, thank you. Any questions for Amy? No? Seeing none. Thanks, Amy. Thanks for your patience today. Okay. Next up, Molly Jones. Thank you so much.
Thank you. Thank you, Chair Doucette, Chair Miller, members of the committee. My name is Molly Jones. I'm the head of public policy at PayActive. We're an employer integrated earned wage access provider. I appreciate the opportunity to be back again this session. In addition to the work on this issue over last session, over the past 5 months, I've been part of a small group of people who have worked closely with the Department of Banking on language for this bill. We have gone through numerous drafts. We started with an industry draft and proposed concepts from the Department of Banking. About midway through the process, we switched over to the Department of Banking's draft and worked off of that bill. And ultimately, that's the draft before you today. I think it's important to note we were charged with creating a workable path forward, not with creating a bill that we all love, but one that works. So maybe that makes me a little bit bad at my job, but even though we don't love the bill, we are in support of it. I think in a good negotiation, everyone leaves a little happy and also a little unhappy. And I think that seems to reflect some of the more mild support you might see from different stakeholders in the room. Again, I think we are all a little unhappy, but best not to change the goalposts on our negotiated bill. And I think it's a good path forward. I also think it's notable, given the discussion on the database, that this was included in the department's initial proposed concepts that were discussed and eventually dismissed throughout our extensive process on this. I'm happy to talk more about that in detail, but PayActive is in support of the bill and appreciates all the work on it.
Thank you, and thank you for your brevity, and thank you for being part of the team. Like you said, we've seen you a few times here, and appreciate your work and working collaboratively with everyone. I'm going to pick up there with the question on the database. Well, sort of two questions that we've come up that are sort of unique today because we talked extensively about all the other various aspects of this, but the database, could you expound further upon that, the earlier discussions and why you think it doesn't work?
Yes, absolutely. Thank you for the question. I think throughout this discussion, I think it sounds great when it's being pitched by the only company that is capable of running that type of database. I think we talked about already some issues related to sensitive data collection. We don't collect social security numbers or other numbers like that. And frankly, many of our users don't have them. I think the biggest concern to us is the cost, which I think unequivocally would go to consumers. We've seen in other states a request of $225 per transaction. So that would be on top of the $350 fee that we charge. So I don't, if the licensee is supposed to pay that, I think that's indirectly a consumer cost. I have a lot of questions about how this would work. In a separate context, I dug into kind of in my own mind coming up with a database. There's other models out there beyond payday lending. There's pharmaceuticals with sensitive pharmaceuticals that have to be managed in real time. And ultimately, I think with the complexity of this issue, we are getting that employer data. And I don't think it's a necessary step. We are going to be reporting data to Department of Banking through this bill. It would be my suggestion that we look at that data over a year or two and then determine if a database is necessary. But I think jumping into that is a sort of solution in search of a problem.
Okay, thank you. And then the second sort of issue we talked about today is the upper dollar limit vis-a-vis the 75% requirement in the bill. Any thoughts on that?
Yeah, I think that's an thank you for the question. I think it's an interesting proposal. I'm curious about the utility of it. I think there's some instances or many instances where someone would use their earned wages to pay for, say, a larger bill that you can't put on a credit card, like your mortgage or your rent or your car payment or your student loan payment. None of those can go on a credit card and you need cash to pay them. I wouldn't want to limit the utility of earned wage access to pay those bills. That said, I don't think there's anything in the bill that would limit someone from, say, doing two $500 transactions. So I don't think we would be opposed to that provision. I don't have a specific number in the cap, but I do kind of wonder what the value would be to the consumer.
Okay. Yeah, and it's interesting too. I mean, it occurs to me when you say that, like in terms of you guys putting money out there, if you have a really high wage earner who's coming in trying to borrow 75% of their income, you're I'm going to say extending credit. I know that's controversial in this conversation, but you're extending credit at a pretty high level. On the other hand, I know what's your average advance, which is
It depends on the state. I think it's about $120 on average.
right. So on the other hand, if we were to say 1,000 or whatever, it seems like it wouldn't make too much of a difference.
Yeah, it seems like it would be an edge case. Yeah.
Okay. Senator Miller.
Thank you, Mr. Chair. Amy, I want to talk about the written testimony that you submitted. So you stated that you were part of the work group that came up with the product that's before us today. And in your statement, you stated that from our perspective, there are 4 outstanding sticking points in the draft that we would respectfully ask the legislature to weigh in on. And so my question to you is, if you walked away with a consensus, why would you ask the legislature to weigh in on, I guess, some sticking points for you, for your company?
Thank you Chair Miller. I think that's a great question. I think in my written testimony, my goal was to really summarize where I think we are in those discussions. I think they were incredibly productive, and we agreed on 90% of the issues. I think there were those 4 issues I listed were still outstanding from the discussion. Those are not all priorities for Pay Active. We can support the draft as it is today, but I did think it was fair and in interest of those discussions to identify the areas where we sort of agreed to disagree.
But you want the legislature to weigh in on them, according to your testimony. You have to excuse me. So I've been a shop steward, and I've negotiated contracts. And so a pet peeve of mine is we sit at the table, we negotiate, we walk away with the consensus. Then another party that didn't get everything that they wanted leaves the room and shout, I didn't get everything. Well, no, we agree, but these are the issues. And so my question to you again is, why is it important that you have the legislature weigh in on it when the whole purpose of you sitting down was to come to a consensus?
Yeah, I think that's a great question. And I do want to reiterate, we're not trying to move the goalposts. We're not asking for any changes. We're able to support the draft as it is. The draft that was filed, I believe, looked like the latest draft from the Department of Banking. And that doesn't reflect those 4 issues. Again, we're not asking for those changes. I think other providers might be. My goal was to be straightforward and comprehensive in my presentation of what was agreed upon and what was not. Similar to the Department of Banking kind of outlined their interest in this database issue. That was not on our radar going into this hearing. But certainly those 4 issues from our conversation are, the Department of Banking is aware of those, and I wanted this committee to be as well.
All right, well, I appreciate that. So what happens if the legislature, the chairs of this committee, decide to put in all of your recommendations? To change the bill to address all of your recommendations, the 4 recommendations? What happens to what you negotiated?
That's a great question. I'm not quite sure of the answer. I think we're in support of it now. We would be in support of it then as well. I think we defer to you on your policy choices on those issues. I imagine other stakeholders would have a perspective on those 4 issues as well.
And so what happens if the chairs decided, they're not operating in good faith, so why don't we just leave things the way they are?
We support the bill now, and we support it if there are no additional changes.
Okay, nope, I'm not talking about the bill. The law states, we know what the law was, and that your industry decided to leave the state. And so it's apparent that there was a general consensus, but it looks like here that individuals walked away not happy. And so what if the chairs decided, well, you know what? They really didn't come to a general consensus because they're asking us to weigh in. So since they're asking us to weigh in, let's do this, like what we suggested last year, or let's just keep the law the way it is. So the point I'm making is you don't want to leave it up to the chairs to make the decision. And so your industry sat down with the Department of Banking and you walked away with the product that everyone, that you agreed to, that you received a general consensus. And now you're asking the legislature to weigh in on the other 4 sticking points, which you couldn't come to a general consensus on. So that's the point I'm making. The point I'm making is, what if we did decide to change the bill, draft the bill such that we address every item in this? And so someone is going to be unhappy, and probably be the Department of Banking. And so the point I'm making is that I feel that what's in here, what you've written is really negotiating in bad faith. And so that's my position. Thank you, Mr. Chair.
May I just respond briefly? I appreciate your comments, Chair Miller, and really it's my intention actually to be transparent and not negotiate in bad faith. So I had made a commitment to the Department of Banking that we would not move the goalposts, and I'm upholding that commitment and supporting this bill draft with no changes. I'm sorry it appears that way, but that was not my intention.
Yeah, I understand, and again, Mr. Chair, I understand what you're saying, Amy, and you did say that, but it's almost like you're speaking out of both sides of your mouth. Yeah, we agree, but these are 4 things we want the legislature, because this is what you said, as we asked the legislature to weigh in on. So you're asking us to weigh in on these 4 items. So sticking points. And so that's the only point that I'm making. Thank you, Mr. Chair.
Thank you, Senator. I was looking at your testimony, Molly. I did have one other question that was raised. You said question number 1, whether tips or finance charges subject to the fee cap. I think that they are. What would be the other interpretation of that?
Yeah, so those 4 issues outlined, thank you for the question. Those 4 issues outlined are areas where we did not come to agreement in the draft bill. So I think the draft bill does have tips as finance charges subject to the fee cap. There were some providers in the negotiating coalition that disagreed with that. That's not our position, but that is the position of some of the providers.
Okay, understood. Okay. Any other questions for Molly? Seeing none. Thanks, Molly.
Thank you.
Okay, John Erlinghauser. John, where'd you
Hey,
go?
I had to banish myself back to the Naugatuck Valley. Unfortunately, I had an appointment, but not that I didn't enjoy spending most of the afternoon with the Banks Committee. It's always a pleasure.
Okay.
I appreciate you having me virtually. And just so everybody knows, my name is John Erlinghauser. I'm the Senior Director of Advocacy for AARP in Connecticut, and AARP is a nonpartisan social mission organization with an age 50 plus membership of nearly 38 million members nationwide and about 550,000 here in Connecticut. And we support livable communities for all ages, aging in place initiatives, financial opportunity, and resiliency for everyone as they work and age and retire. And we're before the General Assembly every year on a multitude of bills that support these issues. And I'll just say we have had a long history of working against predatory lending and supporting access to affordable financial services. In fact, early on in my career with AARP, when the Banks Committee, long before you folks were on the committee, there was a bill to weaken Connecticut's predatory lending laws and payday lending laws, and we fought very hard against that. So we're not new to the table, and we certainly engaged on this bill last year. And I did submit written testimony, and I'll be, quite honestly, a lot of it was put together by our national office upon reading the bill. So I'm by no means an EWA expert, but I just thought I would provide some comments and observations about some of the things that were said today. And by the way, in addition to submitting written testimony, we emailed members of the committee yesterday an op-ed that a coalition of consumer organizations jointly did several weeks ago in the Connecticut Mirror, and that included the AFL-CIO, CCAG, National Consumer Law Center, Consumer Reports, Center for Responsible Lending, and others. So we've all been working together as a group and meeting. The thing that's unfortunate is we've heard multiple times about the coalition of organizations that's negotiating with the department, and they don't include any of the consumer organizations. So there seems to be a majority consensus amongst the providers, at least some of them, that the Department of Banks draft is good, but and we understand that the committee is not doing the negotiation, so this isn't directed at the committee, because in the past, for example, when we did the senior financial exploitation legislation, the chairs pulled everybody together, the banks that were on one side of the issue, the consumer groups, the legal folks, and the department, and we actually came together with something that everybody could support. And much like our previous speaker said, not everybody was happy, but we came to an agreement and ultimately supported what was a very good product for folks. Not perfect, but a very, very good product. And it was as a result of, again, several years of negotiation. Unfortunately, in this process, it's industry driven with the department through the administration, and we haven't been a part of that. So there's that issue. Several things have been said, for example, that, and I think this is a very good public hearing. I'm actually quite pleased because I've heard several legislators say throughout the hearing that I haven't thought of that, or I didn't look at it that way, or I didn't see that perspective. And, one is on the registry as an example. I mean, at the beginning when I was in the hearing room, one of the providers gave a big laundry list of what somewhat seemed like word salad as to why the registry wasn't possible. And then, Monica Burks from CRL said, certainly it was possible, but, based on questioning from Senator Miller, based on the fact that, we are talking about the fintech industry. And then one of the providers of said service for the payday loan industry said absolutely they can do it. Now, granted, they have something to gain by that, and that has to be taken into consideration. But again, that's something that should be looked at and that should be considered and should be attempted to be worked out and shouldn't be dismissed because the industry, went out in a negotiation over the department on something like that. It was important enough for the department to include in recommendations to the legislature as to things they would like to see strengthen the bill if it moves forward. So, and then there was some discussions about, APR and no other options. I feel a lot of sympathy for folks who are in a position to feel the need to have to use these products. We, work very hard for consumers. On the other hand, that doesn't mean there shouldn't be good. Yes, time up.
The buzzer went off. Yeah.
I don't
briefly summarize if you could.
Well, I'll just say, with regards to that, we regulate all kinds of industries that people need and use and have to use, whether it's electricity or insurance or you name it. And so, the fact that it's, we don't necessarily agree with this industry, but we should make sure that consumers are protected the best they can be. And some of that should be directed from the consumer groups to the process as opposed to from the industry to the department, based on an industry-driven model bill that is happening in other states across the country. So we appreciate the due diligence that you as the committee do, and we thank you for having us here. And I'll do my best to try to answer any questions and address any of the concerns that you all may have.
Thanks. I hear you on the and thank you for the comparison to the senior exploitation bill and sort of the negotiation there. This is a fundamentally different issue. It's, in a lot of ways, it's been more difficult, I think. But just know too that I think from the consumer protection standpoint that those arguments, those points are being heard, and I think I'm going to speak for the department. I think as well that they're heard from their standpoint as well. So it's not as if those points have not been considered in the negotiation. I know, we on the committee haven't been in the room for a lot of those negotiations, but I think understand that those viewpoints have been heard. Any questions for John? Rep. Delnicki.
Yes.
Good evening, John.
Good evening, Representative.
So if there was anything that you could come up with to make the bill better, what would it be?
Well, I would certainly say the idea of the registry is something that I could see us and other members of the coalition supporting. I think that's certainly one. And I think there are other things that we could look at, and I'd be more than willing to, talk with our national office and come up with some suggestions that we could put into the legislation in addition to the registry. I think, it would be important to be able to inject some of those things into the negotiation. So, again, I think if in fact, people want suggestions, I can make them. I think that's one. Caps. It was interesting because we did have a meeting with the industry, and at one point they said, they pointed to, I think it was Washington State, where there's a $10 cap, and we asked, well, is that your bar? $10? Well, not necessarily, was kind of the answer. So it's kind of sometimes hard to get into a discussion when out of hand, the suggestion is by the industry, at least anyway, dismissed, like, for example, the registry. I'd be more than happy to provide you with some additional information that we think could strengthen this bill.
Good. Well, I'm going to look forward to that. Thank you.
Yeah.
Thank you, Mr. Chair.
Thanks, Rep. Delnicki. Okay, seeing no further questions. Thank you, John.
Thank you all for the work you guys do.
All right, Ashley Urisman is next on my list, who is online with us. There she is.
Hi, good evening. Hi, good evening. My name is Ashley Garrison. I am the Director of State Government Affairs for the American Fintech Council, or AFC. I'm on the road tonight, so if you hear background noise, I apologize. But I want to thank you, Chairs Doucette and other members of the Connecticut Banking Committee. I'm here to testify in support of SB 1393 with certain amendments. We at AFC are the Senior Trade Association representing the largest fintech companies, including some of the biggest providers of earned wage access or EWA services. Our mission is to promote a transparent, inclusive, and consumer-centric financial system and support responsible innovation in financial services and encouraging sound public finances. You've all heard tonight that EWA is an innovative financial tool that empowers workers to access their wages really in a flexible way that best fits their lifestyle. This includes through their employers as standalone products or as part of a subscription. And we really applaud the Connecticut legislature for considering this regulatory framework that would allow companies to really support EWA in Connecticut again. But we are concerned with the provision of this bill that requires users seeking the transaction to bring at least 75% of their earned wages, and we ask that this requirement is floor be removed from the bill before it advances. We respect things of the legislature to protect consumers, but withdrawal accounts really should be set by the providers instead of by the statute. This ensures more flexibility within the withdrawal accounts and ensures that they fit the provider's models and serve the consumer best within this ever-changing market. Simply put, EWA providers have the flexibility to make determinations based on the real-time data that they see from their users to ensure that EWA products adapt to meet everybody's needs. That said, we really applaud the inclusion of some of AFC's core principles of responsible EWA in this bill. That includes a mandatory no cost action available for all users, strong and clear fee disclosures for all transactions, no underwriting or credit checks, and the ability for users to cancel their EWA service. So, in short, we believe that SB 1396 establishes great standards for Connecticut users and overall better serve the workers of the state when it's amended. Thank you for considering the issue.
Hey, thank you for joining us. One question I had, does the American Fintech Council have a model bill that they endorse or a particular state that they endorse?
Yeah, so you've heard from a number of our members today who have been working on model legislation. We really applaud the Nevada legislature as a really good example.
Okay. Any other questions for Ashley? Seeing none. Thank you, Ashley.
Thank you so much for your time.
Okay. Moving on. Next on our list is Sarah Mamula. Hi, Sarah.
Hi, good evening. My name is Sarah Mamula, and I am Head of Government Affairs for the Financial Technology Association, an organization representing innovative fintech companies, including leading earned wage access providers. FTA champions the power of technology-centered financial services and advocates for the modernization of regulation to support competition, inclusion, and innovation. Additionally, I'm also a Connecticut native, and I'm sorry that I couldn't be there in person this evening, but I have family in Madison and New Haven, so I'm thrilled to be with you in at least a virtual capacity. On behalf of FTA, I thank the committee for the opportunity to express our support for Senate Bill 1396. This legislation provides important regulatory clarity for earned wage access products and the workers and employers who rely on them. Getting paid once or twice a month just doesn't work for most Americans, and 2 in 3 people agree that the current pay cycle is broken. EWA fills this gap by allowing workers to tap into their already earned wages between pay cycles. It helps people pay their bills on time, manage their cash flow, and handle emergency expenses like a doctor's visit or auto repair. EWA is safe, consumer-friendly, and transparent, making the product unique to other options on the market. There are no mandatory fees, no credit checks, no interest, and no impact to credit scores. EWA providers always offer a no-cost option, and workers can only access a portion of their paychecks before payday. They are non-recourse and simply let people access the wages they have already earned. These protections apply whether the model is business to business and offered as an employee benefit or direct to consumer, which allows any worker to choose the provider that best fits their needs and is flexible should an individual switch jobs. We support appropriate regulation like SB 1396 that is risk-based and tailored to the unique nature of these innovative products. This bill would create a durable regulatory framework for EWA providers, ensuring strong, clear consumer disclosure requirements and codifying the protective consumer features of the products. We thank the committee for championing innovation in financial services and working to provide the people of Connecticut with quick and convenient access to their already earned wages. We urge you to support SB 1396. Thank you.
Thank you, Sarah. I'll ask you the same question as the previous speaker, given I assume you're basically a 50-state trade association, essentially, or?
Yes, we are. We advocate on earned wage access, including other fintech related matters at the state and federal level.
Right, right. So I'm just trying to get an idea of sort of what the thought process is from your perspective. What would you say? Do you have a model bill or a model state that you sort of look to endorse for this?
We, similarly to AFC, we have member companies, earned wage access providers that we work with, and are model agnostic when it comes to state level legislation. So we support business to business as well as direct to consumer models.
Okay, but you don't have a preferred.
I don't have a draft text.
We like Missouri or whatever, or we endorse the ALEC model bill or anything like that.
No, we have endorsed other legislation. I mean, including the hearing in Maryland today. We expressed support for that bill.
Oh, okay. Okay. Actually, that's interesting. Tell us from your perspective about that bill, because we've heard about it, but I have not kind of studied up on it or heard directly from anyone in Maryland. What does that bill look like compared to ours?
Unfortunately, I was not able to be in two places at once, but in conversations with our membership, we determined that it was a helpful bill for the industry. Okay. And provided helpful regulatory framework.
Okay, we'll take a look at it. All right, any other questions for Sarah? Seeing none, thank you.
Thank you.
Okay, Ben LaRocca, you're up. Thanks for your patience.
Okay. Oh, there we go. All right. Thank you, Chair Doucette, Chair Miller, members of the committee. It has been a long day here. I'm not going to read my testimony. I'm going to make a couple comments and then hopefully ask some questions because maybe that might be most helpful. First, I also want to thank Harry and Tanisha, who's going to be coming up after me, as a couple of earn-in customers who valued the service so much that after not having it for over a year, they still were willing to take time off of work to come and share their stories with you, which, I think that speaks to the value that this product makes to some folks. And it really makes a big difference to people when they have a tough time in your life. We've been there for them. I want to thank the industry colleagues, the Department of Banking that have worked here, the members of the committee that have worked on this issue for a long time, spent a lot of time working on this issue, I'm sure more than most of you would like. So thank you. Happy to talk about some of our recommended changes to the bill. We definitely do want to get something done. I think the bill draft, as we see it, is maybe a point in time where we needed something due to the committee schedule, but there's still negotiations to happen. So want to continue to work with everybody on those. A couple thoughts on the database. For an average payday loan, that the database would be tracking, the finance charge is like $65. So a $3 fee on $65 is 2%. In this bill, our fee would be $5. So even at $2, you're talking about a 40% increase in the cost to this. Essentially what you would be doing is making 99.9% of the people pay for something that's totally not needed. The way the industry works now, if somebody were to get advanced multiple money on the same income, the company would take the downside risk for that. So it's kind of a solution in terms of a problem, and it costs a lot of people money for a problem that just doesn't exist today. Wanted to make a couple comments to follow up with the gentleman from the AFL-CIO. Just we had the state of Connecticut was one of the largest users of Earnin. Employees of the state of Connecticut, we were one of the largest employers. Same with Stop and Shop. I think between those two organizations, we had about 1,000 of our customers worked at those two. So, so there's a need for the folks that work in jobs like that for a product like ours, and a lot of people were using it. And then lastly, I want to talk a little bit about frequency of pay and how Earnin came to be. Our CEO was the CEO of another company, and he would do this out of his pocket to his employees, give them advances on pay out of his pocket. His employees loved it. When he sold the company, one of his employees asked, "Hey, would you still help me out?" And a little light went on and said, "Hey, my employees love this. Other employees would like it too." And that's how Earnin was founded. He did it out of his personal bank account, out of his pocket. Now we have over 2 million customers in every state in the country other than Connecticut. We still have Connecticut customers, just not on this product right now. So thanks. I yield back my time and happy to answer questions. Thank you so much.
Thank you. Question for you, because I think you're probably the best authority on this, and I think you have the most sort of stake in it on the question I asked Molly about the tip model. I think it has been clear now for a couple of years that tips are considered finance charges. The bill essentially says that, although there's a monetary cap as well, sort of built in there. So what is your view on what it says on in the bill right now? Are you advocating for a change to that provision? And if so, what would it be?
Yes, we are. Yeah. So thank you so much for the question. I appreciate it, and definitely happy to talk about it. I know that tipping in financial services is novel. It's not necessarily novel in the industry broadly, or excuse me, in the economy broadly, but it is in this industry. It is our business model. For the first 10 years we were founded, we were 100% funded by voluntary donations of our customers. And to my opening statement, we only get paid if our service is so valuable that our customers reward us with a voluntary contribution. We have to provide a service that they value. A lot of financial services make money when the customer fails, but we only make money if they think it's so valuable that they will voluntarily pay us. We do think that tipping is an expressive conduct, and we think that we have a right to solicit tips. Those are both constitutionally protected. We think that the provisions that were put in SB 1033 are unconstitutional. We provided some input in our testimony that talks about that. And NetChoice, who also testified, did a really deep dive into the constitutional issues around tipping, and would be happy to go into those a little bit more. But there's a number of Supreme Court cases that are implicated.
Okay. I mean, I guess it's an open question at the very least. It's a novel question. It's not one that's been, that there's clear case law on or anything like that. And I looking at your testimony now, and I see that issue is raised, but again, nothing that's really directly on point. Certainly it's like I said, sort of a novel issue. Could you live with the model that's in the current bill?
We would prefer that tips are not finance charges and are not limited. It would be very difficult for us to operate as with that provision as currently written.
Would you object to setting the tip to 0? We had some testimony earlier.
No, we would be happy to do that.
Okay, because
so I think that
it currently says in the bill that there'll be a sort of a disclosure that the tip can be 0. I mean, was that part of your discussions with the department?
I think that was actually in one of our earlier. So one of the other, I don't remember who testified at this point now, but we shifted versions. We sort of had our model bill version that's based on the states that have passed it, and we sort of switched out from that version and went into the Small Loan Act language specifically. And I think when we made that transition, that fell out. We would be happy to do that. The no default or the default to 0, depending on how it's written. I think that's an important point to make sure that it is voluntary. And I think there is a difference between, and I think the product that got tipping into trouble in the state of Connecticut wasn't really a voluntary tip. It was more of a choose an auction price to price your loan. And I think that's a different concept and product than the way that Earn and monetizes, which is strictly voluntary with no impact on your service, good or bad.
Senator Miller has a question.
Thank you, Mr. Chair, and hello, Ben. It's good to see you.
Likewise, Senator.
So, Ben, I had a question. I don't know if you heard the exchange between Molly and myself. Did you sign off on the bill the draft that have here today?
Yeah, thanks, Senator. That's a wonderful question. Again, I would say that this was a point in time. I don't think anybody in the working group felt that what we submitted was going to be the final product. I think we wanted to get something to you so we could get it in legislative language and we could continue that discussion. And I see this as one step in many steps to go before we reach that final agreement.
So, you know that I was a strong advocate in trying to get the two parties at the table so that you could work on some type of agreement. And I'm glad that you were able to do that finally. I'm glad that you came, to a consensus. But I think, and I'm saying it to you, like I said to Molly, I just have a problem when you walk away from the table with the consensus and then you come before the committee and they say, hey, look, this isn't what I want, but this is how you can make it better. When you sat down at the table with each other and you couldn't make it better at the table, but you're going through the back door. And so it's not just you, it's just something that I've seen here in this building since I've been a legislator, and I've been a legislator since 2009. And, I've had an exchange where I sent the individuals back to the table and said, okay, you work it out and come back to us. And so in Molly's testimony, she said that she wanted us to weigh in. And I'm at the point now where keep it the same. If you can't come to a consensus and you want my chair, you want our committee to work on it for you and work it out, which we've tried. And again, no one's happy. And so I just feel that we're at the point now where no one's going to be happy and everyone is going to cry in their milk to say, I didn't get my way, but I'll accept this anyway. And I just really have a problem when two people, I should say, when a group of people sit down and they give their word, because that's what that was for me. Those negotiations, that was binding. And when you walk away from the table and say, okay, this is what we're going to do. And so now you're leaving it up to my co-chair and I and the committee to say, hey, look, we can make this better and this is what we want to do. So again, it's dumped back in our laps. So, and I just want to make that point, Ben, because honestly, as you can tell, I'm pretty disappointed. I'm very disappointed in the actions today. Thank you,
Ma'am.
Mr.
I
Chair.
appreciate that feedback.
Thank you, Mr. Chair. So you started out as a totally voluntary.
Correct.
loan. And is it your desire to have the tip model back, yet without any requirement of a tip? And reading about the fact that there's allegedly some kind of a court case pertaining to voluntary financial technology tips violate the First Amendment. Are you party to that?
Yeah, let me break down a couple things. I would say our goal is that payroll becomes more worker friendly. Right now, it's a two-sided market, but really the employer is the only one that matters because they're the one that actually pay ADP and Paychex and other companies like that. We own a payroll company. We are trying to create a payroll company that is more worker friendly. So that way employers will want to use us because their employees will want to have us deliver their payroll in real time because that's the goal. And the goal is to do it for free. We're not able to do that yet, but that's where we want to go. I think our current business model relies on voluntary contributions of our customers. Everywhere we operate, that's the way we do it. We think that legally solicitation is protected. There's a court case on Schaumburg on that. So we are allowed to solicit support from our customers. On the customer side, they are also allowed to support us if they want. So if the state of Connecticut right now says we have to limit a tip to 36%, that's like 29 cents. So it would basically be illegal for a customer to say, I like earning, I want to give you $1 to help support your operations because of that. And so that prohibition on expressive content, like the Center for Responsible Lending, who we heard from earlier, they solicit donations. They actually call them tips on their website. If you go to CRL/donate, they ask for tips on there. AARP solicits donations. So the fact that they can solicit donations and we can't is a content-based restriction. So the government saying you can solicit and you can't is a content-based restriction. And so we would the order of magnitude we're talking about is like $1. Our average tip is $1, but it's the difference between us being able to operate and us not being able to operate, and the business model that literally millions of people are choosing in the market today. And so, sorry, I'll pause there.
So if you went to a business model, say tomorrow, where it was strictly going to be tips that are strictly voluntary, that they start out at 0, you would be able to operate.
So yes, that is the way we operate based on voluntary tips elsewhere, and we would like that to be how we operate in Connecticut. We do have an expedited fee now that is part of that, which is similar to what other companies charge. So it's both.
Well, thank you for your candid answers. I appreciate that. Thank you, Mr. Chair.
Don't see any other questions, so.
Thank you so much, members of the committee. Appreciate your time.
Tomanika Beach is with us online. However,
yeah, it looks like my camera is turned upside down, and I do apologize. I do apologize for this. But good evening, Senator Miller, Representative Duquette, Delnicki, and Foster, as well as the remaining members of the Banking Committee. Thank you for allowing me to speak at this public hearing for EWA Senate Bill 1396, which I am very much in support of. This bill will enable Connecticut residents like myself and many other working class citizens who are single-handedly trying to take care of our families to live more comfortably in this state. I make a decent wage, but after I cover all of my expenses, I'm left with pretty much nothing to hold me over until my next paycheck. I avoid using my bank's overdraft feature as well as my credit card because they both do not offer the best fee options. Prior to April 1st, 2024, I was a customer of EWA Financial Apps. It was a great relief to know that if I fell short one week, that I could borrow the necessary funds at a click of a button until the next payday. It enabled me to cover unexpected daily expenses that arose from unfortunate situations. The EWA apps that I've used for the past 4 years, like Earnin and Moneyline, to the best of my knowledge, does not engage in any predatory practices that I know of. Excuse me. As a longstanding customer, I've never felt that my money was wrongfully being siphoned from my account by way of exorbitant or fraudulent fees. The fees that I paid for borrowing was within reasonable range of what I could afford. Therefore, I never felt that I was drowning in debt, as some may assume. In the recent months, I've never experienced this much hardship due to the high cost of living in Connecticut in these inflationary times. Out of all the states that I've lived in, New York, Las Vegas, Florida, all of which offers EWA, Connecticut is the most expensive. We are your constituents, and if there's ever a time that your help is needed, is now. There's an urgent need to reinstate EWA in Connecticut, which should be made available to us regardless of whether it's being offered as a benefit through our employers. Considering the potential possibilities of stipulations and restrictions that could potentially be involved, I would prefer to have full autonomy over how I access these funds. Thank you in advance for your consideration, and I really do hope that the EWA does get reinstated in Connecticut.
Thanks, Dominica. Good to see you again, even
Good
though
to see you again.
we're looking at you sideways.
Yeah, I feel so bad. I'm so sorry. I had it fixed all day, and then all of a sudden I'm like upside down. I'm really sorry
Are
about
we
that.
sideways? No, you can see us straight on.
Yeah.
Just can't see you. Okay, well, good to see you again. I know you joined us last year. I remember your name. I remember your testimony. what have you been doing? So you haven't been able to use Earnin? Have you been able to use another company in the meantime?
No, no, they're all have been I guess discontinued business here in Connecticut. So I haven't had access to any of them. In the meantime, I'm just using like my high interest credit card, or I sometimes would use the overdraft feature, which I don't, I prefer not to because of the cost of it. It's $38 to borrow money from the bank anytime you take it. And those fees are not refundable. So
Yeah, I was going to ask you that too, if you've incurred any overdraft fees or.
yeah, I have quite a bit during this past holiday season. Just to give you an example, I had an unexpected expense where I had to pay upfront for something that just came out of the clear blue, and I had to dip into my rent money. I had to dip into my 401k. I had to dip into some other sources of income. And if I had that the EWA app, or if I had access to it, I would have been able to work my way out of that until my next paycheck. But unfortunately, it left me in a bind.
Okay. And just curious, I know Earnin was offering a sort of a fund, a support fund. Did you participate or get any?
I did participate. That was I think at the middle part of last year or the earlier part of last year, right when we were doing this. So it was like at the early part of last year, but it was like a 125 stipend that was offered at that time.
That was just a one-time thing and there were
It
no.
was a one-time thing for any overdraft fees that we incurred on our accounts.
Okay. Okay. Thanks. Senator Miller.
Thank you, Mr. Chair. How are you, Tamanika?
How are you, Senator Miller?
Doing well. How's your husband?
He's doing good. He's doing good.
Good.
Yeah.
Tell him I said hello.
I know.
So I appreciate you testifying today, and I appreciate the question that my co-chair had asked is, how have you been surviving? And so I don't know if you heard the exchange between myself and Payactive and Earnin. You know, Tamanika, that I was a great proponent of trying to get the parties at the table
Reach
to
an
come to
agreement.
some type of agreement.
Yeah.
And as I just told Ben, I'm kind of disappointed that they walked away with the consensus, and then again, they're dumping it in the laps of the legislature to come up with a draft that they could be happy with. And so honestly, and this is a matter of record, that my position now is the pressure that has been put on the legislature to do something. I get that. And what kind of pressure did they use? They use our constituents. And so, as I explained before, and I said earlier, I grew up in one of those families where my father had to use loan companies. Back then it was loan companies, and they were high interest rates. And he went there to tie over. He had 7 children, a family of 9. And so he was the only breadwinner, and he needed to pay the bills. And so I get it and I understand it. But I think in order for this to work, everybody has to work together.
All
We're not
parties
going to
have to come
walk
together,
away
right.
with what we want.
Yeah.
And so what has happened is that they've slowed down the process again. And so, and to put it on us, the responsibility on the legislature is not fair. But I was hoping that they would walk away from the table, and it's just a matter of the committee looking at it and say, this is a good product. Both sides are happy with it. They can live with it, because when you negotiate, nobody walks away happy. They can live with it. And we can put our stamp of approval on it and go. But it doesn't look like it's that way. And so I know that individuals, the users of this product, feels that it's our responsibility, but I don't think it's just our responsibility. I think it's also the responsibility of the providers that give you that money. And so, and I'm going to throw it out there. They're pulling out the stops to get this product back in the state. And it was their choice, by the way, to leave. We didn't tell them to leave. It was their choice to leave the state
Stipulation.
because they said it wasn't economically feasible for them.
Right.
One good thing that it has done is it allowed me to form a relationship with you.
Yeah, that's correct. A memory.
I just have to put that out there that it's as legislators, excuse me, we want it to work and we want it to balance. But this backdoor trying to get your way doesn't work for me. And I believe in your word being your bond. And so I just want to let you know that I'm just in a very awkward position now. I'm in a very awkward position.
What
I
do
don't
you
know what I
not agree with, Senator Miller? What are there certain things that are in the agreement or the proposal that you don't agree with? I mean, what is there that has to be worked on?
It's not me, it's them.
Oh,
We gave the charge to them like I was trying to do last year when I had both sides sit at the table. The charge is them because they're the players in this game. You're the player in this game. So it's not me. It's them giving us a product to say we can work with this and both sides. There's a general consensus, both sides can work with this. But I'm hearing today, no, we can't work with, we agree with it, but we can't work with it. And so now we're going to come back next year and you're going to want more. So I just want to make it publicly known that I do support the users of this product. And I want a product that will work.
yeah, we
But
do need
also,
something. Definitely, we do need.
but the
something to
industry
help
that's
us.
providing that product to you, they also have to be willing to compromise. And so
Right.
I just wanted to bring that up and
Okay.
make you aware of that.
Well, thank you for sharing your thoughts on that. And I would definitely like to go back to the to Ben and speak with some others, and hopefully we can come up with something else.
Thank you, Mr. Chair.
Okay. All right. See no further questions. Thanks, Tamanika, for joining us. Hopefully
Thank
next
you,
time
Senator Duquette.
we'll see you.
I'm sorry. I do apologize again.
All right. Next on my list is Annette Diaz, who I don't think is with us. And then after that is Tanisha James, who I think is with us. Once again, also a repeat participant, right? You were with us last year. Welcome.
How are you?
Thank you. How are you?
I'm good. I'm okay. Thank you. I'm glad to be here. And I want to just thank Chairs, you, and Miller, and other ranking members, Delnicki and Berthel and other members of the committee. Like I said, well, my name is Tanisha James. I'm a resident of Waterbury, and I would like to thank you for the opportunity to submit my testimony today in support of this bill, 1396. Last year, I was virtual, but it was more important to me to be here to testify in person, because this service that I was using, which is Earning, one of the EWA services, was very beneficial to me. I can't speak to everyone else's experience, but I know that it did help me build some financial independence and help me gain some financial stability. There's a lot of things that I hear that are untrue about, how the service works for me. As far as the tipping, when there was tipping, it was an optional service. It wasn't a requirement to use the service. And the way that I took it as is, when I did tip, I didn't tip often. And I think the most time that I tipped was $3. And it took me some time to get there because I couldn't afford it. I was at the time looking for money, in an emergency or whatever. I have 3 kids. I'm a single mother, and I wasn't trying to give money away. And so, but then I thought about it and I said, hey, okay, if I tip, this little tip will allow them to kind of better the services, better the experience, better the app, maybe expand, offer other services and products, et cetera, et cetera. I, from my perspective, the way that it helped me build financial stability is that, you know, as myself and other Connecticut's, you have a permanent job here, you get paid biweekly. Well, my biweekly pay wasn't enough by the first, between my insurance payment, between my rent, between having to buy food, by the time that I'm supposed to pay my electric, my gas the next following week, I don't have that because everything went out towards the first of the month, or God forbid there was an emergency, like I think it was like my radiator or water pump, one of the two. And I was like, well, I'm strapped for cash. I don't have family that I can depend on. So what am I going to do? So that started me looking for this particular company, and I settled on it. There's no interest rate. There's no credit check. There was no monthly fee that they was asking me for. The only time that I ever paid a fee was if I needed to get the money instantly, like that day. There is a free service where sometimes I've used the service and I said, well, you know, I don't need it instantly. I can wait the 1 to 3 days. And it was in my account within 1 to 3 days without charging me anything. And even if I did pay a fee, the most that I've paid was just like going to a regular ATM, which in some cases were cheaper, depending on how much money that I was trying to access of my wages at that time. So it's not a loan, it's wages that I've already earned, and I'm accessing that, just not having to wait until I get paid. And so again, these are fees that are less than me going to the ATM sometimes, and it was convenient for me. And the way that I looked at it is that for some of my bills, just like a cable bill, there's a $20 fee. And if I had gas and electric, that's another 10 for each service. That's $40 a month. At the end of the year, that's $480. I'm out of fees alone. What are my other options? Okay, credit card. And credit card for someone like me, it's 24.99 to 26.99 point interest. God forbid you're only paying the minimum balance on that every month. You're carrying that over. So at the end of the year, I'm no better off with using my credit card to depend on. I'm no better off with a payday loan that's even more predatory. And then both of those things affect my credit, which affects me long term. So the way, again, that I built my financial stability was through using this service through earning, because it allowed me to access money that I know that I worked for, and I can use that to pay my bills. And I think it's an unfair statement for people to think and assume that people like myself are going to be irresponsible and think that it's just some magic payday, like, oh, I just access free money. No, like Tomanika said, she got 401k. I got money from my 401k as an emergency too, and I have to pay this back. This is money that's in my 401k that I built into, and this is something that, again, that I have to pay back. So I don't think that people are talking to people like me. There's all these other opinions, but I think if you hear from more people like me that's actually using this service and that's in this position, you will find that it does provide financial freedom. It does provide financial stability. If you think that I can be in a worse position by saving $480 a year, because again, once I'm able to access those earnings early, I'm able to pay my bills on time. So there's no more of me paying those late fees. And if I'm saving $480 just in 1 year alone, well, what about the second year and the 5 year? Then I can start putting that $480 to use to pay down the credit card debt that I already have, the student loans and car payments and other things. And then you open up to allow, like I said, to provide somebody that financial stability. And you allow these people that will look at this tool, like I said, as a resource and not something that's predatory.
Okay, thank you. Thank you. I have a couple questions. So
Sure.
we hear that little buzzer go off and we
Yeah, I
we
know.
try to
I'm a
keep
talker,
everybody-
so I'm sorry.
But that's all right. That's all right. That's all right. And I think you're our last speaker for tonight. So we've got nobody waiting. Thank you for all that. I was going to ask you, and you sort of started talking about it. You know, what do you think? I don't know if you heard some of the a few of the earlier speakers. There was Ms. Burks from the Center for Responsible Lending, I believe her organization was talking about sort of the cycle of debt and they have a report. I don't know if you saw it. You know, they
done some research and polled people and looked at the industry, and they talk about sort of the cycle of debt, people sort of stacking these things on, going to multiple companies, getting advances from different apps, and then ultimately getting in a situation where maybe they do miss a repayment on one of them, or some of them result in an overdraft fee on their bank account. Do you think that's a valid concern? I mean, it sounds like you know, probably using this responsibly, right? And there are others who might get caught up in it. Do you see that as a concern that we should take into consideration?
No, I don't think that that's a reasonable concern because, again, when you are, struggling, and again, this is not even paycheck to paycheck because of the cost of inflation and everything else these days. You're not living paycheck to paycheck. So you're living to pay your bills and then you're struggling to get by until the next paycheck. And so I guess as far as what her perspective is, you know, I appreciate her opinion, but I think that she's not really talking to like people that are realistically like in my situation. And in every service, there's always going to be somebody that finds a loophole, wants to abuse a service or something like that. But again, we're talking about hardworking people that have jobs and, you know, they go to work and they earn a living, and all we're asking is to have the opportunity and the option, not to have my employer decide whether I can have my pay a few days early if I have it, because life doesn't wait for an emergency. Life is not, I can't say, oh, you know, my car breaks down on Tuesday. Oh, well, Joe, can you hold my car till next week, Thursday, till I get paid? I mean, like, no, it doesn't work that way. You have to have an option that you need to rely on to be independent. Like, I don't have to worry about whether if my mom or my cousin or my second uncle or my father's side is going to loan me the money. No, I can say, well, you know what? I know I did work. I know I can go in and I can access my wages early to take care of a potential emergency, or to just, again, just be able to have the option to maintain my finances as I want to. And I think the average hardworking person with that option will do so, because again, what are you saying to me as an option? If I don't have this as a resource, then what are the options that people like me have? And those haven't been working because we're in the predicament that we're in. And then I don't understand how we can't have a conversation about why Connecticut is the only state that can say to me that I cannot have this service, but all of the other states have figured out a way to not have the problem.
Well,
that we have a problem in this
that's
state.
not true. It's all over the map. There are some states that are really close to what we're doing here. Okay. And they don't say that. And
Well, I mean,
shaking
that's
his head
just
in the
my
back, but
perspective.
we
I
can
know
go.
well, let's say the
we can-
majority.
It's all over the place. But the other thing I want to say is that, you know, Ms. Burks actually made the point that she said she does go out and talk to people who, and again, they collected a lot of data. And she said a lot of people admit, well, this may not be a good deal, really. You know, there may be a lot of fees, you know, whether, you know, and the tips and everything. And,
Well, I just
but
think
it's
that's
what I
propaganda.
have to do. And that was sort of.
I've
her
stood
point.
at bus stops. I've handed out
Yep.
flyers. I've submitted a change.org petition. So I talked
Yeah.
to a lot of people that didn't even know that this was a service
Yep.
that was offered in Connecticut before it was cut off. So
Yep.
I'm not sure what people that she's speaking to, but again, I certainly do not think it's people that are in my position, because everyone that I have talked to and associated with, as far as if they would use this service, if they had the option to, everyone would want the option to use this service, because again, it does provide that financial freedom. Because what else do we have to depend on? What else better service or tool or resource that you can use other than your own self-independence, knowing that you have that there for you as a safety net, knowing that you worked?
Yeah, I hear you. On the tips, you said you left a tip. I mean, why would you leave a tip? Tell me why you would leave a tip. And do you think that there should be no limits on tips?
When you say a limit, you mean like a mandatory limit, like you were saying, like, oh, a person is obligated to leave like a certain percentage of a tip? Or I think that we
No, like a cap. So I asked you two questions. Why would somebody leave a tip? I mean, myself, I don't use these apps, but sometimes I'm on GoFundMe or whatever. They ask me to leave a tip and I say, why would I? Why would I leave
Why
a
would
tip?
you leave a tip at a restaurant? I go to some restaurants and they call it gratuity now. It's already included in my meal, and anything after that is a tip. Why do you leave a tip? To better the service.
Do these
Again,
apps
because
encourage you to leave a tip?
no,
No?
I, again, as I stated, I left the tip because, and it took me some time to get there. And when it asked you, do you want to leave a tip? I didn't leave a tip. It was 0. I slid it to 0, wherever it was. If it was at 0, I was like, okay, I'll make sure it's at 0 because I cannot afford to leave a tip. I need access to my money for a reason. So not even $1. But then I took the $1, maybe $1 here. Like I said, no more than 3 times did I tip. And I know one time, maybe $3. But again, it was because I like using the app. I like using the service, and I wanted that to continue. And I felt that those tips, again, would be used to help the company expand the service, expand customer experience with the app and certain things like that. And that's what my reasoning was. But did I have to leave a tip? No. Did sometimes, like I said, I did not leave a tip.
So, and you also participated in the fund that Earn-In had last year.
When they gave out the $35, I didn't get any of that because number one, I felt like, $135 wasn't going to make or break me, but I knew that they were doing that to members to kind of like, help them kind of like offset. And I thought about everybody else, and I said, well, somebody might need to have that a little bit more than me. So I didn't want to be in a line or in a place that would be more beneficial to them helping someone else, but I could have.
Okay. So you haven't had a relationship with Earn-In since then, since we last saw you?
When you say relationship, what do you mean?
You're here on your own.
I've always been on my own.
Because you
At the
passionately on
very
this
moment
issue.
that I found out that this service was I could no longer use Earn-In, I reached out to Earn-In and said, what do I need to do? What can I do? Tell me anything. And then after sending 2 or 3 messages to support, someone sent me an email and said, well, hey, this is what's going on. Would you like to be a part of it? Yes, I would. I'm here. I took off of work today. I've been here since 12 o'clock because this is an important service to me. That's how important this service is. That's what it means to me to have this service back. And when it left, I had to pick up a second job, which I did. And, it was a seasonal job. It ended, and now I'm back to scraping and scrapping.
Thank you. Senator Miller.
Thank you, Mr. Chair, and good evening, Ms. James. Thank you for staying so long.
Yeah, absolutely.
Appreciate it. I love your energy.
Thank you.
So I just want to clarify something. And I said it to the last person that testified. We did not kick the industry out of the state. The industry didn't like our rules and they decided to leave. Our new law. And so my question to you is, how many times when they were in the state, how many times a year did you use Earn-In?
Well,
Or any app that the EWA?
Okay, so yes, it was only Earn-In that I used, and I could say I used it at least about maybe 4 times a month, and no more than I would say. It would be maybe less than the $20. But again, if I'm paying out $40, even if I use that consistently as a year, and I say okay, which again it wasn't 20 because I think the most fee that I used, I want to say was like $3.95. And I only maybe had to do that once or twice. And because it goes depending on how much of my wages that I'm trying to access early. It depends on that dollar amount that I would determine if I get it instantly, am I going to pay $1? Am I going to pay $1.50? Is it going to be $2? Because like I said, sometimes even if I used it 4 times a month, maybe 2 of those times I chose the free option, meaning that I got it into my account within a day or 2 and I didn't tip. So that means I accessed my money early, totally for free, no tip, no instant fee. And so again, even if I am paying those fees, certainly a late fee is more at the end of the year. Overdraft fee is more at the end of the year. So even if I'm paying fees every time I use the service, those fees are still not going to amount to the fees that I would be paying on the 1 or 2 or 3 bills that I would have running late.
So if you said you use it about 4 times a month?
Yeah, maybe.
So did you always find yourself behind the 8 ball then? Like you could
No,
never
not
get ahead?
necessarily. As I stated, Senator Miller, I started to use the app more consistently to make sure that my bills were being paid on time, because I would have bills that were, be reflected at different points. And being that I only get paid bi-weekly, I have 3 children, I have car payment, I have rent, I have car insurance. Those are pretty like some hefty bills. And, they're all due. And then, I have to worry about the cost of food. I have to worry about the cost of gas. I have girls. I have to make sure that, I guess their hair is done. I have to make sure my hair is done. I work, it's laundry, it's clothes, it's all of these different things. So I use that in little increments. When I would get paid in the beginning of the month, that would be like my main time that I pay all my high bills. And at that time, I don't have anything else. So maybe I might go in and say, okay, well, I'll take $100 right now, and that will get me through the week with gas, and I'll buy a little bit of food or whatever the case may be. And then once my bills come on 2 different days, I'll go in and I'll take the money, or have it go into my account. So when I set up the payment, the money is there, and then I'll go in and do it for the next bill. The payment is there, and then I don't have to worry about those bills and everything like that. And the service is totally voluntary. If it was up to me when the time came to make sure that, I made sure that whatever I took out early, was kind of sort of like paid back. And the thing about that is that, there is no bad credit thing or nobody calling you or hounding you. The worst thing that's going to happen is you don't have access to the service until it's paid. Yes. But again, because I started to see how it helped me be more financially. And I knew that if anything happened at the end of the day, can't depend on my mama, ain't got no friends, ain't got nobody, can't use this credit card or don't want to, then I can depend on myself and the wages that I've earned to, again, get me through that financial struggle that I was going through.
And so one of the reasons that I stayed on this committee is because I realized something, that we have individuals who are unbanked and underbanked, and individuals who struggle because there aren't products that help them to manage their monies and to save their monies. And I was just talking to a credit union where they have programs to help individuals. And part of the program, not for this particular bank, but in my research, is that there's financial counseling. Have you ever sought financial counseling?
I have. I do, take advantage of, those programs and, things like that to, well, when they're free, because
Yeah.
again, I'm I can't afford to pay somebody to tell me how to spend my money, and then I gotta pay them to tell. No, I don't need that. So I will do it on my own. And I understand some people do, but I'm not there yet. So I won't speak to that, but again, I have, but I found out still at the end of the day, it's no one can really walk your shoes the way you can. So you really can't have somebody that you don't know or don't have a real relationship with on the outside that can come in and tell you like how you're going to manage and spend your money. Like that has to come within first, and then somebody can help you educate it, but that has to be precipitated from me. And I have not been in close relationships with anybody in Waterbury recently that has helped me do that. So I'm basically pretty much on my own. And I understand what you mean by, the conversations about, why earning left. But the company that I deal with, they came in as such a great service, and the EWA services came in I should say, not just this one company, because there are a few that came in as such a great resource. I think the reason why they left is because to stay under the regulations that Connecticut was offering would have definitely done more harm to their customers. And I found it a bit as a benefit. The services that they were offering were good enough, like as is. And you know, it just, to me, maybe if they would have stayed under the regulations, they would have lost customers. And how does that help them build their business and build their brand, if they're going to be like other companies? And I think one of the people said, oh, Chime and Dave, and they thought of scam. Well, EWA is not Chime. They're not Dave. Again, it's earned wage access. These are wages that I worked for. So I don't understand like what we're talking about. I worked for 5 days, and if I've earned $500, then it's wages that I've earned, and I'm accessing them early through EWA services.
So
that is
excuse
the
me.
difference.
So excuse me, because you're very passionate about
Yeah,
this.
I am, and I'm
So
at the same
you're
time.
saying that you have to submit a pay stub to them?
To who?
To
No, I never
the
had to
provider.
I never had to submit a pay
Okay.
stub.
So if I can, I just want to make a point that one of the issues that we've been working on as legislators is financial literacy, because we realize that if our constituents, the residents of this state, are financially literate, meaning that understanding their finances and knowing how to manage their finances, then it creates wealth for the state. It makes our state healthy, but it also creates generational wealth. And so, I know what you're saying about struggling because I lived it, and I had a parent that struggled just to make ends meet, and he had 5 girls, so girls are high maintenance. And so I understood. I had a mom that says, save every penny. And I think that one of the things, what we're doing even in schools, is that we're teaching financial literacy, because individuals are graduating from college with exorbitant student loans. And you just mentioned a student loan. And so my role, one of the roles that I'm taking on, again, as I mentioned earlier, is to help families be able to manage their finances, to go to banks and go in a bank and be able to get a loan and be able to save money. And so we've done work around that so that people don't have to pay late fees and drafts and the like. And so I appreciate you I appreciate you coming in to lobby for them and to advocate. But I'm going to give you a charge that you try to focus on creating generational wealth for your children, your 3 children, and teaching them how to save. And because we struggle. I even struggle. I'll be honest with you. I worked every day too, and I struggled to pay my rent. And I struggled to pay my bills. Like you said, all those big bills are due and you still have food. And so we do struggle. And I just don't want to, and I'm hearing these stories and it's breaking my heart to see the individuals are struggled. And Ms. James, it's worse now because food is expensive.
Yeah, I
And
know.
we're
And
dealing with,
people are stealing eggs in the supermarket now because they are expensive. And that just brings me back to my point. And I understand what you're talking about. But again, we're talking about going into banks. They don't give you free money. They don't give you free money either. It's like when you get a loan, that's what it is. It's a loan. They're giving it to you for a reason. It comes with interest. So again, we're still talking about 2 different things. Having access to a loan is different from having access to my pay and the wages that I've earned early. And that's all we're asking for, is to have the opportunity and to use that as an option, to use the wages that I've earned as an option to build that financial stability, rather than to having to depend on a bank to get a loan, or depend upon a credit card that has interest, or a payday loan that's going to charge me double to loan me money. Again, I work hard enough for these wages. And I think that at the very least, again, life does not wait for me to get paid. So in an emergency, and as of right now, there isn't anything. And I think I kind of sort of make decent money, and I have to think about the people that don't make as decent money. I was working at Walmart a few years ago. Cashiers are making $14 an hour. If they have an emergency, what do they depend on? They can't go into a bank. Should they have to worry about paying a credit card with higher interest fees when they get paid $14 an hour? I mean, that's unfair. That's unfair. And it's unfair to think that, again, people in my shoes cannot be responsible enough to manage and use this service in a capacity where it's going to be beneficial. And I don't know what surveys or what data has been used, but allow it to be brought to the table to have a discussion where everybody can, agree on something that's fair without it affecting people like myself.
I
Because
agree.
now again, I'm back to where I had built myself from going to paying $20 for cable and $10 for gas and $10 for electric. Again, that's $40 a month. By that 6 months, I was not paying any of those fees. And I was looking forward to starting to save that money to pay down on my credit card bills and my student loan. And then all of a sudden it got took away. So in 6 months from the time I used that service, I was able to eliminate paying my bills late. So that, yes, it is an advantage to me, because when you allow people to remove these kind of barriers that help create debt, then is when they can start to save.
Yeah. Well, I do appreciate your testimony. You definitely given us a perspective that I think is important. So thank you so much again for waiting so late. It's been a
I would
long
have been
day.
waiting
but we
all night,
appreciate-
trust me. And if it tell me to
Well,
be
we
here tomorrow, I'll
appreciate
be
it.
here tomorrow too.
Well, we definitely appreciate it. Thank you, Mr. Chair.
Thank you.
Thank you, Madam Chair. Rep. Foster has a question.
I just have a quick question, because you make an interesting point that's very contradictory to a report that was given, is that, like, because of this and that the overdraft fees would exceed what you paid for the advances, that you were able to in the end pay less in the month because you used an advance as opposed to overdrafting your bank account, which would have been a much higher fee.
Correct.
According to the report from the Center for Responsible Lending, this is not the best economic financial situation, but I would really love to do that math with you if you'd be willing to share some of those numbers with me, because it makes sense to me that if you had like your cable bill that was due on the 13th, and then you had your internet bill due on the 16th, and then your auto payment of your water bill, and then your utility bill, and each of those overdrafted, versus you taking out once or twice in advance and paying a $5 or a $10 fee, as opposed to each of those triggers on your bank accounts being an overdraft, that actually maths out better. And in my head, it had not made sense. I know I said maths again. Oh God, I'm so sorry. It makes sense that would work out. And I actually had not felt like, until you gave that example, that the repeated use in a single month was ever not predatory. Like, in my head, it felt like when people were using it multiple times a month, that was setting them up for failure. But if you were overdrafting otherwise.
Let me share a story. And I guess I'm really not going to say the bank, but I can, but it was TD. I had 3 charges on my card, and I guess I didn't have the money. One was like, 2 were like less than $3. One was like 3 and some change. I got hit with 3 overdraft fees. So now I'm paying $105 because the bank, now they have the discretion on whether they're going to pay the fee or not. So the bank decided to go ahead on and approve these 3 minimal transactions and then tell me that I had to pay 3. I sat on the phone for over 2 hours cussing everybody that I could talk to out, because I'm like, you're really going to, I think I went to Popeyes and something at Walgreens. And so you're going to charge me $105 because I bought a $3.36 meal at Popeyes, and then you're going to charge me another. And they were serious. I mean, and I'm like, I just could not believe that. I had to change my whole perspective of the checking account, talk to so many people. And so that brought me to the realization that these are people's lives in real time. So let's just say if that was the case for these 3 different services that you just mentioned, that's $105 there, when I could have chose. Now I know the 13th and the 16th and the 18th is coming up, so I can go into earning and schedule those, you know, depending on how far. Again, the only time that I've paid is if I needed the money now, today, in an hour. I can't wait the 1 to 3 days. Waiting the 1 to 3 days costs me nothing. Okay, even if I needed to pay it now and it was $3 each particular time, I had to take it out $3 because I needed it instantly. That's what, $9, as even supposing to 3 overdraft fees, or maybe even 1 in that month. The fees that I would pay still wouldn't touch that $35. The fees that I would pay if these bills are late, because remember, it's $40, would still not touch that $40 in the month. So at the end of the year, I'm still ahead, even with paying the instant fees.
Yeah, and if you put it on a credit card as opposed to overdrafting,
And
then you
your
would carry a
interest.
balance and you would get into the cycle of
Exactly,
debt
exactly.
only
And that's
pay
the cycle of
minimum
debt.
principal.
That's the cycle that's continuing to have these struggles and fostering me to be in the same repetitive cycle, rather than, again, if I have access to my wages early, then I have that financial freedom. Then I'm independent and standing and say, I know that I worked. Maybe it could be even used as an incentive for people to work, because hey, if I go to work every day and I know if I have an emergency, I don't got to worry about falling on back on nobody. I've worked, I can access my wages, and I can be 100% building that stability.
Yeah, I appreciate, I mean, I think Senator Miller was getting on something that like we need we can't like use these as a substitute for inadequate wages. That like there's definitely a point to us doing financial literacy, but if you just like, if I were just thinking about the products that are available when someone's going to run out of money, that are, you know, where the most ROI is for you paying for a fee to get money that you don't currently have.
Right, but it's no more, again, it's not as predatory as every other option that we have. And every
Including
other option
overdraft
that we
fees.
have has been proven to do more harm than good. So why not allow this service the opportunity to see how it can help as it is, with whatever supportive changes. Allow that to see what kind of growth it's going to build, and create that data, rather than having to depend on, you know, people coming in with propaganda who are opposed to it in the first place.
Well,
because I don't see how somebody that's opposed to it is going to come in and give you data that's going to help support it.
Well, and you make,
how smart would that be?
Well, that's that's the exact point I think that I would like my members of the banking committee to sort of consider, is that in this report, there's this correlational association that people who repeatedly used EWA are also more likely to use a payday loan, and are also more likely to come up against like a variety of other emergent fiscal indicators. So, but that's not actually a causal link between EWA and other types of predatory lending processes. That's just a spurious correlation because they're experiencing inadequate salaries.
Exactly. And they need access to money. So
they're using a bunch of different things, some that are predatory, some that might not be, some that are problematic.
I agree.
And nothing is solving the fact that people don't have enough money, which is more work than we could probably do here.
Right, but I don't want to sit around and wait for us to figure out, you know, are we going to increase our pay the way we're increasing inflation for every service that we're using? I can't sit and wait and tell that. I can't sit around and say, okay, well, let Connecticut go from a 2 bi-weekly pay period and to a 1 week pay period, because again, we're still going to have emergencies, and someone is still going to fall short. Someone is still going to need to get, even if we get paid weekly. If I get paid on a Monday, and I'm a Friday, and my emergency is on a Monday, then it does not help if I have to wait till a Friday. So again, we're talking about a resource that allows you, again, to have access to your wages that you've already earned, and to use it in whatever crisis or however you may feel that whatever you need it for.
I appreciate you answering my questions. Thank you for hanging with
Thank
us.
you for asking. I appreciate it.
For hanging with us. You bring us to the end of a long day. Actually, there was one more name that was signed up, Devon.
Yeah, it was my son. He wanted to be here, but he just started a new job and
Okay.
he had to be at work.
All right. Well, we appreciate you. We appreciate your testimony. We're listening and
I appreciate it. I hope
Thank
to
you for
be
coming.
back and
Okay.
speak again. Well, maybe I'll be speaking on something else. You never know.
Anytime. Love to see you. Okay. With that, I think we've reached the end of our hearing. Thanks everyone for participating. See you next time.
Thank you, Mr. Chair.